Good morning. Let's get started. Thanks everyone for being here. We're going to have a productive day. I'm going to ask the clerk, Juan, who is a little bit nervous because it's the first committee chair, but we're glad to have you, Juan. And if you'll take a deep breath, I will too. Please call the roll.
Whitmire,
Present.
Flores,
Present.
Hinojosa,
Hinojosa. Present.
Huffman,
I'm here.
Betancourt.
No, he's not
Not
here. He's going to learn the members before the day's over. Go ahead. Betancourt's not here.
Miles,
He'd be not here too.
King,
He's here. We're in good shape. We have a quorum. First members, thank y'all for being here, and welcome our new Vice Chairman, Senator Flores, who has a world of experience, and Senator King, who we've worked with for years, and excited about him bringing his background and working knowledge of the criminal justice system. First, we need to adopt committee rules or standard rules, and is there any objection? If not, Senator Flores moves that we adopt committee rules, and the clerk will call the roll. Same ones we've had last session, and the clerk will call the roll.
Whitmire,
Present.
Flores,
Yes.
Hinojosa,
Yes.
Huffman,
Aye.
Betancourt, Miles, King.
Yes.
What's the numbers? Good count.
5-2.
Yeah. There been 5 yes. We adopt the rules. So the agenda is, we've got a couple of important bills this morning, then we'll move into bail bond this morning, and then fentanyl this afternoon. I don't expect us to be complete by the session at 11 o'clock, but we're going to move right ahead with Senate Bill 402. And I will give the chair the gavel to my Vice Chairman. Senator Flores, if you'll lay out Senate Bill 402 by Whitmire, I will give the committee, just go ahead and bring it up while you're looking for it.
The chair brings up, let me get that right there. Chair brings up Senate Bill 402 by Whitmire.
Thank you, Mr. Chairman and members. Senate Bill 402 is the first bill we're hearing because I put such a priority on public safety. The criminal justice system is just that, a system. I look at so many stakeholders in this room. You understand it as well as I do. If any part of the criminal justice system is not working well, it affects everything upstream and downstream. And we'll hear this morning, we have several elements of the criminal justice system that are just not working. Specifically, in Harris County, this morning we have 1,875 defendants charged with murder or capital murder, waiting to go to hearing or to trial. Now let me say that again, 1,875 folks charged with murder or capital murder. Only 900 of them are confined. It's unheard of in my criminal justice experience, and I could believe speak for Senator Huffman, Hinojosa, all of us on this panel, to have capital murders loose on the streets of Houston, or murderers. There's 600 of those 900 that are fugitives. Just stop and think about that. Why does Houston have a crime issue? Why is it we constantly see violent acts by repeat violent offenders? Because 600 of them, we do not have an address or working knowledge of their location. And 1,875 persons charged with murder or capital murder waiting to go to their hearings and trial. It's creating a huge problem in the county jail. It's creating a huge backlog. We have dangerous people loose, not being held accountable, and even those that are presumed innocent waiting to go to court. So SB 402 is not a designated emergency item by the governor. Could be, but it's certainly an emergency item before this committee today. What we're attempting to do with this legislation is give the judges some guidance, set their priorities. We already do so in child sexual abuse and rape cases. We already do it in domestic violence cases. And I can't imagine anyone not seeing the merit in putting murderers and capital murderers at the front of the line to be held accountable. It's a great piece of legislation. I can't imagine anyone opposed to it, but that is why we have this hearing. My first witness that I would call would be our district attorney, Kim. Don't worry about that. Come on. Kim, state your name and who you represent, and tell us why you're here today.
Well, the chair calls District Attorney Kim Ogg.
Good morning, Senators. I'm Kim Ogg. I'm the Harris County District Attorney. I'm a lawyer with 35 years' experience. I've been board certified since 1992. I have been the District Attorney since January 1 of 2017. As you know, we have suffered some hardships in Houston with Harvey and, of course, COVID, which everyone suffered, but it has created a tremendous backlog of cases, including our most dangerous offenders. This is my testimony in support of SB 402, legislation requiring trial courts to prioritize hearings and trials for murder and capital murder offenses. Scheduling falls exclusively within the power and jurisdiction of the judges in all criminal cases. The state of Texas, by way of assistant district attorneys, enjoy the current authority to push only domestic violence and sexual assault of children cases forward as a priority. We need to add murder and capital murder because they are our highest risk offenders and create the greatest public safety threat to the community. This bill would expand the court's current authority and require them to prioritize murder. It would give guidance to our courts that is needed. I support this move. The public interest served by Senate Bill 402, if successful, is to make the public safer by reducing the number of accused murderers awaiting trial in jail, where they're a danger to jailers and other offenders, and on the streets, where those on bail can be a danger to others if they break their conditions of bond. We only have 269 on bond, but we have 613 fugitives from the law who've not been arrested or apprehended. In total, this number of 1,875 is in essence a city of murderers within a city of law-abiding citizens. And what is the scope of the problem? Well, at this time, and these are late January statistics, approximately 1,841 capital murder and murder cases are pending against nearly as many offenders in Harris County. How did we get to this point? The Harris County multi-agency homicide count, which we put together from the homicides reported by HPD, the Sheriff's Department, Pasadena, and Baytown, show that in 2021 and 2022, we had the greatest number of homicide deaths in 30 years, with 2021 being the top year and 2022 being a close second. So we look at the number of crimes committed, but we also look at the number of crimes filed. Remember, murders aren't always solved immediately. Sometimes it takes a year, even more. But the number of cases being filed reflects the work that's been done on past murders and current murders. And what we see is that in 2017, we filed about 250 murder or capital murder cases. Last year, we filed 505. That's a 100% increase in the number of murders and capitals being filed by police in Harris County with our office. We tried last year, remember judges control the schedule, 54 homicides. 54. That's 10% of the number that we filed. So we look at the number of murders happening, we look at the number of murders we file, and we look at the number of murders that we finalize, that we finish, that we either convict or the person is acquitted. And when the number that's being disposed of is far fewer than the number being taken in, that's your backlog. That's what we want to end. And why do we want to end it? Because the average time that families of murder victims wait for case conclusion, this is the average, it used to be 23.9 months in 2017. It's now, as of the end of 2022, 40.2 months. Over 5 years. By now bringing the most serious cases involving the highest risk offenders to trial first, fewer of these high-risk offenders will be on the street and in our local jail, reducing the chance of them hurting others. It will bring finality to family members much, much sooner. For similarly situated defendants, they will be more motivated to take a look at their own cases where they're facing up to life, life without parole, and even death. And I think that when they see these cases moving, we can anticipate more movement through plea bargaining. This would increase judicial efficiency and move our system forward one case at a time. My commitment as your DA in Harris County is to treat every single one of these cases with the priority they deserve, Senators. And to that end, we've created a special squad, the Homicide Division. They're nationally unique, and to date, they have brought to conclusion since their inception in May of 2022 more than 50 capital murders in their first 8 months since inception. They've brought them to conclusion. So I've dedicated the resources. I'm asking the courts to prioritize and for you all to give the judges guidance in what our community believes are the highest risk, most important offenders. SB 402 will aid crime victims and their survivors. It will aid the courts. And I am joined by several survivors today who will testify. Dr. Alma Allen and her husband are here. Their son was killed. They waited over 3 years for trial. And they were some of the, quote, lucky ones. Carmen Guillen is the sister to deceased victim Anna Weed, murdered January 24th, 2017, convicted 5.5 years later, and sentenced on June 30th, 2022. They are here in spite of their family's pain and suffering in support of a real solution that this chamber can deliver. Hopefully, we'll get the support of the other chamber, and with you all's leadership, we can make a dent, a really important dent, a big dent in our pending cases of our most serious offenders. Thank you, Senators.
One quick question, then I'll yield to my colleagues. What controls does your office have, your employees, your district attorneys, in the effort to constantly reset these cases? Because I've been told by those even in the defense bar that the current model in Harris County with handling these cases and others, but the ones we're talking about this morning, is to reset, reset, reset. Because that's the model that they realize they're not going to be held accountable. Evidence gets old, witnesses get lost, and so it plays right into the hands of the defense to reset, reset, and reset, and that explains partly the time frame in which these cases are brought to court. What influence can you have on that with your assistant DAs in that courtroom setting?
We can have a tremendous impact. We have to get our evidence together faster. We're dependent upon the police, and I think by prioritizing this, it makes it clear for both sides we need to be ready. And so we are not without any of the responsibility for getting a case ready, but it is out of our control to determine when it's tried. And having practiced as a defense lawyer for 10 years, I can tell you, delay benefits the offender, the accused, because witnesses do die. They do get intimidated and change their testimony. Evidence is at times compromised. And the longer the delay, the more difficult to achieve justice and to ensure public safety.
Thank you. Senator Huffman?
Yeah, I just have a couple of questions. Thanks for being here today, Kim. So just to review, there's 1,841 murders pending, 54 tried last year, right?
That's what our
And there's
statistics show.
23 criminal district courts in Harris County that have jurisdiction to try these, right? So that's maybe average of about 2, but I would suspect there are some judges doing more than others. Is that correct?
That's correct. But there's not any court that's taken a really bold stance. We've had some with a few more.
Yeah.
But with this number pending, many of our courts, and as a jurist, you'll understand this, have as many as 24, 23, 25 capital murders pending.
That is, that.
It's amazing.
I can't even get my arms.
And then that's just the capitals.
Yeah.
That's not the murders.
So are you using these emergency courts where there's visiting judges? I know you and I have talked and you mentioned that. So how many of those are there? And are they being used for the murder cases or the capitals or the more serious offenses? How's that?
The emergency relief dockets have been a real strain on our office, but they're useful in moving these cases. We have visiting judges who are actually trying the majority of our serious cases, including capital murders and murders.
Please
Not
repeat
the-
that. Please repeat that.
It's not the home court that's trying these cases. That's the
I
elected
want everyone to
judge.
pay attention to this. This is critically important, especially you judges out there asking for a raise. Say that again.
Yes, ma'am.
I'm done.
Yes, Senator.
Yeah.
I will beat the horse.
No, say it again.
The home courts are not where most of our murders or capital murders or even serious felonies are being tried. They are being sent through transfers, to our emergency relief dockets, who are staffed by visiting judges, many of whom were defeated in the last couple of elections. Those judges
like
tried.
Vanessa Velasquez, right?
Yes, Denise Collins, Vanessa Velasquez, a number of our past sitting jurists. That's where many of these cases are being tried. I have gone to the judges individually and asked for them to transfer their cases, if nothing else, to the emergency dockets so we can try more. That's where we're getting trials. I asked for more. But I haven't been able to get a consensus that the judges want to do that. They have not agreed to send it. A few of them have, and I'm grateful to those judges.
Sure.
Judge Robert Johnson is one. He's sent his cases. But I will tell you, I believe they need guidance from this body to get this job done. At 52 out of 500 being filed a year, it'll take me 10 years just to dig out from the backlog of 2022. Add that to my existing backlog, and Houston, we've got a problem. We need some help.
One more question, if I may,
Sure,
Mr. Chairman.
sure.
Are you, so when you go to these emergency courts, you have prosecutors that have to, fill those slots too. Are you sufficiently funded to adequately hire enough prosecutors to cover and to catch up with 1,841 murders?
I am not. When the emergency courts were approved on a grant from the Supreme Court or Office of Court Administration, the judges wanted these emergency dockets immediately. I said I needed time to staff them. The problem is I can't staff them with brand-new lawyers out of law school. The cases they're handling are serious, so I have to use the same prosecutors assigned to those home court judges. That means I've got lawyers with cases set on the same day, both in the emergency relief docket and in the home court. It is not fair to any lawyer to put them in the position of trying to try two cases at once. It can't be done. And no, I am not staffed properly. I needed time to hire and train. If I'd started 3 years ago, 4 years ago, when I started asking for resources, we might be there. As it is, with the labor market, it's very, very difficult. So our lawyers are working double and triple time, especially my homicide division. I'm fortunate to have such good public servants who have chosen to be assistant district attorneys and try these cases for the crime victims.
We're going to have legislation to ensure that you're not defunded, but unfortunately, we cannot make the Commissioners Court fund you adequately, though we will do our best to send signals that that's.
I'm aware, and the fight will continue because we need the staffing. We just must have it. You just can't run a criminal justice system without enough people.
Thank you, Mr.
Let-
Chairman.
Mr. Chair, let me emphasize something. Is it not true this guidance will impact the innocent that need to get to court, those charged that are innocent? Certainly those that will be found guilty and held accountable, but certainly we're here this morning, as you emphasized, on behalf of the crime victims. And so.
Let me make the pitch for the defense counsel.
Because I'm fixing to call, or the chair's going to call some crime victims. We've got Crime Stoppers here. It's the hurt, the misery, and the frustration that the families have to endure while their cases are moving through this slow process. And-
It's absolutely
you said the
true. We've had
10-year
to dismiss
10-year
cases.
number- The 10-year number is just unbelievable to get to the backlog that we're looking at. But anyway,
Forgive me for interrupting.
no, that's fine.
On behalf of the defense, this will aid those who are not guilty, where there's not sufficient evidence, where the evidence has fallen apart. The sooner those cases are dismissed, the better. And, there's no statute of limitation on murder. Should new evidence develop, we can always go back and revisit those cases. But in the meantime, those who are being held where there's really not sufficient evidence anymore, and we don't always know that till we're getting ready for trial.
Mr. Chairman,
Those cases should be dismissed.
Come on.
Senator Hinojosa, you recognize.
thank you, Mr. Chairman. One of the things, and I know Senator Whitmire, Chairman Whitmire talked about the delay, and really what happens. I've been on both sides. I've been a prosecutor, I've been a criminal defense lawyer, and evidence gets stale. Witnesses disappear. And you're right, many witnesses are intimidated. And then you said there were 613 fugitives.
Yes.
Are those people on bond, or they just didn't show up in court?
No, sir. They have evaded detection since the day of the murder. And as we file those cases, as the police put the cases together, sometimes it takes days, weeks, months, even years. Those individuals, once they're charged, they've either fled the jurisdiction, they're hiding successfully within the jurisdiction, or we simply don't know where they are.
Some would be on bond.
There's 269 that are on bond. That number has significantly decreased since the passage of Senate Bill 6. We've seen about a 300-person difference in the number of murders or capital murders who were in jail prior to SB 6. We've seen a 300-person increase since SB 6. And I think that that's been appreciated by our public out on the street.
And those that are in jail or out on bond, but now you said there's been a reduction in the number of bonds set out for somebody committed charged with murder or capital murder. Those that are in jail waiting for trial, so they sit in jail for over 4 years waiting to be tried.
That's right.
Yes.
Decades.
And that's wrong. You're correct, and that's wrong.
On
Nobody
both
should
sides-
sit,
on
the
both
jail
sides.
is not designed for that.
On both sides of the bar.
It's broken. Yeah, this is broken.
Mr. Chairman.
But by prioritizing it, you don't just tell the defense you've got to be ready. You don't just tell the judge you've got to make this a priority. You're also telling the prosecutor and the police department this is a priority evidence-wise, and we're going to be called to trial.
Thank you.
Mr. Chair. Senator Miles, you recognize.
Thank you, Mr. Chairman. I want to thank you first for bringing this bill forward, and I look forward to signing on to this bill if you will allow me to as a Harris County delegate. I want to thank Kim for you for being here. You know, what we just got through talking about is, unfortunately, our criminal justice system in Harris County is it's embarrassing. And our criminal element that's in Harris County, they know that if they commit a capital crime in our county, that they're going to just go sit for 20, 30 years. You know, and unfortunately, we have constituents that are calling, complaining that the assailants of the crimes that were committed against their family members are not going to trial. And it's an embarrassment. It's an embarrassment to us from a criminal justice standpoint. It's embarrassing at the county level. It's embarrassing to us as legislators that oversee Harris County. And Mr. Chairman, you mentioned, you know, some of the ills and the negative parts. One thing you failed to mention was that it's also an insult to the hard work that our great law enforcement is doing in Harris County and in Houston by not prosecuting these criminals in a manner. The criminals in Harris County know that you're just going to go sit. Sometimes they sit right there in county jail most of the time, right there next to their families and their loved ones for decades. For decades, okay? Something as a speedy trial for the victims and the families who have been suffering doesn't come for decades. I want you to think about that. So, Senator, Chairman, this is a great bill. I look forward to signing on. We're going to work hard this session, DA Hogg, to correct some of the things that are wrong in Harris County. And I think you'll find that you'll have the support of a majority of our body because Harris County's criminal justice system has to be corrected, and we have to make some changes in the right direction. So thank you for being here. Thank you for bringing this bill forward, Mr. Chairman.
Thank you, Senator Miles, and I'll allow you to sign on before we leave here this morning. In closing, before we call the other witnesses, Mr. Chairman, I want to just emphasize it's unheard of in my 30 years as chairman of this committee to have someone charged with capital murder, which is the most serious offense in the penal code, which the state has a huge responsibility in dealing with, that they would be out on bond because they know the consequences, if held accountable, is the most severe punishment, either death or life without parole. And Senator Miles, thank you for mentioning our law enforcement. It's the most dangerous element that they have to deal with. These fugitives, as they approach them, or those out on bond where they've violated the conditions of their bond. Back when I was a young practicing attorney, and certainly in Senator Huffman's court, they would be revoked. The capital murders on bond, violating terms of their bond, are not being revoked. So an officer has to serve a warrant, and the officer knows that's the most dangerous element he or she will have to deal with.
But respectfully,
And it
Mr.
speaks
Chairman,
and it speaks to their morale, Senator Borscht.
respectfully, Mr. Chairman, the bond issue is a separate issue from what we're talking about.
I understand,
right
but this
now. That's
backlog,
been- we
waiting
should
to
have
get
a
them
bill
to court.
address that as well.
No, we're going to deal with bond in a little while. But this element is waiting to be held accountable by going to a hearing or to court or free on the streets of Houston. It's unheard of that someone charged with the most serious offense of capital murder and/or murder is loose on the street of Houston. It's a small, relatively small number, a couple of thousand people that are holding millions of people hostage. Seniors come up to me and say, Senator Whitmire, please do something, because we don't leave the house after 5 o'clock because they're afraid of this element. Thank you for being here. Now, Mr. Chairman, I'd like to move into some witnesses that are crime victims and ask them to come forward. I know your office, Amy Johnson, actually represents victims. If we'd like to let Amy come elaborate on what her job involves. So thank you.
Yes, sir. I want to thank you, Senator, for bringing this bill. I want to thank every senator on this panel for hearing our problems in Harris County. They are solvable. And I want to thank you all for bringing us one of the solutions.
Thank you, and hopefully this will bring our community together behind this initiative. We're going to hear other important bills today as well. Amy Johnson signed up in support. Amy, I'm going to be careful, Mr. Chairman, with the time restraints. We've got a lot to do today. This is very important, but we have other important matters. So I'm not going to limit people to 2 minutes, but be mindful of our time, because first of all, there's a lot of people want to testify. Go ahead, Amy. State your name and who you represent.
Good morning, Chairman Whitmire and the committee members. My name is Amy Johnson. I am a victim assistance coordinator at the Harris County District
Pull the mic
Attorney's
over just
Office.
a little.
I've been in the criminal justice field for over 20 years, working within the courts and in law enforcement. I've worked with victims of sexual assault, domestic violence, victims of violent crime, survivors, family members of survivors, and child abuse cases. So I am in here to support the bill, Senate Bill 402, just because these resets that I deal with these families on a daily basis, that they traumatize the families. Some of the quotes from the families that I work with, the anxiety, sleepless, emotional breakdowns we face getting ready for court again, to only be let down when it is reset. Then we have another round of anxiety. That's a quote given from a mother who lost her son and waited 4 years to go to trial. Delay after delay, it gets harder and harder with each passing trial date. The murder victims who are left behind do not have a chance to grieve their loved ones while you're going through the process of getting your day in court. The wheels of justice turn slow. This needs to change to help the families left behind so they can grieve and move forward with their new normal of life without their loved one. That's from another case that waited over 4 years to get justice for her mother who was dismembered. Excuse me. The frustration of putting life on hold is that these family members prepare for their court date emotionally, the toll it takes on them. They don't really get to move forward in their new normal of life. They don't have closure until they are allowed to have that day in court, rather whatever that verdict may be. Passing in this bill, I think, will help reduce trauma of these families and then the mental health that these family members are going through. It helps with their healing process. Also, a piece of the, y'all kind of touched upon it a while ago with DA Ogg, when these cases take so long, we get witnesses that pass away that are key to the case. They go missing. I had a case, I was the advocate on Harris County Sheriff's Deputy Sandeep Dhaliwal. He was the officer shot in the line of duty. His father became ill after, and as we waited trial for years for that case to go, he couldn't make it to trial because he was ill. So that something, he could never get over it. They deserve the defendants, they deserve their due process to have their cases heard, so they're not sitting in jail waiting, just like we've discussed a while ago with DA Ogg. 3, 4, 5 years, they may not seem like a really long time to us or some of these people, but for these families that we're working with, it's a lifetime and eternity for them to get onto their, what they call their new normal. And so passing of this bill will let these families know that Texas cares and that these cases, these murders, these capital murders, they are important. The 2 dates that these families, they remember, they always remember that one phone call that the loved one, that tells them that their loved one was lost, and then the other one is the date that they get that verdict, no matter what that verdict is. Thank you for your time.
Thank you for being here. Any
Do you have
questions?
any questions?
No, ma'am, we're fine, thank you.
Okay, thank you.
Let the record reflect Senator Miles is present, and showed up at 8:01. Thank you. Next, Alma Allen. Ms. Allen. If you state your name, please, and who you represent, Ms. Allen.
Yes, sir.
And if you want your, would you like Mr., I don't want to assume that's Mr. Allen, but
That is him.
Mr. Allen, would you like to join Miss Allen? You're certainly welcome. We appreciate you traveling to be here.
Yes, sir.
And normally we try to say, sure, a couple of minutes, but you got all the time that you need to tell us your concerns.
Yes, sir. Thank you.
Senator Miles, you want Russell in my office to handle that camera? Please. Russell, will you come assist Mr. Allen with his camera? You can actually join us up here on the roster and use Mr. Allen's phone if you would. And there might be a chair when you finish, you can report. Yeah, state your name and who you represent. Mr. Allen, you as well, but Ms. Allen, you're in charge. Dr. Allen, what kind of doctor?
Theology.
Wonderful.
And ministry.
We need a lot of that around here. State your name and who you represent.
Yes, sir. We thank you, senators, and to our Honorable DA Oggs, too, as well. We are pleased to be here, but we wanted to let you know I am Dr. Alma Allen, a theology teacher, and we also have an accredited seminary. We also have a counseling center.
Yes, ma'am.
Where we license and counsel those such as what we are going through now. But we wanted to let you know that on October the 19th, 2016, we received a frantic call, hysterically, after we had recessed from a Wednesday night church service at 8:30 p.m. And that call was from our daughter-in-law. And our daughter-in-law called us and she said, June have been shot. This was a hysterical time that we wasn't expecting, and also known as Julius C. Allen Jr., 26 years old, leaving 3 young children and a wife. And the investigation now begins, and I'm going to allow my husband to speak in a minute. The gunman, as now he's a fugitive, and our family now is in desperation of his capture. We're talking about right here at October 19, 2016. 6 months later, he was captured. 6 months later, placed in jail, and then turned around and bonded out to now receive a call from one of our prosecutors assigned to us, explaining to us the story again. Now we have the first prosecutor. Now we have what we call a reset. We are reset because the defendant has fled after he bonded out. Now we have another assignment of 2018, a prosecutor number 2. We are back now to square one. Reset, reset, reset. Here we are at 2018, reassigned again, prosecutor number 3. Reset, reset, reset. Here we are now, fugitive, still on the run. We have now a court date assigned. He was to show up in court. Why? Because he was supposed to receive an ankle bracelet. Did not show up in court because of this. Now he's still a fugitive. 2019, here we are 2 years later. Finally, we're on the docket of the trial. Now we are assigned to prosecutor number 4. We went to court 3 years later for the judge to say mistrial. Do you know how that feels? Yes. We're here now. The judge is saying mistrial. We're back to square one 3.5 years later. Reassigned prosecutor number 5. Until we receive the prosecutor that has seemingly had enough sensitive or sympathy for the family, emotional and mental stress. This wait was devastating to the family. This wait was traumatizing to the family, and it left us mentally and physically affecting the family. We had a daughter that was almost a twin to our son that actually had 4 children. She was so traumatized that she left her 4 kids with us and left and was so traumatized that she went out in the street. Did unusual things because she was not raised that way. Traumatized because her brother was no longer there, and it took too long for us to get on the docket. Here we are now at our primary care doctor. Our primary care doctor said, you are under too much stress. We're filling out stress papers. Yes. A pastor, a counselor, that teach grief, filling out stress papers. This is ridiculous because we had to wait substantially too long for us to go to trial. Now we have antidepressant pills we're going pick up from the drugstore. Both my husband and I and our daughter doing these antidepressant pills. Here we are 3.5 later, and we are going through this trauma. Now once we go to trial, here we are. After the mistrial, the witnesses either murdered or didn't show up because they were actually afraid to show up. Once we go back to trial again, lo and behold, God bless the judge that we were under. He came and he said, don't worry, we're going to work you through this. This was a retired judge that came back and understood all of the laws and the precepts, the statutes of what had to happen. And because of his support, that's the only support that we felt comfortable with the judge coming out of his chamber down to us, talking to the Allens, that was the plaintiff, and saying, don't worry, we're going to get this moved forward. Lo and behold, he did. He made sure that the prosecutors got on their job, and he was definitely on the defenders' attorneys. Continually, they wanted to do a reset. They wanted to do a mistrial. But because we had a judge that also said, we're going to get through this because we're already behind and we are lacking. Then we go back and we look at all of the unsafetyness of what we had to go through. We had to literally hear gunshots late at night. We live in a predominantly good neighborhood where you can walk through the neighborhood. People walk their dogs. People jog through the neighborhood. But why do we have to hear gunfire late at night as a warning? And then because of the delay of him not being prosecuted timely, 3.5 years went by. Mental anguish, hurt, pain, unsolved issues, trying to sleep at night. That was drastic.
Let me assure you that we share your pain and anger, and you're making a difference today. And we're going to pass this legislation and resolve this matter.
Thank you, sir.
Mr. Allen, if you want to give us a short comment, state your name and who you represent.
Yes, I, Julius C.
Dr. Allen's done a fantastic job.
Yes, she has. I, Julius C. Allen, pastor of Vineyard Place International Ministry, the husband of Dr. Alma C. Allen.
Yes, sir.
I can state that we did go through a whole lot of tremendous pain, very devastating. It affected us not only physically but mentally, and it really took a great big toll on our lives and affected us. We even in the midst of us going through that, we were even lied on in the midst of it, of trying to say we were paying people to testify, which was a lie. We had different challenges, different things that were coming from different directions, which was affecting us mentally. Witnesses being killed. When their names are mentioned, next thing you know, the witness was killed. I mean, very tremendous pain. My wife covered everything. I don't want to repeat everything over.
And we want to thank you because you're making a difference, and there's a lot of support.
Yes.
We know it's broken.
Yes.
So that's the reason for this piece of legislation. So let us pass this today. There's going to be
Yes.
other elements of the criminal justice system that's
Yes.
going to get addressed today as well.
Yes. And
Thank y'all for being here.
one other thing that I want to state, I give hats off to D.A. Kim Oggs, such a tremendous woman doing a dynamic job in Houston, Texas.
Thank you.
And I stand in agreement for her to be reelected.
Mr. Chairman. Mr. Chairman.
We'll worry about that in a couple of years.
Mr. Chairman.
Thank you. Senator
Chairman.
Miles.
Dr. Allen.
Yes, sir.
Pastor Allen.
Yes, sir.
Let me say, on behalf of Harris County, all our public officials and public servants of Harris County, let me apologize for what you've had to go through. It's been a long, treacherous, painful journey.
Yes, sir.
But as my chairman said, let us pass this bill, and we know it won't bring your son back, but hopefully, by passing this bill, we can give you some relief and some joy. So on behalf of all the public servants for Harris County, because some of us here do serve Harris County, although we're not at the county level, please accept the apology on behalf of us, okay? And we look forward to passing this bill in the spirit of your son. Thank you. Thank you, Mr. Chairman.
Thank you, Senator Miles. Carmen Gillian? State your name and who you represent, please.
My name is Carmen Guillen, and I'm the sister of a murdered Anna Dudley Weed. My sister was murdered on January 24th, 2017, and it took 5.5 years to get justice. It's sad, but I do want to say I'm really grateful for Kim Ogg and her team, and I'm grateful for the Senate that is hearing this bill, and I'm just grateful for all that the lawmakers do to make things like this happen. But it's sad that we have to be here and appear before you and plead with you and let you know what it took to get here. And I just wanted to say that when my sister was murdered, she was murdered in her front yard by her next door neighbor, and he was set free 12 hours later. And he was on bond for those 5.5 years, and free to live his life, free to do whatever he wanted to do. And he lived in the neighborhood my mother lived in. So my mother and my sister lived in the same neighborhood as her murderer, and she was in constant fear for her life because he was within the community. And I just think it's really sad that it took that long to get him off the streets, a criminal that admitted killing her in broad daylight in her yard. And why does it have to take that long to get him off the street? And so I would like to just urge the lawmakers to make it a quicker process to get these people, like you were saying earlier, these criminals, these off the street and into a jail, and let them wait until, they're prosecuted. But I just wanted to say that the only other thing I wanted to say was the pain and suffering. As far as my family, my sister's husband has battled depression since the day she was killed, and he continues to this day. My mother continues to, of course, suffer the loss of a child. And then I have a younger brother that's severely depressed, so we all lose. I mean, all the families lose, we all lose. And I just want the legal system to change and to make murder cases a priority. And that's all I ask.
And we appreciate you being
And
here.
I thank you.
Thank you,
I
ma'am.
thank you all.
Sorry about your suffering of your family, but we're addressing it today for those going forward. So thank you.
Thank you very much.
Yes, ma'am. Letitia Ybarra.
Morning.
Yes, ma'am. Ms. Ybarra, state your name, please. Who you represent.
My name is Leticia Ibarra. I represent myself, my family, and every other murder victim family that I've met along the way. In August of 2020, I got a call no parent ever has wanted, and it was from the county morgue. They had my daughter. That morning, a young man that she knew beat her over the head with a skateboard and stabbed her in the neck multiple times. He admitted, he was caught that day, and he's still in jail awaiting trial. We've received reset after reset after reset after reset. We're pending sanity evaluations. One evaluation from the state. Now we're waiting for one from the defense. It takes so long to get these done, and I understand. But we're at 2.5 years since he murdered her. Again, he sits in Harris County Jail, which was not meant to hold people for 2.5 years. I have refused to allow my family. Jessica had, my parents are in their 80s. I refuse to let them know anything about the case. I have children, other children, college-age children, who have to go on without their sister, knowing this happened to them. They have to try and live their own lives. They go through their own battles of of guilt. We could have done something, we should have been, all of these things. It's on and on and on. We're not even ready for trial, and we're 2.5 years out. So let's say tomorrow we're ready for trial. Well, how much longer are we going to have to wait? And every day that goes by is a day that I have a nightmare that someone's going to bail this kid out of jail, and he's going to show up at my door. He's going to show up at my parents' door. My daughter's address, our legal address, is my 83-year-old father's address. So if this guy gets out of jail, that's public information. Is he going to show up at my dad's house and murder him too? We know what he's capable of. He's admitted it. So putting these cases as a priority is imperative to justice, not only for myself, but for my family. We've all suffered so much. And, it is so far-reaching, it's not just me, it's my kids. It's every teacher of my daughters who's reached out to me, who suffers, worried about this, worried about me, worried about the justice system in general in Harris County. So I implore you to pass this so that I can then try and have some kind of closure. Again, I'm taking this on for my family. I refuse, by letting them know anything about the case, I refuse to let this young man hurt my family anymore. So really, it's just me that shows up in court every single time. And I'm her mom. I will take it for her. But when is this going to end? Am I going to be 5, 6, 7 years later, sitting in court, shaking because I'm going to see the face of the young man who did this to her?
Well, thank you for being here, and you raised an excellent point about jails were not designed for long-term confinement. It poses a real danger to the officers working and other defendants. And we're not discussing jail standards today, but Harris County has 500 defendants in Louisiana, cost them millions of dollars in delays, 500 in Post-Texas and West Texas, millions of dollars to taxpayers. And it's just delays. So, as I said earlier, it is a system, and when you see a breakdown at
Right.
this element, it affects everything upstream, downstream. We have a jail overcrowding, which is posing real dangers to our community. It's maxed out. It's not even meeting the state standards. So, thank you for being here today and putting a face on this critical issue.
Thank you.
Ask a quick
Senator Huffman?
Quick, did you state, and I missed the very beginning, but did you state that part of the delay initially was the defendant going through psychiatric evaluation? Was there a
Yes.
forensic element? Yeah.
Yes, and so that's what we're waiting on at this
Okay.
point. Of course, the state has done their evaluation. It has come back. It came back pretty quickly.
Now
We're
the
waiting
case-
on the defense
okay.
side, but the defense evaluation was ordered last summer.
Okay.
And so then there's a delay in process, gathering
Right.
information and all of that. So that's
Okay.
more delays
And
that,
to Senator Whitmire's point about there's different parts of the system,
Yes.
that's something else the state is working on this session.
Right. And so
that is
priority-
to speed up the forensic process from the
Right.
state side,
Right.
because that's a delay too.
Right.
Sure.
So we have to own that, right,
Right.
folks,
And as-
members, and make sure that we speed up that process as well.
right. And as Kim Ogg mentioned earlier, if there's a priority on these type of cases, well, then that puts priority to gather all of the information and
Absolutely.
get all these processes moving.
Thanks for pointing that out. It's an
Yeah.
important part of the
Yes.
problem.
Yeah.
It
Thank you
can
for
be,
being-
not always, but it can
Yes,
be, yeah.
yes.
Thank you for being here.
Thank you. I appreciate it.
April or Gary? Andy, I'm going to let you finish up in a moment.
Good morning.
April, state your name and who you represent. You can introduce, I'm very familiar with your family, and I would welcome your
My name is April
opportunity to
Aguirre,
introduce the parent
sir.
and sister.
and thank you for everything that you've done for our community. This is Armando Alvarez, Wendy Alvarez, Adriana Alvarez, and my daughter, Allie. We're here today because crime has affected this family greatly, to a point where we can't look away. Arlene Alvarez was murdered in a chain of events because of out-of-control crime in our city, where somebody was robbing somebody else, and the person that was being robbed shot recklessly at our vehicle as we were driving by. Wendy and Armando were on their way to dinner. and they lost their daughter when she was shot in the back seat.
9 years old.
Yes, sir. In the back seat of their vehicle on their way to dinner on a Monday night at 8 p.m. No family should feel unsafe to go to dinner. And I feel like every Houstonian and Texan should feel safe. But because of the out-of-control crime in Harris County and the disregard of our local officials, we have come here today, all the way from Houston, pleading for help. When you allow small crimes and you let those small crimes go without punishment, those crimes grow into bigger crimes. If we don't prosecute these people committing small crimes, we have the ability to turn these people's lives around if you catch them early. But in Harris County, we have a revolving door. You think you're doing a favor for these criminals when you give them a slap in the hand or a PR bond for these offenses. For example, felon in possession of a weapon. These are individuals that have committed crimes against people that are still carrying guns. And we're giving them a PR bond. If you care about gun violence and you care about making a safer society, then we need to get strict on these policies to hold these people accountable, to let them know it is not okay to victimize our community. It is not okay to victimize our people. It is not okay for you to carry a firearm when you have already been convicted with a crime and we have told you, no, you cannot carry a firearm. It's a complete disregard of the law. But when they go before these judges and magistrates and we let them go, what is the message? I have children. When I tell my 8-year-old son, honey, don't do that anymore, 5 minutes later, he's doing it again. But if I pinch him, he doesn't do it again, not because he doesn't want to, but because he doesn't want to get pinched. It's very simple concept. You cannot be gentle on crime because these criminals are not gentle on the people of our society. They don't think twice to violate people's rights. The basic right to just be and live and interact and go to work and drive to dinner. They don't respect those rights. So why are we so gentle? Why are we so generous? Why are we so kind to these people that are not kind to us? That wouldn't think twice to rob or steal or hurt. A lot of people don't die in the process of a robbery. But just because you survive doesn't mean you're the same. Doesn't mean you still have the ability to work. One topic that is never spoken about is the price of crime. Victims end up with millions in hospital bills. Arlene was in the hospital for maybe 24 hours, and the bills are still coming in. Who is responsible for that? I'll tell you who, the state of Texas. Because when a child comes in or a person comes in with a serious injury, they go on emergency Medicaid. So the state of Texas flips the bill, all because we wouldn't hold criminals accountable. It's a chain of events. I don't know at what point we got so soft, but these criminals are not soft on us.
Let me thank you for being here, and we're focusing on getting these cases to trial or hearing as quickly as possible. And I've met with your family, and words can't describe our feelings, and it just shouldn't happen. So thank you for being here, and if your sister or brother would like to say a word, they're certainly welcome.
You know, I want to
April,
remind you
you've got-
guys
you
that you
always-
guys have such power to make a difference across the state of Texas.
We're doing it this morning, April.
Yes,
Really-
sir.
we really
And
are.
it cannot stop. Some things may not work, and that's okay, but keep trying. But let's not go soft on crime. Let's
We're
not.
going to go fair on crime.
Yes.
Smart on crime. And fair.
People's lives matter.
Yeah.
And I can tell you whose lives matter more. The people that wake up every day and choose not to hurt others. But when somebody has repeatedly hurt people, those people need to be taken seriously.
All righty. Thank you very much. Appreciate y'all driving up here. Last but not least, Andy. State your name and who you represent, Andy, and be mindful of our time.
I'm Andy Kahn, Director of Victim Services, Crime Stoppers of Houston, and we're here in support of Senate Bill 402.
I've served on the board of Parents of Murdered Children and Surviving Family Members of Homicide for over 30 years. We meet every month at Crime Stoppers, and I will tell you the attendance, sadly, over the last year or two has grown exponentially. Going back to what DA Ogg testified on, it was a family I dealt with in 2017. It was a high-profile case in Houston. Charges dismissed in Houston subway restaurant murder of an 18-year-old who was murdered protecting his mom. Several people went to a subway, robbed it. They ran towards the man, the young man who was 17, ran towards the man who had his mother at gunpoint. He was shot in the back and killed. That was 2017. 5 years later, that case was dismissed. The reason that case was dismissed because the witnesses went missing. And this backlog, as we've heard today, has complicated so many efforts to resolve cases because it takes too long to go to trial. And I'll never forget talking to Hilda Vasquez, the mother, whom her son saved from being killed that day, whose son was murdered, only 5 years later to learn that the case was dismissed because the witnesses went missing. And that's happening far too often. And that's what this bill will do. And as someone who works with homicide survivors, I want to be able to tell them that we are going to trial, and it's not going to take 5 years like it took with this case, because this case, when the headlines read like this, charges dismissed, witnesses can't be found, that has a reverberating effect on so many other families that are fearful it's going to happen to their family. So I thank you, Senator Whitmire, for sponsoring this bill. I thank this committee again. And like I said, I see this is a win-win for everybody. It's a win for victims, surviving family members of homicide, for defendants who are languishing in jail, and for those who are truly innocent to get their cases disposed of. Thank you.
Very good. Any questions? Thank you, Andy. Mr. Chairman, if I could, I'll read into the record those that have signed up but do not wish to testify.
Yes, Mr. Chairman.
Jessica Anderson with HPD is in support, does not wish to testify. John Wilkerson, Texas Municipal Police Association, in support. James Parnell, Dallas Police Association, is in support. Ray Hunt, HPD, HPOU is in support. John Chancellor, Texas Police Chiefs Association, in support. Thomas Parkinson, San Antonio, representing himself, does not wish to testify. Mr. Chairman, I don't believe I have any other witnesses or testimony at this time, so I'll close and I'll be glad to move that we report Senate Bill 402 back to the full Senate with a favorable recommendation.
So noted, Mr. Chairman, to close and to submit the bill.
The clerk call the roll.
Whitmire,
Yes.
Flores,
Yes.
Hinojosa,
Aye.
Huffman,
Aye.
Betancourt, absent. Miles, absent. King,
Aye.
5-2.
5.
5-0.
5 ayes, no nays. It passes.
5 ayes, no nays. It passes.
Yes. Thank you, and I think we'll take back the chair. If we could, members, we'll leave that vote open, and Senator Miles will certainly be back present to vote. With that, thank everyone that is here on Senate Bill 402, and certainly the families that traveled long distances, and we will represent them as we take this bill to the Senate floor and monitor the results of the bill. At this time, Senator Huffman, you want to bring up Senate Bill 1004? Yeah, that. Yeah, I think that would get out. Thanks, Pete. Kind of help you all can to get acclimated.
287. These are all different ones. Okay.
Sign on to that, too.
You ready for me?
Yeah, I'll do it on the floor today.
All right, thank you, Mr. Chairman and members. Members, according to the Texas Department of Criminal Justice, there are currently 76,940 individuals on parole supervision or mandatory parole supervision. Of those individuals, 1,689 utilize electronic monitoring and 2,626 utilize GPS monitoring. This past year alone, 1,127 monitor straps for individuals on parole supervision or mandatory supervision were cut, or an active warrant remains following an alert for a cut strap that could not be immediately resolved. Currently, it is only a technical violation of parole and is not considered a violation of the law to tamper or destroy an ankle monitor. Senate Bill 1004 creates a criminal offense if a person knowingly removes or disables a tracking device that the person is required to wear to enable the electronic monitoring of the person's location. This applies to an electronic monitoring house arrest program or as a condition of community supervision, parole, mandatory supervision, or release on bail. An offense would be a state jail felony unless the person is in a super intensive supervision program, in which case it would be a felony of the third degree. I do have a committee substitute I would like to send up, Mr.
Chair lays
Chairman.
out committee substitute for Senate Bill
1,000.
1004. Is the objection? Chair is none. It is before us.
Committee substitute clarifies that a medical professional can cut off an electronic monitoring device for the purpose of medical necessity. The medical community was a little concerned about the language, though of course that was never the intent. It also requires the automatic revocation of parole when an individual cuts off an electronic monitoring device. Additionally, the committee substitute gives judges discretion to make the punishment for removing an electronic monitoring device to be served concurrently or consecutively. Finally, it clarifies that even if a person has a third party do the physical removing of the electronic monitoring device, they can still be charged under the statute. Members, sadly, we have seen the recent news stories of individuals who cut or disable their ankle monitors and subsequently commit violent crimes. These devices are integral tools utilized to increase public safety and promote accountability upon the release of individuals charged with or convicted of a crime. But when they remove or destroy these devices, which track their daily activities, the lives of Texans may be in danger. These are a great tool when used, and the rules are followed, and we want to continue to use them, but there needs to be a message that if you cut them off, there is a consequence.
Thank you. Thank you. Any questions? Brian Collier, resource witness. Yeah, Brian, come on. I've got a quick question. I was surprised to find out that it's not a new, state your name and who you represent.
Brian Collier, Executive Director of
I
Texas
was
Department of
surprised.
Criminal Justice.
I was surprised to find out it wasn't a new offense, and I assumed it was being handled by revocations. The conditions of your parole is that you wear the monitor, you tamper with it, you take it off, we would do a revocation, you'd be issued a blue warrant, you'd be confined, might actually assigned to a
Intermediate sanctions.
intermediate sanction facility for 90 days or longer to kind of realize how serious we are about these. That's not working?
No, sir. Really two issues. One is we issue the warrant. We do, if we have a cut strap, we issue.
How quick, excuse me for interrupting, but so we can understand, how quick when somebody tampers with it is the vendor or you're notified?
Instant, within less than 5 minutes. I mean, you usually get it real time. You'll get the fact that its strap has been cut or either tampered with, then we start an investigation very quickly to try to
Very
make contact
quickly.
with that.
What does that mean?
Within the next 30 minutes, you're trying to talk to the guy to find out. You may, if you can't reach him, then you're going to go ahead and issue a warrant
Okay.
for that individual's arrest. And then we have to wait on that apprehension to happen. And then once apprehended, they could be subject to revocation or subject to intermediate sanctions facility. But for many of these, depending on the length of their sentence, they're nearing the end of that sentence. Revocation doesn't really mean that much from a penalty standpoint as far as time.
That's what I wanted to get on the record.
Yes, sir.
That the current system's not a deterrent, and that's reading Senator Huffman's bill is so critical.
Yes, sir.
You think it'll be the tool we need?
I think absolutely that, and combined with that, if you don't mind me saying, in our legislative request this session, we actually asked for 12 investigators to solely focus on apprehending these individuals, to cut that strap. And I think those two things combined could definitely make a difference.
You're going to get your money.
Yes, ma'am.
Enforce
Yeah,
my
I
bill.
think you're talking to the right person.
Yes, ma'am.
Thank you for being here.
Yes, sir.
Aaron Johnson? State your name, who you represent, Mr. Johnson. And try to
Morning, thank you. My name is Aaron Johnson.
limit it to about 2 minutes, because
Absolutely,
this bill's in great shape.
we're good. I represent the Texas Association of Pretrial Services, and I realize the focus of this particular bill is talking about the post-adjudicated, but I can see it being applied to the pretrial field as well. I am not opposed to utilizing electronic monitoring. I think there's, just like anything else, it's a tool, and it has a time and place. There's been multiple research studies about the effective use of electronic monitoring and what that looks like. My only concern was the levels of cutting the strap. So if I'm understanding this correctly, I don't see the evidence in charging a higher level offense just for cutting the strap. We were talking just a moment ago about providing guidance to the courts. I think this would be a good opportunity to really take a look at the effective use of electronic monitoring. I think there are times, and certainly many jurisdictions, who overuse it just because they feel like it's going to help deter something, which it has been proven not to. So in my experience, overall, I'm an advocate for the process. I've been doing pretrial justice since 2000. I'm currently the president of the Texas Association. I'm the education chair for the National Association, and I also run the personal bond and magistrate office in Galveston County. I've provided training and information to the national audience, the Kansas legislature, California legislature. Now I'm here in Texas providing it to you. We've also worked with other countries, such as Nigeria and the country of Georgia, as they also are tackling and going through kind of what this looks like overall. So, again, like I said, I'm not opposed to the utilization of electronic monitoring. I think just make it a state jail felony, or just make it something that you cut it off, here's the charge.
Very good.
Actually, that is what it does. Unless you're in super intensive, then it's higher.
But that's on the post adjudication part, correct?
Yeah.
For parole?
Yeah.
It also applies to community supervision, yes.
Okay.
Very good. Thank you for
State
being
jail
here.
felony.
Okay. Thank you.
Thank you. Andy, Con? State your name, who you represent.
Andy Kahn, Director of Victim Services, Crime Stoppers of Houston. That's why I sat in the front, so to shorten my walk over here for today. We're in support of Senate Bill 1004. When I went back and looked at what other states were doing, like many of you here, I was pleasantly surprised to see a lot of states currently do have statutes charging an offender who removes, destroys, or tampers with an ankle monitor. In Michigan, it's a felony. Florida, it's a felony. You can actually serve up to 5 years in prison in Florida. Kansas, you have the discretion to charge. California, another state that also has criminal charges. And I'll just quote what a state senator said in California. When they cut off their ankle monitor, they're violating the law and preventing authorities from monitoring them. It's time to strengthen electronic monitoring by adding an additional deterrent. In Kentucky, it's a felony. Louisiana, it's a crime. Missouri, it's a felony. It's time that Texas joins these other states. If I go into a government office and I take a chair and smash it, I'm going to be charged with a crime. Yet, if I'm on parole, probation, or bail, and take an electronic monitor and ankle monitor and chuck it into a dumpster, I'm not charged with anything. It's time to fix that, and we thank you again for sponsoring this bill. I see no downside in having discretion to file charges, and hopefully it'll send a message out to offenders that you will be held criminally accountable. Charging someone with a technical violation, which is what it is right now, having a criminal charge equates more weight to the potential of revoking someone's parole, probation, and bond if there's an additional criminal charge as opposed to a technical violation. Thank you.
Very good. Any questions? Thank you for being here. Individual signed up, do not wish to testify, is John Cursote, the District Attorney of Dallas County, is in support. James Parnell, Dallas Police Association, is in support. Leticia Ybarra, representing herself, is in support. Jennifer Thorpe herself is in support. She's also the Criminal District Attorney of Comal County. John Wilkerson, Texas Municipal Police Association, is in support. Jennifer Sussman-Skingy, Combined Law Enforcement of Texas, in support. John Chancellor, Dallas, Texas Police Chiefs Association, in support. Lauren Laveras, Texas Council on Family Violence, is in support. Shannon Edmonds, Texas District Attorney and County Attorneys Association, in support. Amy Johnson is in support. Anyone else present who would like to testify for or against Senate Bill 1004? If not, public testimony is closed. Senator Huffman moves that Senate Bill 1004 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire,
Yes.
Flores,
Aye.
Hinojosa,
Aye.
Huffman,
Aye.
Betancourt, absent.
There'll be 5 ayes, no nays. Senate Bill 1004 is reported back to full Senate with a favorable recommendation.
Yes.
5 of us. Thank you. You don't want it on local, do you?
No, I think we'll do
You'll
this
take
one
it
on
to
the
floor.
floor.
Yeah, I think so. Good.
Does she want to do SJR?
You want to do your SJR?
Sure.
What's,
Whatever you want me to do, Mr. Chairman.
well, I'm trying to, Chair lays out SJR 44 and recognizes its author, Senator Huffman.
Thank you, Mr. Chairman and members. This SJR is going to sound very familiar to all the members and to the audience and anyone listening, because it was actually passed out of the Senate several times last session and special session, but we're going to make another go at it. This SJR is similar to the ones we did before, passed with bipartisan support in 2021, and we will continue, as I said, to try. Unlike other states, Texas lacks viable options for detaining our most habitual violent felony offenders without bond. It has become starkly clear that our local officials making bail determinations day in and day out need this tool to protect the people of Texas from future harm. SJR 44, if approved by the Texas voters, would amend Article 1 of our state constitution to expand the options available to officials setting bail to include denial of bail under certain exceptional circumstances. It would expand the potential denial of bail to include persons accused of committing a sexual offense punishable as a felony of the first degree, of committing a violent offense as defined by the Constitution, or of committing continuous trafficking of persons. However, for bail to be denied for one of these offenses, a judge or magistrate must determine by clear and convincing evidence that the denial of bail is necessary to ensure either the person's appearance in court or the safety of the community, law enforcement, or the victim of the alleged offense. Furthermore, a judge or magistrate who denies bail under this constitutional amendment would have to issue a written order laying out their findings of fact and explaining why the denial of bail is necessary. Finally, SJR 44 clearly states that a judge shall impose the least restrictive conditions necessary to ensure the accused person's appearance in court and the safety of law enforcement, victim or victims, and the community as a whole. Members, even in the federal court system, denial of bail is often used in exceptional circumstances. It's been held to be constitutional by the Supreme Court. This bill has been delayed now for a couple of years, and I think it has cost lives, to be honest. The delay has delayed the ability of our judges and magistrates to utilize this tool in these specific situations where it could make a meaningful difference. I want to thank Governor Abbott for putting this on emergency items so that we could do it quickly and get this bill moving. I think it's absolutely critical that this bill passes. I ask support here in the Senate, and I ask those who are interested in this issue to please help us on the House side and try to rally the votes. We need 100 votes over there. Confident I can get it out of the Senate. I would assume it's going to fly out of here pretty quickly, but we need help in the House. So that's my bill.
Essentially, it just allows and requires risk assessment. And then after you do a risk assessment, if there is that high risk, you can deny the bond.
You can deny the bond. You have to
And
give a
so-
written order while you're doing it.
So when I was doing my research a few years ago, I couldn't imagine, why is it in the Constitution in the first place? And if anybody can tell me, I'll buy you a Coke. It goes back to the Texas Revolution. Stephen F. Austin and his settlers were being held without bond by the Mexican government. So once they wrote their Constitution, they made certain that everyone was entitled to bond. It's been carried forward, and I think in 2023 it's outdated. That with the challenges we have in the criminal justice system, a judge and prosecutors and victims and society should allow a judge to deny the bond after a hearing.
Absolutely.
I
And
think-
and I would add, it's very balanced. We want to deny bond to the most violent offenders, but it also says that you're to use the least restrictive conditions necessary
After a
for
risk
our
assessment.
low-level offenders.
Yes. Very good. David Mitchum is signed up, would like to testify.
Hello.
State your name and who you represent, David.
Thank you, Senator. My name is David Mitchum. I'm an assistant district attorney with Harris County. I work for Kim Ogg. I'm the first assistant chief of courts, supervise approximately 300 prosecutors every day in the courts in Harris County. I've been a lawyer for 43 years. I've been trial counsel for over 200 jury trials, both as a defense attorney and a prosecutor. I've been board certified in criminal law by the Texas Board of Legal Specialization since 1985. And I'm here to support Senate Joint Resolution number 44, and I would like to speak to that. And I'm here on behalf of Kim Ogg and all the dedicated prosecutors and staff of the Harris County District Attorney's Office. The proposed state constitutional amendment detailed in Senate Joint Resolution number 44 provides for both the application of the least restrictive conditions of bond and the setting of bail by the judge on the bench, while at the same time clarifying judicial responsibility for public safety by authorizing the denial of bail in limited instances of certain cases involving violent crimes and sexual crimes and continuous criminal trafficking of persons. The proposed constitutional amendment balances our society's legitimate pretrial liberty concerns with the two central purposes of bail. The two central purposes of bail are to ensure the defendant's required appearance in court and to provide for the safety of the community, members of law enforcement, and the victims of crime. The proposed constitutional amendment addresses our society's legitimate pretrial liberty concerns by providing procedural safeguards in any judicial denial of bail order. With any such judicial determination denying bail, there must be 1, a written order by the judge containing findings of facts, including a statement of the judge's reasoning for denying the bond. 2, such an order requires testimonial evidence in open court. 3, the heightened burden of proof by clear and convincing evidence is to be applied by the court when considering the required factors under the present general law in the setting of bail in the event of a denial of bond. And 4, although the defendant's present constitutional and statutory rights are preserved, with no limitation of any of the defendant's rights to contest or appeal the amount of bail at issue. For those opponents of the current cash bail system, this proposed constitutional change is not about cash bail. Some defendants are simply too dangerous to allow free in society at any dollar amount. Yet our current Constitution forces us into putting a price on society's safety. This amendment would inject some common sense into the system and allow certain violent defendants or accused sex offenders to be detained in custody until the trial of their case. In conclusion, Senate Joint Resolution Number 44 would provide a more perfect restatement of the law, supporting both the twin purposes of bail, ensuring the defendant's required appearance in court, and protecting the public, law enforcement, and the victims of crime from further reasonably foreseeable dangers, while at the same time providing for the least restrictive conditions of bond consistent with our state's historical tradition of ordered liberty under the rule of law. We, at the District Attorney's Office of Harris County, enthusiastically support the passage into law of this joint resolution.
So, Senator, thank you. Senator
Thank you.
For the President, and I think has a question.
Thank you. David, good testimony. And I think a couple important things about Senator Huffman's bill. First off, you made a comment about testimonial evidence in open court. One of the problems that I see with the current system is that these decisions to release violent criminals back out on our streets like popcorn have been done without open testimony in a court of law. And I think Senator Huffman should be, credited for pushing this point, because if we're going to make a decision about bail, we need to have that, that testimonial evidence. So to people that oppose this, I want to say, how can you oppose this transparency and the sunshine? Am I missing something, Dave?
I don't believe so, Senator. I think you got it about right.
Now, the other point that you made is reasonable foreseen danger. The problem we've got right now is that, from what I see, what's happening is you have certain judges that are releasing them like popcorn again, and these are inmates. These are dangerous, felons that whose attacks on society escalate. Assault with a deadly weapon, murder. Okay, and so you give the judge and the actual guidelines here is to prevent releasing people that are reasonably foreseeing danger. Would you want to comment on that?
Well, that's a significant problem in Harris County, where we have over the past few years we've experienced a number of courts that have released defendants over and over again. It used to be back in days of yore when Senator Huffman was Judge Huffman. If an individual was out on bond on a felony, and they were to pick up another felony charge, and probable cause was established that they had committed the offense, that was enough to motivate a judge to go ahead on their own, sua sponte, as they say, to have the individual placed in a secure environment until the trial of his case. He's still presumed innocent, but he can be presumed innocent in the holding cell until the trial of his case, just as easy as he can be out on the streets of Harris County, endangering our people.
And as the first assistant to District Attorney Ogg, you made a comment that there's a group of people that are simply too dangerous not to consider this as an alternative. Because I see Andy Kahn over here. Crime Stoppers has identified somewhere between upwards of 180. I'm not sure what the current number is right now, of people that have died allegedly at the hands of people out on either, continuous PR bonds or low dollar felony bonds. True?
That is exactly true. We have had defendants out on bond for capital murder go out and be charged with an additional murder.
And I can't speak for then Judge Huffman, but I knew her back then, okay? And I think that her reaction would be, as a judge, pretty like what should be with common sense. That's pretty horrific that you have people out on 2 capital murder bonds, and there's additional lives that are lost. It's astonishing what we're dealing with.
It's horrifying, Senator, and this is just the tip of the iceberg, so to speak. When we talk about murders, there's also aggravated robbers, burglars, other offenders out there that create a real and decisive danger to the people that we are trying to protect.
Well, I've told Senator Huffman, you know, I'm not only all in, I've got all my constituents are all in. I've never seen such an anger about this because it's reasonably foreseen danger. It means that a common person could see this is going to be a problem, much less somebody that's supposed to be a trained legal professional and have experience in, you know, in criminal cases. So I want to thank you for your testimony.
Thank you, Senator, for all your work. Thank you, Senator.
Thanks, Dave.
J.R. Woolley. State your name and who you represent.
Good morning, Chairman,
Morning.
Senators. I'm Judge J.R. Woolley. I'm the Precinct 2 Justice of the Peace in Waller County, and I'm the Legislative Chair for the Justice of the Peace and Constables Association in Texas. As that position allows me, I'm probably one of the few people you'll hear from today who actually magistrates regularly. We as an association are in support of this bill. For years, Texas has had issues with bail, and last session, meaningful changes were made on that front. Chief Heck has stated in the past that broader authority for magistrates to deny bail to individuals who commit certain violent or sexual offenses when the safety of the victim, community, or law enforcement cannot reasonably be assured should be enacted. And we agree with that statement and believe that broader discretion for magistrates would make Texas a safer place to live by taking measures to reduce violent recidivism, which we have seen a lot of across our state, not just in Harris County. JPCA supports our members' discretion and their decisions and supports SJR 44, which provides that discretion and makes additional strides in bail reform for our state. I'd be happy to answer any questions.
Any questions?
Thank you.
Thank you, Judge. Andrew Wright. Officer Wright, state your name and who you represent.
Good morning. My name is Andrew Wright, and I'm a lieutenant with the Houston Police Department, who I represent in favor of SJR 44. I've dedicated my career to working proactively to identify and arrest violent criminals. For the past 3.5 years, I've been the supervisor of the North Divisional Tactical Teams and the Warrant Execution Team, where our goal is to take the most of the worst violent offenders off the streets to try to improve the safety in our area. Prior to joining the police department, I went to law school here at UT Austin, and so when I joined, I took a bigger interest in following the legal proceedings of the suspects that we arrested to see what would happen with them. Back when I first started, it was pretty common. Your first serious violent offense, you would get 5, 7, 10 years of deferred adjudication, probation, and either you followed that or you didn't, and you went to jail for a long time. That seemed good for both sides, because if you made a mistake and straightened up, it worked out well for you. But as time has gone on, this relationship between those we arrest and the future violent crime we prevent has become more attenuated. This situation is not good for anyone. Certainly not good for the police, who are discouraged by sometimes spending more time doing the paperwork to put a suspect in jail than they actually spend there. It's not good for the general citizenry of Houston, who's victim to these recidivist criminals over and over again. It's not fair or good to the victims of crime, who you've heard testify today, who live in constant fear as the perpetrators who committed crimes against them are out in public. It isn't even good for the criminal defendants themselves. As others have testified, when you don't get that connection between the actions that you take and the consequences, your violence escalates until eventually you've committed a crime that's going to land you a substantial portion of your life in prison. While some people have pushed that the cash bail system was bad for poor defendants, I will say that when those defendants were instead released on PR bond, it was bad for the poor communities that they live in, because the FBI will tell you that most people commit crimes in and around their neighborhoods. From a practical standpoint, suspects free on PR bond have little incentive to go to trial anytime soon, as they're free in the meantime. And the phrase personal recognizance is in itself a farce, as why would we take someone's own word of their personal appearance time and time again once they've broken it? Let's take a few examples from people that me and my officers have dealt with. Derek Martin. I won't go into his juvenile record, but 6 days after he turned 17, which is an adult for us, he was arrested with his first felony for shooting 10 rounds from a firearm into a house occupied by 5 juveniles aged 2 to 14. During that same month of June 2020, he was charged with 3 aggravated robberies for robbing cell phone stores. He was then charged with 2 further crimes, possession of a firearm unlawfully, twice, and evading from police in a motor vehicle. But wouldn't you know, having been to trial for none of those crimes, in May of 2022, he was free on the streets of Houston, where he was the lead suspect in 2 different shooting offenses that happened in North Houston, until he was finally arrested at a hospital, which caused quite a stir in a Code Pink. But anyway, that's what it took to finally get him behind bars. And we'll say the victims of that initial deadly conduct back in 2020 saw no justice because as he pled guilty to another crime, those charges were dismissed. That's generally how it goes. You plead guilty to one offense, the rest of them are dismissed, so maybe one victim gets to see justice out of that. That's not fair. We have tons of defendants we could go through. Shermaine Childress on bond for felon in possession, ag robbery, and murder when he was arrested by my wet team for federal felon in possession charges. These are the extents we've had to go to. Last fall, the special agent in charge with the ATF in Houston created a task force with the DA's office and Houston Police to charge the most dangerous fugitives out on bond in Houston that have already been charged stateside with felon in possession of a firearm federally, because the federal system has options to detain defendants and actually keep them off the streets, to keep them from perpetrating violence on more innocent victims. The list could go on and on about defendants, and I don't think we have that kind of time. I think in Houston, we don't necessarily have more criminals. We have the same criminals let out time and time again for us to catch, and it is not a good situation. The citizens of Houston are placed at great risk because of habitual recidivist offenders like those I described, and I urge you to vote in favor of SJR 44 to give judges and DAs the tools they need to keep violent offenders off our streets until they have to answer for their crimes.
Mr. Chairman.
Senator Hinojosa.
Thank you for your testimony. And you really outlined many of the issues we're trying to address with SJR 47. And I don't know if you ever experienced this in your county, Harris County, where you have a person charged with murder and the judge sets a very high bond and the murderer or defendant accused cannot make that bond, but they keep filing motions to reduce, and the judge keeps reducing until they get to a point they can make that bond. Do you have that issue up in Harris County, or have you experienced that?
Yes.
And they let him out.
I'm aware of those incidents. I can't testify specifically about those.
Thank you.
Very, very good, Senator Bittencourt.
Just, Lieutenant, right, just, you made a comment that you're seeing this crime then come back in low social economic areas. True? You want to expand on that?
Yes, I mean, I think initially some of the push for the elimination of the cash bail system was that this disproportionately impacted poor defendants, right? And that the part that we forgot is if we flip that coin over and we give all those people PR bonds and we release them back into their communities, people commit crime most often where they live.
Right.
And so there is going to be a disproportionate impact. There was probably a disproportionate impact on the cash bail system against poor defendants. And if we give them all PR bond and cut them loose back to where they live, there will be a disproportionate impact on poor citizens in the neighborhoods in which they live.
Right, thank you.
I'm curious, you went to law school?
Yes, sir.
UT. Why,
Yes, sir.
why did you decide to be an officer with a law degree? Did you,
This
did you
kind
know
of
that before you went to law school?
No, sir. This kind of stuff seemed a little boring to me, so I wanted to go. No offense.
I'm not going to ask you another question.
Sorry about that.
But it is impressive that you would go to law school, and that's not uncommon. That I had a best high school buddy went to UT and got a bachelor's and came out and wanted to be an HPD officer. We all questioned him, but Tim Hearn, who was eventually shot on a narcotics raid and killed. But it's always impressive to me, Senator King, why you choose that line of work, particularly when you have a law degree and you, I assume, planned on having a law practice.
Well, it's a fun job, and I think it's an important job,
Well,
and I enjoy
we're
it.
fortunate to have you. Thank you for being here today.
Thanks, sir.
Maria Jackson, do you want to testify, Ms. Jackson?
Judge Jackson.
Judge Jackson, yeah, how can I forget that one? Judge, state your name and who you represent.
My name's Maria T. Jackson, and I represent the Houston Police Department. And good morning, Chairman Whitmire, Vice Chair Huffman, and members of the committee. I want to thank you for allowing me to speak today. I'm currently a supervising attorney with the Houston Police Department, so therefore I represent the Houston Police Department. I am here in support of the Senate Joint Resolution 44. I'm testifying because I'm uniquely qualified to testify to support this bill, because not only do I work for the Houston Police Department, I also served 3 terms as the presiding judge for the 339th Criminal District Court and as a magistrate for 20 years, for 20 years, beginning at my municipal court days. There are 5 factors that a judge must consider in setting bail. Bail shall be sufficiently high to give reasonable assurance the accused will appear in court, the power to require bail not to be an instrument of oppression, the nature of the offense and circumstances under which the offense was committed, the ability to make bail, and the future safety of a victim, the community, and law enforcement. A judge has a responsibility to balance these factors when considering the nature of the offense and the circumstances under which the offense was committed. There are circumstances in which denying bail serves to ensure the future safety of the victim and the safety of the community. For example, violent offenders and habitual offenders. This bill lays out perfectly and gives the judges a roadmap of what they need to follow when determining to release a defendant on bond or to deny bond. Now, with that said, it also remains very important that the accused still has the right to have a speedy trial. As both a Houston Police Department representative and a judge, and as Judge Maria T. Jackson, I throw my full support behind the Senate Joint Resolution 44, and I just want to thank you, Vice Chair Huffman and Senator Hinojosa, for bringing this bill forward. It's very important.
Thank you, Judge. Any questions?
I wish she was still on the bench. But
I wish we had some clones on the bench.
Yeah, we're not going to take that up this morning. but-
I just made a comment.
I do come from the old school days as Vice Chair Huffman. I did
Actually,
exercise those rights.
I would never want to correct the judge, but she's a powerful chairman of finance. Here's my vice chair. Here's my vice chair.
Flores, yeah.
Oh, I apologize.
But if you want to call her vice chair, she was the vice chair of this committee for several sessions. So anyway, thank you, Judge Jackson.
Thank you.
Thank you.
Jennifer Thorpe. I'm still doing new court. What is that?
It's nice and orderly.
Good morning. My name is Jennifer Tharp. I'm the Criminal District Attorney for Comal County, and I am testifying in support of SJR 44. I will tell you, I've had the privilege of testifying before this committee and several others on what I believe are smart pieces of legislation. And I have to say, hands down, probably the most impactful for my community, and I believe the state of Texas, was last session SB 6. And I feel that SJR 44 is just taking SB 6 and all that great work to the next level. I won't belabor the point. Several witnesses before me have touched on the importance of this piece of legislation. But if I had to summarize it with 3 terms to describe it, it's smart legislation, there's transparency, and there's also accountability. And so I wholly support SJR 44. I'm happy to answer any questions you may have. But I think what I like most about this is a quote from U.S. v. Berger, which is that guilt, not escape, our innocents suffer. And that's what this piece of legislation is. So thank you for carrying this, and I look forward to everybody happily voting it out of this committee, out of the Senate, and off to the House.
Thank you, ma'am. Any questions? Thank you, Mr. Tharp. Andy Kahn? Where's the opposition? State your name, Andy, and who you represent.
I'm Andy Kahn, Director of Victim Services, Crime Stoppers of Houston, and we are here in support of SJR 44. When you think about what SJR 44 does, it simply allows Texas voters to decide whether or not judges should have discretion. And that's a key word, discretion. It's not a mandate. Simply to deny bond to defendants charged with certain violent felony crimes. Simply discretion. Is it going to be a panacea that some detractors are of the perspective that we're going to be locking people up without bond? I highly doubt so, because the factors are built in with the constitutional amendment. I've charted over 185 people that have been allegedly murdered, though some actually now convicted, by defendants released on multiple felony bonds or felony PR bond or out on bond and had forfeited a bond in Harris County. Of that 185 some odd figure, 65 were in 2020. 2021, there were 57. And I can unequivocally tell you the numbers plummeted in 2022 to 27 that fit that criteria. Part of that reason, no doubt in my mind, was the implementation of Senate Bill 6. Our numbers have dropped dramatically. Passing SJR 44 will continue to have the numbers dropped. There was a news report a couple of years ago. We did a story on a guy that was on 10 bonds for aggravated robbery with a deadly weapon. And I said, well, first of all, dude, you're not very good at this because you keep getting caught. Second of all, in order to rack up the 10 charges, you got to be out here to do this. Right. And the reporter asked the judge, and I give the judge credit because he did respond, and the reporter said, when is enough is enough? And the judge honestly said, I don't have the luxury of saying enough is enough. I have to, by statute, give a bond, and I have to make it where it's not punitive in nature. So I have no choice. 2 years ago, an off-duty police officer, sergeant from New Orleans, he and his buddies were at a Grotto restaurant Saturday afternoon in the Galleria area having drinks and dinner, Saturday, 5 p.m. They were jacked by several individuals for their jewelry. He and his friend were shot and killed. One of the defendants now charged in his capital murder, 19-year-old Frederick Jackson. He was 19 years old. He was on 5 felony bonds in 2021. Bond after bond after bond. And I'll give you another spin on this. Do you think the court did him any favors by continuously releasing him when it was fairly obvious that this bond thing just wasn't working out? Now you have a 19-year-old that's looking at a potential death sentence or life without parole because we continuously released him back to the community. We had another case when someone asked me what was one of the most egregious cases that we documented. Rita Acosta was 43 years old when she was murdered by Jesus Gallegos. Gallegos was just recently sentenced to 48 years in prison. Gallegos was on 5 bonds in 1 year. 3 of the bonds were for domestic violence felonies involving Rita Acosta, assault with intent to impede breathing, aggravated assault on a family member, felon in possession of a weapon. 5 bonds in 1 year. Finally, Jesus Gallegos murdered Rita Acosta. It's time that we give judges discretion. That's all this is. I see no downside in having discretion, and more importantly, Texas voters should be able to decide whether this is a good bill or a bad bill. So I appreciate all the support for this. Let's get it out. Let's get it out like we did last session out of the Senate. And this time, let's get it out of the House and give judges more tools to operate on behalf of public safety. Thank you.
Senator Bettencourt.
Thank you, Mr. Chairman. Andy, I think this is a very important point because I got introduced this to what you just said about domestic violence with the case of Caitlin Rose Enfinger, who the judge released her estranged husband, Guado, if I have the right name from memory, on at least 2 PR bonds, but he also had multiple other felonies. And the second time he released that the estranged husband, he had just come from chloroforming her cat and beating her up. So within 72 hours of release, she's dead. And you made the point that if you can stop domestic violence, you might be able to save the perpetrator, but you certainly save the person that died and maybe the family from a lifetime of horror that they have to now live with. And I think this is a very important point that Senator Huffman's bill recognizes is you have to stop this before people die. And why we're having to have a debate, quite frankly, in the House about this, I'm astonished on that, because when you see these cases, and especially the one you said about domestic violence, I mean, the pattern is there, the escalation is inevitable in some of these cases, and the only way to stop it is to keep that person from being able to have access to the person they've intended harm to in their own family. True?
Absolutely. In other cases we've documented, 3 were actually law enforcement officers, 2 that were on duty at the time. One of them, Sergeant Kayla Sullivan in Nassau Bay, the defendant charged in her capital murder, was on 3 felony bonds in 3 different counties in 1 month.
Wow.
And that is rage, and the inevitable outcome is death. Thank you.
Thank you. Thank you, Andy.
Thank you.
April Agrari. April, try to keep it to about 2 minutes if you can, please.
Thank you for having us again. So basically what this does is this gives our judges to deal with the worst of the worst criminals. The reality of the matter is that being low income shouldn't give people the right to go on a discounted rate and continue killing, robbing, raping. I mean, we're talking about the worst of the worst criminals. So when we are talking about giving these judges these tools, this is not going to be something that's going to be applied to everybody. But we got to think, do we have the tools to give these judges to deal with the most heinous of criminals? And this is what this is going to be for. I think that it's very common sense piece of legislation, and I think that it's going to help everybody across the state of Texas. Unfortunately, some of these crimes are just getting worse and worse. When you think you can't be surprised, we read something even worse. It's happening, it's a part of our society, and our laws need to evolve to deal with these types of criminals. Maybe 30, 40 years ago this wasn't happening, but it's really happening now. The domestic violence cases here in Harris County have skyrocketed. The violence against complete strangers with road rage shootings, that in itself, for you to be able to shoot a complete stranger with such little provocation, it's a danger to everybody around you. You can't let these people out. But I thank you for bringing up this piece of legislation because it's very needed. Judges have their hands tied. When they're trying to do their jobs, they cannot.
Thank you.
Chairman, just a quick question. I think you made a very good point in that it shouldn't make a difference whether you're rich or poor.
No.
And I know that are arguments against this bill by people that say, well, it's going to impact in a negative way if you're poor and you cannot afford bail.
Yes.
And my response is, it does make a difference. You committed a crime, you committed a crime.
Yes.
And the focus ought to be on protecting the public and the victims, and not necessarily focus on whether the accused is poor or rich.
Absolutely. And usually the victims are of low income. So you have 2 low income groups that are being affected. And just like in our family, this family didn't have the money to bury Arlene. The money was donated by the community. So victims can't afford those medical bills that are imposed on them, and victims can't afford burials. The majority of victims have to cremate their loved ones because they can't afford a funeral.
Thank you for your testimony.
Thank you.
Mr. Chairman.
Thank y'all for traveling. We have several witnesses have signed up in opposition. Jaslet Griffin Lee. Is Miss Lee here? Griffin Lee?
I'm going to pass, thank you.
Okay, she did sign up in opposition. Nicholas Hudson. Mr. Hudson, state your name and who you represent.
Good morning, Chairman and members, and I'm unfortunately here, Senator Hinojosa and Senator Huffman, to testify against SJR 44. Our country's made important promises in our Constitution and laws about what justice is supposed to look like.
Ooh, excuse me, did you say who you're representing?
The ACLU of Texas.
Okay, sorry.
All of us are entitled to a presumption of innocence under the law and a fundamental right to pretrial liberty. And even if we're accused of something very serious, we're entitled to those sorts of rights. And given these fundamental rights, any denial of a person's freedom before trial has to follow a very fair process that follows certain requirements. And you can only deny people's bail after for very good reasons. And intentional pretrial detention is only allowed in America when facts and circumstances about an individual defendant show a clear and convincing evidence of an extreme, unmanageable risk of either fleeing prosecution or committing a serious or violent crime. I want to acknowledge that you'll have a difficult task ahead. I think that balancing a defendant's liberty with public safety, those are important tasks and they're difficult.
Let me interrupt you. What about the repeat offenders? I mean, how many strikes do you allow somebody to have? You've heard the horror stories of people getting bond after bond after bond, and then the last time they're out on bond, they go and commit a violent offense. So what do you do with that person?
Well, there are currently some provisions in the Constitution to allow if you're accused of multiple felony offenses.
In Texas, our Constitution says you're entitled to a bond with about half a dozen exceptions.
Denial.
And as someone kept emphasizing, Andy Kahn saying, it's just given the judge discretion to do a risk assessment. And there's actually a hearing on behalf of that defendant.
Yeah, if I could just...
I don't know how you, I mean...
Yeah.
How do you deal with that violent offender that's on the loose on the street? And not 1, 2, 3, 5, and 6 times they get another bond. First of all, I don't know why the first bond's not revoked. You know, when I was a young attorney, they'd be revoked and held and go to trial. So we got a broken system. Wouldn't you agree?
Yes, sir. I don't think anyone would disagree with it. We've got a broken pretrial system, and we need to make some big
So a
changes to
reasonable
protect public
approach.
safety.
Now Senator Huffman has a reasonable approach. Give the person a hearing. If they're determined to be a risk, a danger, they don't get a bond.
If I could just say just a moment more about where I think the specific deficiencies are, and I also have written testimony that I've gone into detail on these and I've sent them to all of y'all, and I've talked with your offices about them. But it does include a clear and convincing standard of evidence. It does include least restrictive conditions, both legally required.
When I cured this years ago, we couldn't get the least bond. So she's even been more reasonable than I was a few years ago.
Well, I think that there are other ways that it's insufficient, and I want to just describe what the consequence of this would allow. As written, it says we are okay with allowing innocent Texans to be jailed for months or years, pending a trial of allegations legally presumed to be untrue, if a judge is satisfied that somebody might miss even a single court date, or might commit even a minor crime indirectly connected to public safety at any point in the future. Our concern is about overbroad pretrial detention, and that's why we wanted to come and talk to y'all today. And we've gone into detail in our testimony, and happy to answer any questions, but I want to acknowledge this is a difficult subject. And that
It's
y'all
not really difficult after you've heard these horror stories from 5 and 6 bonds, and someone kills an officer from New Orleans. It's not a tough call, particularly with the safeguards that Senator Huffman's included. So anyway, we appreciate it. We know you got a job to do, but I'd rather have my job than yours this morning.
I know, tough crowd.
Yeah,
Thank you, I appreciate it.
tough crowd.
Chris Harris. State your name, Mr. Harris, and who you represent.
Sure. Hi, my name is Chris Harris. I'm the Director of Policy at the Austin Justice Coalition, and I'm here in opposition. When there was an initial hearing about this a couple months ago, I came with a couple gentlemen, one in particular by the name of Cyrus Gray, who was out on bail on a capital. His story, I think, exemplifies the injustice and the fault, the foolishness of this effort. We have a criminal justice system that continues to be impacted by racism at every single step of the process. We know similarly situated individuals, similar charges, similar criminal backgrounds, people of color are treated differently throughout the system. And in the case of Cyrus Gray, he's innocent, okay? He spent over 4 years in pretrial detention on a high bond. I'm sure there was clear and convincing evidence to keep him there in the minds of the jury, in the minds of the judge there, and the minds of the prosecutors.
Excuse me, what's he charged with?
Murder.
Okay. And he's in confined?
He was. He's now out on bond because, well, one, during the trial, the jury consistently voted to acquit. Then they came down with COVID, so they called a mistrial.
Wow.
But it was during deliberations during which they repeatedly voted to acquit. Another gentleman was arrested for the same crime. He just celebrated his 5th year anniversary in the Hayes County Jail. Okay? Similar facts. Okay? This person is almost surely also innocent. Okay? So this is what we're talking about when we talk about a system that can't be trusted with these additional tools that you're talking about. Okay? I think we've seen Justice Hecht in the Supreme Court talk about supporting some of these things. We see even in states where they're getting rid of cash bail, they're enhancing judicial ability to hold people, detain people without bail in the case that they see that there's an issue. The issue is that this is happening without the other side of the coin, without actual remedy or relief for people who are poor on the other side of this system, who are still being jailed improperly, who are still being jailed en masse at immense harm to them, their families, and their communities, as well as at immense cost to the state and to its taxpayers. So there is a place for what this is attempting to do, although I agree very strongly with the gentleman from the ACLU that this is overbroad, particularly as it relates to people who are deemed to, not coming back for a next hearing. But doing this, particularly without major reforms on the other side of this, to ensure that we're not also jailing people who are simply there because they're too poor, who actually represent no threat, who actually represent no risk to flee. I believe it was described as a 3-legged stool, and this topples the stool over. And again, we have a jail system that has major issues. We have, obviously very full jails in many large communities, major costs, and people are dying in those jails. So, those people's lives matter too. And unfortunately, we're not hearing the stories of those folks who are dying in overcrowded jails in our community. So, thank you for the time.
Thank you for being here. Nathan Farnell?
Yeah.
Farnell?
Yeah.
State your name and who you represent.
Good morning. Nathan Fennell. I'm an attorney at the Texas Fair Defense Project. We are unfortunately going to have to oppose SJR 44. I want to talk about two.
You say unfortunately you're opposing it. Well, you made that decision.
So right. And there are two pieces of this that I want to talk about today that are both protections in SJR 44 that we think don't go far enough, and we would hope that the committee would consider. The first is Senator Betancourt spoke some about the transparency that's built into this and the findings that are in there, and that's really important. We appreciate that. One thing that a lot of folks don't know is that in most parts of Texas, magistration hearings are not open to the public. They're being done in jails where people can't watch the hearing. And so magistrates can't be held accountable for the decisions they're making in the moment. That's true of all bails being set, not just these hearings, but it's particularly important that the public be able to see what magistrates are doing when they're setting bail.
Do you support the constitutional amendment if we made it where magistrates' actions are public?
Not with that alone, no.
No,
No,
wait a
we're not going to
minute.
support it.
Wait a minute. I hear your concern, and I think we're actually going to look at reforms on magistrates.
Okay.
Because they should be transparent.
We-
Actually, we need to know who are the magistrates, where they come from, who selects them, what's their qualification.
Yes,
So
Chair.
we could reform the magistrate process if that would make a difference to your support for this constitutional amendment.
It would make a difference to a lot of things. I don't know that I could say with that alone we could support this constitutional amendment.
Okay.
I think the second thing that that is important about the provisions in SJR 44 is so again, just to be really clear, the first piece, right, is about the public's being able to attend and view magistration. The second piece is specifically this joint resolution talks about the consideration of failure to appear in court. And as you've heard a little bit of before, failure to appear in court is no doubt inconvenient for judges, and it causes resets, but it's different from flight to avoid prosecution. Most people who miss court actually turn themselves back in later. And there's a difference between someone who misses court one day and someone who is intentionally trying to avoid being prosecuted. And when we're talking about
You're not condoning missing court, surely?
No, I'm not condoning missing court.
It sounds like it.
I'm not intending to. What I'm saying is that what we're talking about here is an awesome governmental power, which is that the government can take someone and hold them in jail, no matter what they do, no matter how much money they have, until our courts, which we know are backlogged, can get around to having a trial for them. And this can take years. This can take many years. And so what we're talking about is trying to balance the harms that the state is trying to avoid with the rights of the accused. And what we think is that considering the fact that someone might miss a court date, which is serious and can be addressed by revoking their bond, by pretrial conditions, by these kinds of things, we think that risk alone, without a finding that the person is likely to actually affirmatively try to flee prosecution, is inadequate to justify preventive detention without bail indefinitely for someone.
Okey-doke. Any questions, Senator Bentoncourt?
Thank you for the reference earlier, but I want to go back over this.
Yes.
Don't you think that testimonial evidence in open court would have helped the last two references that were the previous speaker? Because they seem to be in a situation where they don't have an open court discussion of their bail status, true?
I think that's certainly correct of the initial bail setting hearing. I can't speak to whether those folks may have had subsequent bail hearings ever where someone could present testimony.
Okay, but there should be an argument of this because really no fact or supposition of fact that if the bill offers testimonial evidence in open court, that's a positive step.
That's absolutely correct, Senator. Yes.
Right. Because I think that's important because when I hear these other stories, I know what that testimonial evidence would do to help them. And so I don't understand the recalcitrance of supporting the bill because this is like a major step forward.
I think that is a major step forward. Yes, Senator.
So, Bettencourt, I think we just need to clarify because we're throwing around the word testimonial evidence. The bill specifically doesn't require testimonial evidence. It does require evidence presented and a written order prepared by the judge.
Okay.
But it's set up in a way where it could be done through hearsay testimony or something that, as most bond hearings are done now, information is presented to a judge. The judge has all the information that was in SB 6 that's provided about a defendant's, history and background and so forth. So all the factors that they currently have to look at under SB 6, plus any additional information that could be offered by either, the defense lawyer or by the prosecutor. But it does require the judge, for the transparency side of it, to prepare a written order that includes findings of fact. So the judge would have to make specific findings of fact and a statement explaining the judge's or magistrate's reason for the denial. So for the public, they would have access to that document, which would very clearly set out the reasoning and the thought process that the judge had in making their discretionary decision.
Yes, and we are appreciative of that and the thoughtfulness that's gone into it.
Yeah, okay.
Any other questions? If not, thank you.
Thank you.
David Gonzalez. And I'm going to ask everybody to keep it to about 2 minutes so we can finish before we go into session at 11.
Yes, sir. David Gonzalez, the Texas Criminal Defense Lawyers Association, testifying in opposition of the bill. We just categorically oppose any constitutional amendment that denies bail. But we concede that by clear and convincing evidence, it's a very different standard than probable cause for an arrest. It's just if it was like Senator Betancourt's testimonial hearing, then you're right. There's a far greater kind of examining trial as to what are the factors that would then lead someone there. I just think it doesn't require that. It says there's nothing that shall require a hearing in the bill. And second, we're not present at magistration. We're not advocating for low bonds. We're not appointed until days later. And so the current Constitution provides for the denial of bail for repeat felony offenders. This changes it, and I understand a first offense capital murder, there's a difference on those repeat offenses, but our concern is that we're changing the Constitution for what appears to be a magistration issue on people setting these bonds, and we're not part of that process, and those are our concerns about the amendment.
Very good, thank you. Lauren Rosales. State your name, Ms. Rosales, and who you represent.
Lauren Rosales with the Bell Project. Good morning, Chair Whitmire, Vice Chair Flores, and members of the committee. My name is Lauren Rosales, and I'm the Texas Operations Manager for the Bell Project. I appear today in opposition to SJR 44. The Bell Project is a national nonprofit that provides free bail assistance and court support to thousands of low-income people every year while advancing policy change. Our work across the country proves that cash bail is unnecessary and that there are more effective ways to improve our nation's pretrial systems. Pretrial detention was designed as a carefully limited exception, but SJR 44 is not limited enough because it allows judges to use pretrial detention simply if they believe a person may miss a court date. Missed court appearances may be inconvenient, but they are hardly reason enough to keep a person in jail away from their families, jobs, and communities. Most missed court appearances are unintentional. They are not attempts to willfully flee or evade prosecution. Like missed medical appointments, they occur due to sudden illness, inescapable work obligations, travel challenges, childcare responsibilities, and confusion around details like the location or time. Pretrial detention results in more family and caregiver separation, unemployment loss, economic insecurity, housing instability, and worsened health and behavioral health outcomes. This amendment would mean that more Texans would remain locked in jail away for weeks, months, or years without having been convicted of a crime. More Texans will plead guilty, and we're resulting in more unnecessary incarceration. We ask the committee not to subject Texans to these extreme consequences simply to prevent a missed court date, and are here to offer our support to improve public safety by preventing criminal system involvement in the first place. Thank you for your time.
Any questions? Thank you for being here. Melissa Martinez? Martinez, I'm sorry. Didn't read it. State your name and who you represent, please.
Sorry. Hi, good evening. I'm here testifying against SJR 44, and I just want to bring up some personal stories. So Matthew Shelton was detained in Harris County because he couldn't pay a $10,000 bond on and out of the country DWI case. He died an entirely preventable death because he didn't get his insulin. His sister said that he had even medicine and needles needed to treat his diabetes, but the jail wouldn't access them. Simon Peter Douglas, who was the first one to die in custody in 2022 in severe emergency psychiatric crisis within 24 hours of being booked in. Evan Lee and Fred Harris, who were both special needs individuals, and Ja'Carri Simmons were murdered in jail. These are people who have been neglected and a continued missed opportunity by legislation that is choosing harm over care. Everyone deserves to be centered and worked at the root of the core for transformative change. A better world is possible. And within that possibility, it's to acknowledge, to not result in frustrations, and to dismiss to continue restricting and contributing to a death and assault machine of the prison industrial complex. An eye for an eye has never worked. It's time to put faith and belief into practice of loving everyone and investing to a path that is nurtured, that is righteous, into a space of professional on these crises and building and repairing to be the best. I'm from Houston, and I'm also a resident at Harris County. And I'm trying to seek an education in mental health and so forth. So I am not only missing my classes or at my job because I'm also low income, but it's because I'm here invested in my communities from both angles. And I am also a survivor of many violences. And I have put the work into practice in seeing the humanity of those that are being subjected to these dehumanizing legislation of incarceration, because I have seen firsthand towards those that have harmed me that they need care, they need to be invested for. And I agree, and I hear the urgency for safety, and I completely agree in that same urgency. But as many have spoken before me, and to my community, safety is a huge priority to me. It's why I'm putting my belief and my faith into practice to oppose these bills, as that will make Texas less safe. And what makes us safe is harm reduction, mental health services, having these investing of these allocated resources for these spaces to grow and nurture. I am calling on y'all to just please go into practice of your faith and beliefs of investing toward others and loving thy neighbors, as said. And let's process and look inwards first by being proactive than reactive, and vote no on SGR 44. Thank you.
Thank you, ma'am, for being here. Jaslet, Griffin, Lee, I think I called your name earlier and you chose not to. Griffin Lee? Yes. You pass. Okay, thank you. Anyone else present would like to testify? Come forward. Did you fill out a card?
Yeah.
Excuse me, Senator. The first one I filled out, I put two on it, and I put
No
SJ.
problem. We'll straighten that out when you get there. Go ahead and state your name and who you represent.
Thank you so much for your time. My name is Saba Blanding, and I'm from Houston, and I'm speaking for myself against SJR 44. I don't need to reiterate what's already been said or waste anyone's time. I just encourage everyone to consider what actually will help prevent these injustices. Is that okay?
No, it's just telling us to come to work.
Okay.
But we're already working.
It's not a fire drill.
We're covered right here. We're going to finish up here in a minute.
Okay. Well, I just wanted to read something from the CDC. I appreciate y'all bringing up domestic violence, but the truth is what's going to help is not to compromise constitutional rights, but violence interruption efforts. The CDC says all forms of intimate partner violence are preventable. Strategies to promote healthy, respectful, and nonviolent relationships are an important part of prevention. So there's a lot of violence interruption programs that actually stops it at the source, and it doesn't compromise constitutional rights. Thank you so much for your time.
No, thank you for being here. Megan Lavoie is a resource witness, Office of Court Administration. Aaron Johnson is neutral. You want to testify? Come down and you got 1 minute.
Aaron Johnson, Texas Association of Pretrial Services. Again, I want to bring up one item that really just continues to come up, and that is Harris County is not the representative for the entire state.
Thank God.
So the things that are
Probably
occurring
good
in
news.
Harris
It's probably
County
good
that
news.
people have issues with, that is not what is happening in the rest of the state. I want to state that first. And I have 3 examples of where I think this, I don't have an issue with the proposal because it follows basically federal law.
Then let us vote on it then, will you?
However, there are 3 examples, very distinct examples of current law where things are subjective and are not being done. And I have data to support those things. One is CCP 1406. That is where the law enforcement have the ability, they may, to give out citations in lieu of arresting individuals. That would be a 30% decrease in the amount of people coming to jail. To my knowledge, the counties that I work with, that law has been on the book for 30 years. They've had 0 cite and release, okay? 1622, 17032, the mental health bond process. According to OCA stats, there are many counties that have not issued a personal bond.
I don't understand how that's possible if 17032 was designed to give people personal bond that are presenting mental health issues that are in custody. Third, with the PSRS, we know, we talk about this part of the legislation where it's supposed to be letting people out on the least restrictive means. Personal bond and pretrial services, that is least restricted. However, out of the 50% of the eligible charges, the state of Texas gives personal bond less than 11% of the time.
Okay. Thank you for being here.
Thank you.
Ken Good. With the professional bail bonds neutral. Ashley Fernandez Dorsanio. You have a short minute.
Members of the committee, my name is Ashley Fernandez Dorsanio, and I'm with the Texas Civil Rights Project. And I here in opposition to Senate Joint Resolution 44. I'd like to begin by highlighting that pretrial detention is not meant to be part of the punishment. Rather, pretrial detention is only intended to ensure that individuals will not willfully flee persecution or commit a serious crime, as some of my colleagues have said. Justice is rooted in the idea that people are innocent until proven guilty. Now, currently, Section 11A of the Constitution permits a judge to deny bail to individuals who have previously been convicted of a crime or previously violated a condition of the release or protective order. But I believe that the current proposed resolution goes a step too far by allowing someone who has been accused for the first time of a crime to be denied bail. I just would like to say that these are not criminals. These are people accused of a crime for the first time. And so this resolution cannot be justified as keeping allegedly repeat offenders off the street.
Very good. Thank you, ma'am. Anyone else present wants to testify for or against Senate Joint Resolution 44? If not, public testimony is closed. Senator Huffman moves the Senate Joint Resolution 44 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmire.
Yes.
Flores.
Aye.
Hinojosa.
Aye.
Huffman.
Aye.
Betancourt.
Aye.
Miles. King.
Aye.
6-0.
Six ayes, no nays. Senate Joint Resolution 44 is reported back to full Senate with a favorable recommendation. And we stand recessed about 30 minutes after.
Chairman, could you recognize that?
Sure. Is any objections, Senator Betancourt being shown voting aye on Senate Bill 402 and Senate Bill 1004? Chair hears no objection. Let's try to get back around 1:30 about watching the action on the floor, but shoot for 1:30. But if it goes longer, it'll be 30 minutes after the session ends. Thank you all. Well, criminal justice come to order. First, let me comment. We have a stack of cards that want to be shown on the record for the morning SJR 44. So later this in this meeting, the clerk will read them into the record. At this time, I would lay out Senate Bill 1318, recognize its author, Senator Huffman.
Thank you. Thank you, members. Mr. Chairman. Members, in 2021, the legislature passed Senate Bill 6, addressing the release practices surrounding habitual and violent offenders, which aims to better protect the safety of victims, law enforcement, and our communities. SB 6 represented one of the largest overhauls to Texas bail system, drastically increasing the amount of information available to judges when setting bail and enabling statewide data to be tracked on bail outcomes. According to testimony from the Harris County DA's office this past interim, following the passage of SB 6, Harris County was projecting around a 10% decrease in offenders charged with new crimes while out on bond. And I think we heard testimony this morning from others, including First Assistant Mitchum, about the impact that SB 6 has had actually on the bail system. So it is working, but we are, with any large piece of legislation that makes radical changes throughout the state, we understand that many times there needs to be some tweaks to the bills as we move forward, and we have the opportunity to have some hindsight. So we know that according to OCA, over 45,000 bail forms from judges and magistrates across the state have been submitted documenting bail decisions. And so now we're going to look at some of the changes that we intend to incorporate into the bill. Senate Bill 1318 includes several different policies to further strengthen the bail system. First, it requires hearing officers to make oral or written findings of fact and conclusion of law on the record at the time they issue a no probable cause finding. That came to me through the Harris County DA's office, where there was some reports of judges just stating no probable cause over and over again, and which led to the release of individuals with no clear guidance towards either prosecutors or police about what that finding was based on. So this will be clarify information for both the defense and the prosecution. To improve efficiency, the bill requires the Office of Court Administration to offer counties the option to integrate their jail records management system and case management system with the public safety report system at no charge to the county. Working closely with OCA to ensure that counties have the resources necessary to efficiently implement the provisions of this bill, and I will fully committed to funding this measure. So there will be funding specifically tied to this implementation. So for some of the rural counties that we've heard from and other counties who are struggling to connect that piece, the state will make sure that you get the funding you need so that you can fulfill the requirements under the legislation. SB 1318 enables judges to use the public safety report system when making bail decisions without a defendant being in custody. So there are times when a judge is considering bail before there's been an actual arrest, and there have been some confusion about the ability to use the system, but you will be able to. For a secondary offense committed in a different county, the bill clarifies timelines for the notification of a new offense requirement to be given within the next business day. The bill mandates that the presiding judge, rather than a criminal law hearing officer, be the proper authority for setting the initial bond for a defendant on parole at the time he or she is charged with a new offense, a defendant who has been previously convicted of 2 or more felony offenses, and a defendant charged with certain violent felony offenses. And those are going to be murder, capital murder, aggravated kidnapping, aggravated assault, aggravated sexual assault, and defendants charged with felonies who are also detained with concurrent immigration hold. Furthermore, it requires each county to identify a single point of contact for the purposes of receiving electronic notices when a secondary offense is committed in another county. Again, this just tries to make the bill more seamless when you have county-to-county arrest. The person, and under that, the person would be responsible for notifying the appropriate judicial officer along with the prosecutor from the defendant's original case. To build on SB 6, the bill amends the list of offenses that a defendant may not be released on a personal bond, adding unlawful possession of a firearm by a felon. I wish Ms. Aguirre was here, who had testified so passionately this morning, and so that will be added. Violation of family violence protective order and terroristic threat, manufacturing or delivery of fentanyl, and violation of a bond condition, which is an offense which we have created under this bill. Subsequently, the bill establishes a new criminal offense for the violation of a bond condition. The penalty level for violation of a bond condition would depend on the original offense in the presence of a firearm. Currently, outside of a small number of conditions, violating a bond condition is only a technical violation of parole or bail. This means a peace officer cannot detain a person who is clearly violating a condition of their release, even if they may pose a public safety risk. And we will continue to work on this section to make sure that we're hitting the right notes on this. But we know that if there continues to be no teeth to the penalties for a violation of conditions of release, these conditions will continue to be disregarded by offenders, and time is, history has shown this to us. All the stories that we have seen over and over again from victims proves this. 13, this bill establishes a bond for a jailable felony offense that may not be set until the defendant has gone before a hearing officer or judge, so no general order bonds. It creates a new avenue for appeal when a prosecutor considers the bail amount insufficient to preserve public safety for a defendant charged with a felony and has previously been granted bail for a felony offense. Lastly, the bill amends Harris County's bail hiring board to create more transparency surrounding the board's meetings and decision-making process. The bill changes oversight of the board from the Harris County Commissioners Court to the presiding judge for the Administrative Judicial Region. It requires hearing officers to be reappointed following completion of their one-year term, rather than allowing them to continue to serve until a successor is appointed. Finally, the bill includes the hiring board under the definition of governmental body, making it privy to the Open Records and Open Meetings Act. Early feedback since passage of SB 6 in 2021 has shown improvements in the bail system to ensure judges have pertinent information to make informed bail decisions, but more work must be done. There are still too many repeat violent offenders terrorizing our communities that are being released on low-level bonds. And so everyone is aware. I do intend, with the chairman's permission, to leave this bill pending today. I do want to hear feedback from interested parties. My goal is to make this a really good bill. Not everybody's going to agree with it. I get it. But a good bill that works. We want this to work. This is all about everything you've heard today. We want to keep violent offenders, repeat violent offenders off the street and quit terrorizing these families. Haven't y'all all heard enough of this? And so my goal is, let's fix it. I want to hear what you have to say. I'll do my best to accommodate your concerns, and I welcome your feedback. Thank you.
Thank you, Senator Huffman. Any questions? Megan Lavoie, Office of the Court Administration, is a resource witness. Did you want to testify? Yeah, you can come down front. State your name and who you represent.
Good afternoon, Chairman Whitmire, Senator Huffman, and Senators. My name is Megan Lavoie. I'm the Administrative Director for the Office of Court Administration, testifying as a resource today on this bill. As you know, OCA was instructed to implement Senate Bill 6 and the Public Safety Report System starting in April of last year. The Public Safety Report System, as you know, serves two purposes. It does provide additional information for judges on a defendant, including their criminal history and a summary of their criminal history, as well as whether the defendant is eligible for a personal bond and if they've been charged with a violent offense. It also serves as a reporting mechanism to report bail decisions to the state level. I just checked right now, and we have nearly 460,000 bail forms on our website that are available to the public. We're currently working with a data contractor to look at all that data and create a dashboard on our website so it can be more easily accessible to the public and policymakers as well. So I was asked.
Excuse me if you interrupt. The 400 and some odd thousand forms? What do you mean by that?
Bail forms. So part of Senate Bill
Where
6.
People are out on bond.
Yes, so it captures all the bail decisions that are being made by magistrates and judges across the state. So it has the defendant's name, what they were charged with, what the bond amount was, whether it was a personal bond or a cash surety bond, and also the judge.
Active cases.
Active cases. Since April 1st of last year.
You are collecting a bunch of forms.
Yeah, there are. You can go and
They've been filled out. They've been filled.
We're trying. There's so many on there that it actually is slowing down the system. And so working to try to speed it up because you have to wait a couple of seconds for them all to load because there are so many on there right now. So I was asked to just go over some of the changes that specifically impact the public safety report system. You've heard Senator Huffman talk about integration. That was one of the biggest concerns that we heard right off the bat from counties is that they wanted the system to be able to integrate with their jail systems and case management systems because there was a lot of duplicate effort in data entry and entering bond conditions because bond conditions are also required to be in the public safety report system. We did release the API from our side and did a change order with our vendor, so that is available for counties right now to capture, but there does have to be changes at the local level and there is a cost to that, and we did submit a fiscal note on what we estimate that cost to be. The other big piece of change to the system would be supplying electronic notice to somebody that is designated by the county to receive that notice when somebody is out on felony bond and commits another felony. We think this is going to be a game changer for the system. We have actually seen this up close in Operation Lone Star when somebody is arrested, goes through Central Magistration, Operation Lone Star, and then a couple weeks later is rearrested and comes through the process again. And when it shows up on their criminal history, the case hasn't been indicted yet and information hasn't been filed yet. And so if there's an electronic notice that happens through the public safety report system, through a specific contact that's entered into the system, we believe prosecutors and judges will now have information that they previously did not have access to. And so we do think that that is a great change. The other that Senator Huffman did mention was allowing judges to use the public safety report system to make better informed decisions when they're setting warrants. Currently, the system isn't set up to do that, but we believe it can be configured to do that, and that will be very helpful for judges as well. Lots of other provisions in this bill, and happy to answer any questions, and I look forward to working with your office as this moves through the process.
Senator Miles.
Thank you, Mr. Chairman. Chairman Huffman, I know Harris County needs bail reform, and we need bail reform now. And the principles of this bill, I support 100%. I've got some concerns, and I don't know if I'm asking this young lady or if I'm going to get an answer from you. And I've discussed them with the chairman.
And we may need Mr. Mitchum from the DA's office, who may help us too, if necessary, because he can answer questions too.
Okay. So do you want me to wait for him as well? Is that what you're saying? Or?
I don't know what your questions are.
Let me
Pose it, and then we'll find the right
and
answer.
I won't be long, I assure you. Right now, Madam Chair, ma'am, the local judges make the decision. Is that correct? For the most part?
When you say local judges, are you talking about the elected judges?
Yes.
Not always. And Mr. Mitchum, do you mind if Mr. Mitchum steps up, Mr. Chairman?
No, I welcome it.
Oh, yeah.
You mean make the decision on setting the bonds or appointing the magistrate?
She and I are on the same page. Yes, sir.
Yeah.
No, many times it's pushed off to the magistrates, yes.
Okay.
Yeah.
It's my understanding, and please correct me if I'm wrong, David. Yeah. Yes, Senator. Yeah.
Have a seat.
Come on, have a seat and identify yourself.
We're capturing that in the system. So about 26% of bail decisions that are in our system are made by magistrates, which are
That's
not the
statewide,
elected
though.
judge. That's
When
statewide.
you get to Harris County, it's going to be the magistrates.
And we can look in the system and provide that specific data to you.
So statewide, magistrates are making the decisions.
26%.
26%.
Are done by magistrates.
And where is Harris County falling in that 26? In or out?
I would say they would fall in that 20%.
In that 20% that are making the decision.
Maybe Mr. Mitchum can.
I don't know the exact percentage, but I believe that it would be
Sure, we gotta
substantially
know where
higher
Harris
than.
County is. Are they in or out of that 20%?
Well, they're above the 20%.
They're inclusive of that 20%?
I believe so, yes.
All right. So magistrates are making it now. Is it a problem with the magistrates making it? Do you, in the author of the bill, do you see a problem with the magistrates making it?
I do.
You do?
You're asking my opinion?
Yeah.
Did I
And
say
is that the
I
same?
do as well. I
Okay.
do as well.
And you as well?
Well, because.
With the magistrates without interference from other entities.
So Senator Miles, the magistrates will decide who's eligible for a PI bond, the amount, and the challenge for us is how do you hold them accountable? First of all, we don't know how they're selected, their backgrounds, and often even who they are. So if it's a good magistrate, we need to say that's a good magistrate. But when they're making these poor decisions, which concerns a number of us, how did they get chosen?
Well,
And
I'm
if you think
concerned.
they have a series of bad decisions, how do you hold them accountable? Because the judges are elected, but they've passed that responsibility to the magistrates, and then they duck when you want to deal with
I guess
the
my
magistrates.
concern is if 26% of the state is only a small percentage, is not the majority, and we're going to take this in a different direction as a minority, we're going to take this in a different direction, then I see a bigger problem.
But can I address why it's so low statewide? Because in the rural areas, you have a district judge that handles it.
Okay.
Or a county court, or even the JP we heard from.
And
this
that's
morning.
understandable.
It's only in the Harris County model where judges used to do it, JPs could do it, but in recent years, they've delegated it. And we used to actually, before we did some reforms a couple years ago, they would have a schedule, and the judges would give the magistrate armed robbery, this is what you'll set as a bond. So there was not much deliberation, but I personally, responding to my constituents, want to know who are the magistrates. There's no transparency. We already heard from the defense bar this morning, they're not allowed to speak. So we're trying to open up.
And I appreciate that history lesson, but I guess where I'm going with this, off of the bill, and Mr. Chairman,
Sure.
is we're going to let a minority dictate and change part of the state rule, and we're taking away local control. Because does this bill not give the governor the power? Am I reading this right?
This doesn't give.
The governor's going to start making the decisions?
No, the
Maybe
governor's-
I'm reading it wrong.
I don't see the governor giving any power. I mean, we're still saying you can use magistrates for certain enumerated offenses. The presiding judge, the elected judge, has to make the decision. And it's, if you look at it, it's for someone who's on parole, those who have.
I'm supportive of all that.
Okay, so,
I'm
and then
supportive
it
of all
says
that.
we're making the.
Let me be on the record. I'm supportive of all that.
So you could still have magistrates in other offenses, but we're making it more transparent at how we appoint magistrates and what process. So I guess your concern is because the administrative judge is a governor appointee, that you give it to the governor.
That's my concern.
Well, that's kind of a convoluted, I understand what you're saying, but again, it's going to have to be very transparent about how it's done.
Thank you for clarifying what my concern is.
Yeah, no, I understand when you put it that way. I just was trying to follow you. Everything, we're making it open to open meetings and open government, so, you could file an open records request for records about how it was conducted. Everything has to be done in an open meeting. I mean, it's just, there's this veil of secrecy now about how it happens, and this was brought to my attention by, testimony through the interim. I mean, they brought this to my attention. That was the problem. I didn't even know it was going on.
Madam Chair,
I keep finding out things that's going on there that nobody knows.
I prefaced this conversation with Harris County needs bail reform. We need it now. I'm for bail reform. I support everything that's in this bill.
And this only applies to Harris County.
I just have some concerns.
Okay.
That in Harris County alone, we're going to be giving the directions and instructions and appointees from the governor. That gives me a little heartburn and no concern. Thank you, Mr. Chairman.
And I will support the legislation, is using your words, that it's a broken system. The status quo is not working. It's not serving the public, it's not serving the defendants, it's not serving the bar. So in search of a solution, we're trying to make it as transparent as possible and as fair as possible.
But I don't know if I'm quite concerned. I don't know if we're quite jumping in the fish grease and getting in the chicken grease.
As I said, I welcome ideas. I welcome ideas. If you can find a way to make it transparent, you have magistrates who are qualified, everybody knows who they are, everyone knows how they were selected, everybody knows their background, everybody knows what the rules are, then
Madam Chair,
bring your ideas to me.
Madam Chair, thank you for bringing this bill forward.
And
I look forward to working with you on making those changes.
Yeah, and it's a work in process.
That's right.
Grass. But let me just tell you another concern that I know you will share. No, but I want to say it publicly. Yeah, okay, I'll talk to Huffman if you want me to. But the bottom line is they're abusive often to the defendants. So I'm trying to hold them accountable when they look at someone and say, if you say yeah one more time, I'm gonna double your bond. The scared person, defendant, says yeah again to the judge, and he doubles the bond right there on the spot.
Chairman, I get it.
That's what I'm trying to clean up.
Chairman, I get it.
Yes, sir. Senator King.
Thank you, Chairman.
Yes, go right ahead.
So, and this is really a little bit outside the bill, but I'm trying to kind of remind myself how it works, so just more background. So I'm a JP or a municipal judge in Brownwood, and the morning I come in, and I'm going to do the magistrate's warnings on everybody that was arrested the night before, and there's 10 or 12 people there. What information besides the probable cause affidavit is going to be in front of me?
They should have the public safety report that the public safety report system produces, which has a summary of their criminal history. It has whether or not they're eligible for a personal bond. It has whether or not they're charged with a violent offense. And then it will have a list of discretionary and mandatory bond conditions that the magistrate will then fill out.
So who put that together during the night?
It depends on each jurisdiction. It's whether sometimes it's the jail staff, sometimes it's a clerk, sometimes it's the magistrate themselves that has to run it. It just depends on what resources they have.
Okay. And what data do they pull down to do that? What are the data sources that kind of pull that together?
So it accesses DPS's TCIC to pull the criminal history. So they have a login. They have to enter the defendant's SID number. If they don't have that, then they enter the defendant's name and date of birth, and that's how they pull that information. And so that's part of the integration process, is being able to integrate with those jail systems so that they only enter it into one system, and then it will populate the public safety report.
Okay. And is that pretty robust and working well, and all the information's getting in there so that it's there when they go to pull it down?
So far, we only have one jurisdiction that has integrated because they took it upon them. They have their own case management system. It's actually Garland. And as far as I know, it's working well for them. And so we're hoping to get more jurisdictions to be integrated once they have the funding to do that.
So if they aren't, will this bill provide the funding for that, or is that?
Yes.
Okay.
We did submit a fiscal note for
All right.
it.
And so by the time they get to arraignment, it's a whole different game because all the information they've had time to do, all kind of gathering, and they've got a much more thorough thing to present to the judge at that time.
That's correct.
Okay. And I'm sorry, I hadn't thought about this in 2 years. So we don't have any type of so for that county, it's unless the counties put it in place or by agreement or however they would do it, there's no standardized amounts for bail for different offenses. So it's totally open to that justice of the peace or municipal judge or whoever, county judge, whoever's setting the bail. Is that right?
Yeah, we haven't mandated anything on amounts.
But there are some counties that still have, they do have bond schedules, but it just has to conform with Senate Bill 6 and be constitutional.
But for the most part today, what the magistrate's got in front of them is after the initial arrest is pretty much the TCIC, NCIC records and the probable cause affidavit that the officer filled out and just whatever else they might have local, correct?
That's right.
Okay, thank you.
Any other questions? That's fine. David, you have some comments? State your name and who you represent.
Thank you, Senator. My name is David Mitchum. I'm here speaking on behalf of the Harris County District Attorney Kim Ogg and the dedicated members of the Harris County District Attorney's Office, and we are in full support of the enactment of Senate Bill 1318. This proposed bail reform legislation would, in our opinion, provide welcome relief and protection to the law-abiding people of Harris County. Given the limitations of time that the committee labors under during the session, I'd like to take this opportunity to briefly point out certain sections of the bill that would be particularly useful and helpful to reestablish a just and balanced approach to the setting of bail in Harris County. And then to conclude with a short report to the committee of a recent criminal case in Harris County that illustrates the gravity of the problem and epitomizes how some of our judges in Harris County have simply lost their way in the ongoing controversy surrounding the setting of bail and preservation of public safety. While Senate Bill 1318 proposes many positive changes in the state law, several sections of the bill would have a particular resonance for Harris County. Among these pertinent proposals are the requirement that hearing officers make oral or written findings of fact and conclusions of law on the record whenever they issue a no probable determination when presented with a criminal complaint. Presently, hearing officers, and that's what we call the magistrates in Harris County as hearing officers, in Harris County often find no probable cause to a criminal complaint with no information or explanation provided as to why the hearing officer made such a finding. This proposed requirement of an explanation would provide law enforcement and prosecutors with some direction toward correcting the problem with a criminal complaint if such a correction is possible. The mandate in the bill that specifies that the elected presiding judge, rather than the appointed hearing officer, is the proper authority to set the initial bond in a case where the defendant is on parole or is a habitual criminal or is charged with violent felony offenses or is on an immigration detainer would be a welcome improvement. The bill amends and clarifies the law that the defendant may not be released on personal bond for the manufacture or delivery of a Group 1B controlled substance such as fentanyl under the Health and Safety Code, terroristic threat, violation of family violent court orders, violation of bond conditions, and the unlawful possession of firearms. Further, no personal bond may be issued for a defendant while out on bail or community supervision probation for an offense involving violence, including any offense punishable as a felony, assault, deadly conduct, or disorderly conduct involving a firearm. The bill also establishes a new criminal offense for the violation of bond conditions. All these proposed changes in the law would make Harris County, Texas, a safer place to live, and God knows we need to have more safety in Harris County, Senator. Additionally, the bill provides for the needed systemic check and balance in the appointment of hearing officers by requiring that the regional administrative judge approve all future hearing officer appointments in addition to the present statutory arrangement whereby the sole authority to appoint hearing officers rests entirely with a 3-vote majority on Commissioners Court. There is a 9-judge panel, 3 JPs, 3 county court judges, and 3 district court judges that interview the hearing officers for appointment, but they are a creature of Commissioners Court. In Harris County, this change in the law would be especially helpful as our regional administrative judge, a former criminal district court judge of long standing, has an extensive professional background in criminal jurisprudence. Further and very importantly, under Section 11 of the bill, there is created a new avenue for appeal by the state prosecutor when the court sets an insufficient bond for the defendant charged with a felony when the defendant is already out on bond at the time the new crime is committed. This part of the bill would be a great step forward in providing the public safety in Harris County from the very real and present danger of repeat violent offenders on multiple successive felony bail bonds. Finally, to show the committee the depth of the public safety issue associated with the setting of felony bond in Harris County and the apparent defiance demonstrated by some among our local judges to oppose and stymie the efforts of the legislature to address this problem, I would draw the committee's attention to a recent case in Harris County. In this episode, the defendant was charged with aggravated kidnapping and felony assault of a family member by impeding the breath of the victim. The defendant in this case is a habitual criminal with a long history of violent criminal convictions, including 2 separate and successive prison sentences for burglary of a habitation and robbery, as well as 6 other felony convictions, with a criminal career spanning over 20 years. The defendant in this case is accused of holding the victim, a woman he briefly dated, hostage in her own car for approximately 3 days and periodically choking her until she became unconscious. The facts and circumstances of this case were so horrendous and egregious that on December 28, 2022, the hearing officer at the probable cause hearing set the initial bonds at $45,000 for the aggravated kidnapping charge and $15,000 for the felony assault. When the case was moved before the presiding judge in the district court on January 10, 2023, the judge, in his wisdom, lowered the 2 bonds to $1,000 each. Later, at the arraignment proceeding, after hearing from the victim who advised the court that she feared for her life as she believed the defendant would kill her if he was released, the judge reduced the bail to $1 for each of the felony charges. In his bail order, filed on January 11th, the judge included the following statement, verbatim. The defendant is unable to post any amount of bail and is currently being held solely because of his inability to access funds. Senate Bill 6 prohibits a personal bond in this case and further limits who can post bond on behalf of the defendant. Bail is being reduced in accordance with the Texas Constitution's prohibition against excessive bail based on an individual analysis of this case. GPS with house arrest added as a condition of release with GPS monitor to be installed prior to the release of jail, prior to the defendant's release from jail. Unfortunately, on January 17th, 2023, while the defendant was out on two $1 bonds for two violent felonies, the victim reported that she and her mother were out driving in their car, stopped in traffic, when the defendant approached the victim's vehicle, brandished a firearm, and threatened to get her in an apparent retaliation for outcrying to the authorities in the first place. This threatening conduct by the defendant was in violation of multiple bond conditions, and he was subsequently rearrested and taken into custody on two additional felony charges, violation of protective order and retaliation, and he's presently in the Harris County Jail awaiting the trial of his several cases. The setting of a $1 bond in the two initial felony cases and the judge's apparent documented displeasure with Senate Bill 6, which restricted the court from authorizing personal bonds for the 8-time convicted felon, demonstrates the depth of the bail problem in Harris County. When the local media in Harris County reported about this case, another sitting district court judge in Harris County publicly defended the judge's decision to set a $1 bond in these cases and reported to the general public that $1 bonds in felony cases are not unusual and in fact commonplace in Harris County. The enactment of Senate Bill 1318 would enable the prosecutors in a case such as the one described above to appeal the court's $1 felony bond decision to a higher judicial authority. Under present law, there is no such practical avenue of appeal. The frustration that my prosecutors feel in these matters is palpable when there's really nothing we can do once a judge sets a bond which we feel like is utterly insufficient, and we have no place to go other than to try to convince the judge to put conditions on the bond. The Harris County District Attorney's Office strongly supports and urges the enactment of Senate Bill 1318 into the laws of the great state of Texas. Respectfully submitted.
Thank you, David. Any questions? If not, thank you.
Thank you, Senator.
Yeah, thank you. Sally Backo, Director of Policy for Galveston. For the record, you state your name and who you represent.
Good afternoon, Mr. Chairman, members of the committee. My name is Sally Bacco. I'm the Director of Policy and Governmental Relations, and I'm here to express the City of Galveston's strong support for SB 1318. Galveston is a community of 53,000 people, but we host 7 million tourists a year. We're home to the fourth busiest cruise line port in the nation. On behalf of the city, I wanted to talk to you about our experience stemming from tragic circumstances resulting from driving while intoxicated repeat offenders. Over a 4-week period on Galveston Island at the end of the 2022 summer season, 3 separate drunk driving incidents resulted in the deaths of 6 people, including 2 teenagers and 2 children. In one case, the driver had 3 previous DWI convictions in 2016, 18, and 21. The driver in this case, having served less than a year of his 3-year sentence, was released from prison for the 3rd charge hours before that crash. In one case, the man accused of killing 4 people in August was placed back in jail when he was pulled over again in February by Rosenberg police, who suspected he was out of compliance with court-ordered bond conditions. The man was taken into custody after officers found him operating a vehicle with an invalid license and without the court-ordered interlock device, which won't allow drivers to start a vehicle if they have a high blood alcohol content. In response to these tragic events, the Galveston Police Department formed a DWI task force, which has arrested numerous drunk drivers. However, police enforcement of criminal laws is frustrated when perpetrators are quickly given bond with few restrictions and given the opportunity to reoffend. The City of Galveston urges the committee to favorably act on SB 1318 as an important step towards strengthening state laws, including bail and bond reforms, and even restricted parole that can provide useful tools that meaningfully dissuade driving while intoxicated or under the influence of substance abuse, controlled substances. Thank you very much.
J.R. Woolley? Judge Woolley. State your name, please.
Yes, sir.
Who you represent.
Good afternoon, Chairman, Senators. I'm J.R. Woolley. I'm the Precinct 2 Justice of the Peace from Waller County, and I'm the Legislative Chair for the Justice, Peace, and Constables Association. I come to you, I have Morning Road on my paper here, Chairman, but I come to you this afternoon in support of Senate Bill 1318. But we would like to see some changes, and I'm going to discuss those with you in order for our offices to remain compliant with the bill. Last session, Senate Bill 6, and it's already been mentioned, made some great changes to bail reform, or to bail in Texas, and it definitely made Texas safer. This bill provides some additional measures in that process, and one of them, the API integration, the financial piece. Chair Huffman, I appreciate that. That's huge. But there's a few other things and some things that we have concerns about. The first section that was just mentioned that we have some concerns about is the finding of no probable cause and the subsequent requirements of that finding. Senator Miles said there's a lot of discussion about Harris County, but there's 253 other counties. And a lot of those other counties, the JPs do the magistrations. We are not courts of record. And this has in here that it needs to be on the record. Well, if we're not a court of record, what record are we putting it on?
You could do a written statement,
Okay.
and we can clarify that.
The second part of that is when we say why we didn't find probable cause, we're taking our neutrality out of it. You know, our job is to call balls and strikes, and if we go past that, then we're playing third base coach and not just the umpire. I'll give you the example of if I find no probable cause on someone for an assault offense, but they did not put in the PC that the person mentioned it caused pain or there was an injury, there's no probable cause. It's a Class C, not a Class A. And then if I then tell them, you didn't say anything about it causing this person pain, somewhat becoming an agent of the state and telling them where to go with what charges to file, and then when it comes back to me and it says pain, is that what the information they really got, or is that?
You help them clean up their case.
Correct, which I think is improper for us to do as a magistrate.
Sorry. No, I just.
Go ahead.
I'll let you
We're
test it.
listening to you.
The second part is the notification piece, which I'm in Waller County next to Harris County. You can imagine how much fun my clerks have when I got to notify a magistrate in Harris County on a subsequent felony arrest. It takes them a little while to figure out exactly where it goes. So this is a perfect fix to that. We've had some conversations with stakeholders there trying to figure out how to make that work best. And I look forward to continuing those conversations to make it, just like you said, Chairman, the best bill it can be. So that's our second concern. And then our last concern is about the hearing officers. And Senator Miles, kind of like you were saying, most of the places JPs do your magistrations. I'm probably the only one talking to you today who's actually magistrating. The other counties under Chapter 54 that have hearing officers have those hearing officers for a reason. And it's because the justices of the peace in those counties are busy. The other judges are busy. So they've come to the legislature and asked for hearing officers to lighten the load. And I know that these are specific, but that's one of the concerns we have as an association is we have judges who were too busy to do it before, and now they're going to get put back on there with required to hear those cases again, that the hearing officer were filed for, or got for.
Maybe they have to work a little harder.
Yeah, it's just specific cases.
Right, and
It's very, very serious of the most serious of, habitual
I-
offenders. You shouldn't have,
It's a very-
most of the rural counties are going to have,
Yeah.
one
And it's
or
a very
two of
small,
those a
very
year,
small concern of
probably.
ours.
Yeah.
Well, those counties, the rural counties don't have it. So it's your Bell counties, your kind of those mid-sized counties that have those officers in place, and it's a small concern of ours.
Yeah.
That we honestly haven't vetted out to a lot of those counties to see what theirs is. This was an internal thing with us. So, but this bill does present real solutions to real problems, and it is maybe with some fine tuning, which I think that we've discussed that could be done. This will make our bail system and the processes implemented by Senate Bill 6 last session even better to protect the citizens of the state of Texas.
Okay.
Thank you.
Thank you, Judge. Jennifer Thorpe. O'Malley County Criminal District Attorney. State your name, please.
Good afternoon. My name is Jennifer Tharp. I'm the Criminal District Attorney for Comal County, and I'm testifying in support of SB 1318. Just echoing a little bit about what I talked about this morning, I think this is good legislation. It goes to increasing safety, transparency, and accountability. A couple things quickly I'd like to highlight. Thank you for adding the unlawful possession of a firearm by a felon. That was something I testified on in the interim. Especially after the lady from Galveston talked, I do think intoxication manslaughter should probably also be potentially included in the type of offense that a PR bond is not appropriate for. As to the appellate remedy, I hear what the judge said. At the same time, if it's not a court of record, for an appellate remedy to have any meaning, you're going to have a basis on why that bail decision was made. So for the state to have the opportunity to appeal that decision, if the state felt that it was wrong, there needs to be a basis on what that judge's decision was made. And so the way I read the bill, it could be a written order. It doesn't have to be a court transcribed proceeding. I think that also is another good piece, and it gets to a lot of the concern, which is transparency and accountability for the judges who are making those bail decisions. So that appellate remedy, that's a review by yet more judges who are elected as to the appropriateness of the amount set. Finally, I wanted to touch on quickly the violations of bond condition offense. I think that also is very important and necessary. Some feedback that I've given to your office deals with the level of offense.
Right.
And so I think there could be some tweaking. My recommendation is to look to 3605, which is tampering with a witness. It originally was one level of offense, and then it became to mirror the level of offense. So if you're tampering with a witness on a murder offense, but to tamper with that victim is a lower level offense than to actually be prosecuted for the murder, doesn't make much sense. Other suggestion could also look to 3605E1, dealing with the firearm enhancement language to kind of fix that. I'd also ask that you consider, I believe the term is in peri materi, which allows prosecution for the violation of the bond condition, but if it also is some other criminal offense, that prosecutor is not barred from either picking one or the other. And there's several other statutes that you can look at that language. And then finally, which I think is really important because we've heard so much testimony about how dangerous it is when individuals are released on bond and violate bond conditions. So for law enforcement, the devil is in the detail in terms of knowing from law enforcement what the bond conditions are that have been ordered. So we'll tell you right now there's different rules on the timing of when information goes into TCIC. So SB 6 addressed with the violent offenses where I think it requires law enforcement to put it in within 3 business days. For the rest of your bond conditions, they have 10 business days. So there might be some benefit in shoring up that timing period. So there's not confusion from the clerks that work for the judges as well as for law enforcement how quickly to put that into TCIC. Overall, thank you. Thank you for all your hard work. Thank you for the opportunity to testify. I'm happy to answer any questions, and I really appreciate all your time on this.
Senator King.
And again, Chairman, thank you. It's just background for me because I just need the background. So as prosecutor, if a judge issued an inappropriate bond or bail amount or doesn't have conditions on there that they should have, and you become aware of that, what action can you take?
I can speak to that right now. I do it on a regular basis. I file a motion for bond increase and for conditions to be put in place. Most often, they've already been released from jail. I will tell you the tricky aspect for me is if they don't have an attorney appointed, we literally have to go find an officer to serve that defendant with my motion and my hearing date to then get them to court. I also will
You're
ask.
usually not going to have an attorney till far down the line.
It just depends. Some people do. Some people, if they're able to quickly bond out, don't follow through with hiring an attorney or get the attorney actually appointed to them. So there is a ton of benefit with this. I will tell you with some of our bond hearings, I can file a motion to increase that bond, and they can be violating that bond by picking up new offenses before I can even get them into court. So I think there is a lot of smart legislation in this bill, which I wholeheartedly support.
And if they're out there and you just become aware because somebody calls and says, hey, they one of the bond conditions were they weren't supposed to come around me or weren't supposed to go to a bar or whatever it is, and you just become aware that they did and there hadn't been a police report or something like that, can you still file a similar motion?
I can still file a motion and then ask for a hearing, but then I have to serve my motion on the defendant and get that defendant into court for the judge to make a decision on it. Now, a judge can sua sponte find a bond insufficient, and some judges do, some judges don't.
So if you're in between the magistrate's warning and an arraignment before you, if it hadn't got to the court, do you file that with the original magistrate that set their bail and
I do.
bond conditions?
I do.
Okay, so that could be a JP or
We have
judge or anybody?
We have one full-time magistrate. We have, I think, 2 or 3 part-time magistrates, and they do the majority of our bond setting unless an officer goes directly to a judge for an arrest warrant. But by large part, it's magistrates, either the one full-time or the part-times.
But do you have to file? I guess that's who's got possession of the case at that time if it hadn't been referred, if it hadn't got to.
If it hasn't been filed,
You got to go back there. Okay.
Yes.
Thank you. Thank you, Chairman.
Yes, sir. Thank you, ma'am.
thank you. Thank you, Joe.
Andy Kahn.
Good afternoon. I'm Andy Kahn, Director of Victim Services, Crime Stoppers of Houston. We started noticing a trend in Harris County, and that had to do with the instance of granting PR bonds to defendants charged with felon in possession of a weapon, a gun. Now, obviously, everyone is cognizant of the issue surrounding gun violence in this state. But this is one issue that no one seems to really want to discuss until Senate Bill 1318, and that is the issue of repeatedly releasing known felons charged with felon in possession of a weapon, a gun, right back to the community. I brought this little file because I couldn't carry 2 binders, because I'm documenting about 30 to 40, in some cases even 50 cases a month that are being given PR bonds for felon in possession of a weapon. I've also documented over a dozen cases of defendants charged with possession of a prohibited weapon, that is, a machine gun, granted a PR bond. One of them was on bond from Brazos County for stealing catalytic converters. So he was on bond from Brazos County, then he was charged with possession of a prohibited weapon in Harris County, that is a machine gun, and yet was given a PR bond. He eventually forfeited that bond, and months later he was taken back into custody where he remains as of now. One thing I have noticed, that there are several Harris County judges that have gone back to defendants who were granted a felony PR bond for felon in possession of a weapon by a magistrate, and the actual sitting judge has gone back and revoked the PR bond and remanded the defendant back in custody and then gave a surety bond. But there are several judges that I have seen that are actually cognizant that magistrates are granting PR bonds to defendants charged with that. But David Mitchum was saying about the dollar bond. I'm going to briefly read you this other case here as a result of that one. Houston area man out on a dollar bond in multiple domestic violence cases was arrested again for violating a protective order and criminal mischief. Now keep in mind, he's already out on a dollar bond. He was given a PR bond for violating a protective order and criminal mischief, and he's back out again, despite having a dollar bond. First of all, getting a PR bond for a misdemeanor violating a protective order is something you really shouldn't be doing anyways, because that's a direct violation of the O'Donnell decision. But again, you have to have some impetus to bring these cases to a higher court's attention. This particular defendant, who's been in and out of prison since 1992, is currently back in the community, and several of the families that he has stalked and continually has violated by showing up in their house for obvious reasons are scared out of their wits. Another individual that we have, a guy named Quentin Allen, he was given a PR bond for felon in possession of a weapon despite actually being released on parole for aggravated robbery with a deadly weapon. Now keep in mind, the defendant was just released on parole for aggravated robbery with a deadly weapon. Then 2 weeks later, he gets picked up for felon in possession of a weapon, a gun, and then is given a PR bond. And then a month later, he's charged with murder. And I can go over these case scenarios over and over again. One of the individual here is out on a PR bond for possession of a prohibited weapon, a machine gun. He's also on juvenile probation for aggravated robbery with a deadly weapon. So you got a guy given a PR bond for having a machine gun who's on juvenile probation for aggravated robbery with a deadly weapon. Another individual right here, he was out on a PR bond for possession of a prohibited weapon, a machine gun, and he was on a PR bond for robbery with bodily injury. He forfeited his bond, and he's currently a wanted fugitive. If we're going to get serious about gun violence in this state, we also have to get serious about the issue of everyday violence, and that's the everyday occurrence of felon in possession of a weapon who are being repeatedly released back to the community, and they know full well they're going to go back to the community. So we wholeheartedly support Senate Bill 1318, and obviously especially that one provision that we started noticing, and that is PR bonds, defendants charged with felon in possession of a weapon, a gun. Thank you.
Very good. Good questions. Thank you, Andy. Anyone else would like to testify for Senate Bill 1318? If not, okay, come down. FAR, these are the FARs still. You in support of it, sir?
I'm neutral at the moment. I'm representing the Texas Association of Pretrial Services.
Okay, you got a couple of minutes.
Just a few things. Aaron Johnson, Texas Association of Pretrial Services. Thank you for talking with me again. In regards to 1318, there are some good pieces of this legislation that I agree with. The association agrees with. There's just some clarifications that I think in the learning from Senate Bill 6. Senate Bill 6 took the stance that everybody in Texas was doing things a certain way. And there were no exceptions for how you had to do this. Now, I want to remind everyone that Harris County, Dallas County, Galveston County, all were under ACLU lawsuits and had to do things a certain way in order to be compliant with those lawsuits. So in the instance of Galveston County, we had already had all this stuff set up. The magistrates, it's already public. They put their stuff on the record. All the stuff is available. But there was no exception. So now the staff, and ours is not the only one, but now the staff are having to duplicate this process. And we've been working with OCA and Audubon to try to establish where we can already communicate and do some of the other pieces that are in this. But again, I want to make sure that people understand personal bond seems to be a bad word, and it's not. Personal bonds are set up so that we can relieve some of the jail overcrowding and the people that are coming through the front door. However, personal bond is done differently in different counties. So some counties have supervision and compliance officers that also work and hold those people accountable for personal bond, and some people are just let out. And I totally understand that because being in the association, we see the wide range. But I don't want people to just think that personal bond is the person is just getting out and doing whatever. That's no different than the surety system, except they paid a certain amount to get out and do whatever. And no one is following up with them. Somebody doesn't show up for court, they might get revocated. They might, the insurance company I'm talking about, might have to pay something. Maybe. They commit a new crime, there's no revocation for that. They just get a new bond.
Yeah.
So domestic violence, I don't, but somebody hits their wife, their spouse, it's $1,500 for the first one, $2,500 for the second, and just bumps it up from there. So I'm paying $150 and I'm getting back out. I'm paying $250 and getting back out. No supervision. And I would consider domestic violence to be one of the worst cases of violence and egregiousness when we talk about things that follow up on that. So I don't want to get lost with certain counties had to be in compliance with the way they do things. Now, a lot of the things here, again, the magistrates in Galveston County, they already do all this stuff. So I don't want to have counties that have things in place to again then have to duplicate everything just because we're trying to be, try to make things one way. So that's one of the issues. The other issue, I'm kind of confused on the making bond conditions a new law violation when we already have that in 2507. So that already takes into account the violation of bond conditions for protective orders. So I don't know what would be the next step other than that would just kind of compound. You commit a new crime, you're already getting a new charge. You don't show up for a compliance meeting, I'm going to charge you with a new crime? Is that, I don't think that's the intent, but I just want to make sure that we're all on the same page in regards to how that works. With the other piece, the only other piece I'm really looking at this point is that under 11, the attorneys, again, I don't know how often that dollar bonds are being set outside of Harris County. So I don't know that this is necessarily something that couldn't just be worked out through and talking with Harris County versus having.
It can't, so, I'm sorry.
No, go ahead.
I didn't wait to be recognized. Never mind.
No problem.
I apologize.
No, don't apologize. The bill's going to be left pending, so.
Understand that.
I would suggest you work with the author.
Absolutely. And I have no problem. I want to make sure that, again, I'm here representing the entire state and the pretrial service offices. And I just want to make sure that people aren't getting the same idea that PR bond is just you're out and that's it. It might be the case in some jurisdictions, but that's not for every jurisdiction.
No doubt PR bonds serve a purpose if used properly. And we're dealing with the improper use of them that we believe endangers the public. So that's why we're having this conversation. But I don't think anybody's
I'm
trying.
sure we'll have more conversation moving forward, so. that's all.
Sounds good. Thanks
Thank
for
you.
being here. Nicholas Hudson. I'm working. I was like, let me introduce you to Senator. Sir, here's Ms. Hudson. And she also is right next door to me. Ms. Hudson, good to see you. Tell us your name and who you represent.
Chairman, Hi, Senator Huffman. My name is Nick Hudson with the ACLU of Texas in opposition to the bill. We've met with each of your offices and provided a really detailed list of where all of our concerns are. I want to focus on just a few key provisions that are particularly concerning to us. One, the bill in two different ways kind of perpetuates a system where of wealth-based detention in the state. Section 7 requires people accused of certain serious crimes to put up a cash amount to a bondsman or to the county. And if you don't have any money, that will operate as a detention mechanism. That is exactly like the type of scheme, unconstitutional scheme that was found in O'Donnell. It would be wise for us to think about more comprehensive fixes to the system that can that don't rely on wealth as a detention mechanism. The other section that I wanted to point to is Section 11, the one that allows prosecutors to essentially just veto or appeal a decision about a bond amount. I think that's particularly concerning because what it essentially does will give the prosecutor the ability to keep somebody in detention, as the bill is currently written at least, during the pendency of that appeal. There's nothing wrong with folks appealing a bond amount. I think keeping someone in pretrial detention during that phase is particularly concerning to us. The other thing I wanted to focus on is just Section 27 of the bill, the new criminal law, the new criminal offense for violation of bond conditions. Judges have broad authority to set a whole host of bond conditions. They can do things like setting curfew, saying you have to abstain from alcohol. The way this is currently written, and I know that y'all are going to continue working on it, you can get a felony charge if you've already accused of a felony and you're out. If you were stuck in traffic and you missed a meeting with your pretrial supervisor. I think we just want to make sure that we don't have those sorts of cases. It may be wise to go to an enumerated list rather than having a catch-all provision in Section 27 if y'all are going to stay on that. One other thing that I talked to a few other people who practice in states that have these sorts of provisions, places like Colorado. And what they said was one of the really concerning outcomes of this type of provision, especially when you have a really hefty criminal penalty associated with it, is that if a prosecutor has a difficult time proving the underlying charge, but someone gets a violation of a bond condition, it provides them a whole lot of leverage to extract a plea on the underlying offense. I think that there could be some perverse consequences if we don't shore that up and make sure that it's not a really hefty criminal penalty in that particular section of the bill. Happy to answer any of the questions. Also provided written testimony that summarize our concerns.
I think we're fine. Thank you. Ms. Griffin Lee, do you want to testify this afternoon?
Yes, please.
Come forward, please. Let me know who you are and who you represent.
Yes.
And somebody told me you were nervous, so I'm going to assure you, just take a deep breath.
My first time, but I'm okay.
Oh.
Thank you. Good afternoon, Chair Whitmire, Vice Chair Huffman, Senator Huffman. I am Reverend Jocelyn Griffin. I'm an associate minister at Brentwood Baptist Church in Houston. I'm a resident of Missouri City. I'm a constituent of Senator Miles. And I'm testifying against SB 1318. I'm here to speak for many mothers and do not want any other family to experience the nightmare I have the last 350 days. This bill, I feel, will sweep up people like my son, those who may have had mental health challenges, others who may become unintended consequences of this law. My son, Evan, he loved to play football and was on his job the last 3 years before his arrest. He loved walking to work and helping senior citizens in the area. I still hear the ringing in my ears from my son, phone calls from the facility. Mama, get me out of here. I'm a dying here. Evan died in custody almost a year ago. I still don't have answers. Maybe the courts can detour those with mental illnesses to help them, not detain them, and make them vulnerable to those in the general population. I feel jail is for pretrial people, legally innocent, not to punish people. People are dying in our county jails at an alarming rate. And we still sending people into the jail. The jail is not designed for a long time stay. No matter the race or how much money we make, the Constitution promises all of us fair and equal treatment. Under the laws, the reality is that people's freedom should only be taken in very limited specific circumstances and be considered on an individual basis, not solely on the charge. Whatever this body decides to do, I would just request that you make sure that we're detaining people solely based on whether on whether they have money or not. We are supposed to presume innocence while waiting for our day in court, like my son Evan.
Can I ask you, excuse me, please?
So that other mothers, families don't have to experience and travel the path I did. In SB 1318, please do not further criminalize poverty. Thank you.
Mr. Chairman, you had a question?
Senator Miles.
Ms. Lee, I want to thank you for coming today, and you did a fantastic job, by the way, of making your testimony, of giving us your testimony today. Please go back and tell Reverend Ratliff I said hello, my good friend and brother.
Thank you.
Madam Chairwoman, author of the bill, I didn't see anything in the bill to address mental health. Did I miss it?
This particular bill does not address mental health, but you know that's always been an overriding concern.
Always
You know,
been an
I started the first jail diversion program in
And-
Harris County.
And to clear the record,
Yeah.
Andy, we addressed this same issue in the 87th legislative session, and she led the way. So it's not the first time we've dealt with this. But go ahead.
But so mental health is always an overriding concern, and it plays. And I'm very sorry, you know, what has happened to your son. And we do need to do a better job in the jails with those who are suffering from mental health illness. I think we would all admit that, but we're working on it. This bill is just designed to promote public safety. Remember, the judges make an individualized determination. That's what I want them to do. So when they look at a defendant before them, they know about their background. They know if they have mental health issues. They know what would be an appropriate bond and what would be an appropriate approach to that individual defendant. That's what we want to happen. And so we do need to work. And I commit to everyone, I commit to you, Senator Miles, and
Ms.
to you,
Lee.
ma'am, that we will continue to work on how we address mental health in our jails, because the jail is no place, not supposed to be a hospital, it's supposed to be a jail. So I appreciate you being here, and I'm committed to continue to work on this. It's a tough problem to solve. We've all done our part in working on it, but we need to work harder. So thank you.
And Ms. Lee, I can assure you, I represent you. I know the conditions for which we live in, our community lives under, and the challenges. I want to assure you that I will not let this bill go by without hearing our voice and our concerns, which is we don't want a bail system that's only for the rich. I feel in the time that I've worked with Representative Huffman that she knows as a former sitting judge, but I can assure you from where I sit that I won't let us design a bail system that only benefits the rich and that's going to be deemed and direct and locking up the marginal Texas citizens as well as mental health. Okay? My staff's going to give you my direct, and as this bill progresses, I will keep you informed, and I look forward to working with you to get your input as well, so that I can bring it back to this body. And I see Senator King over there. I've worked with him in the Senate before. In the House before. Senator Whitmire, Dean Whitmire, and I have been knowing each other for 30 years, and sitting next to him is Hall. I feel comfortable that I can ask you to be comfortable and let us work through this. It's not always easy, okay? But I know that we're committed. This is our second time bringing up bail reform, and we all know, and I think you know too, that Houston needs some type of bail reform that's fair and equitable and inclusive of everybody.
Yeah.
So I commit to you that, okay?
Ms. Lee, I'm interested. Was your son on bond? Had a bond been set for your son?
There was a high bond, yes.
What was he charged with?
It was aggravated assault with a deadly weapon.
And so when his life was taken into jail, he couldn't post bond because it was a high bond?
Correct.
Did he have a previous record?
Yes.
Okay. Well, I'm sorry about those circumstances, but this bill, as Senator Huffman's pointed, is trying to have magistrates that will place a reasonable bond based on the risk assessment of that individual. So thank you for being here today, and you're making a difference. Thank you.
Thank you. Thank you.
Jenny Hickson.
Thank you so much.
I didn't ask her. I think he was beaten by the other inmate.
Good afternoon, committee members. My name is Jenny Hickson. I'm a resident of San Antonio, Texas, and I am also with the Texas Civil Rights Project. You heard earlier from my colleague Ashley this morning. So I first want to recognize the very legitimate challenge that you have before you of balancing both public safety and the rights of those who are accused. In my previous role, I worked on domestic violence, and so I'm extremely sensitive to the enormous pain that this issue causes and the enormous danger that people that are experiencing domestic violence face. The question that I would ask is if this is the right remedy for that. We currently have other programs that we know are more effective at interrupting the cycle of domestic violence that we can put in place without adding to an unfair bail system. And so, for example, BIP costs $2.35 a day. Detaining somebody costs $69 a day. So I think if we're thinking about where we're investing our efforts, we should be looking at ways that we can invest them in long-term prevention and continuously rearresting people and setting higher and higher bonds that they may or may not be able to meet. Does not necessarily get us to long-term prevention, specifically with some of these family violence issues, where we know that people will get out. If they have children together, they're going to continue to be in each other's lives, and unless we address the underlying issue through other types of programming, continuing to double down on very strict bond conditions, which are frankly unfair to people who don't have means, doesn't actually get us to the stated goal, which is a safer community, which is what we all want. That's all I have. Thank you so much.
Thank you. Thank you for being here. David Gonzalez.
David Gonzalez, the Texas Criminal Defense Lawyers Association, testifying in opposition to the current draft of the bill. And thank you, Senator Huffman, for being able to leave it pending and solicit feedback. And in doing so, we can look at two different sides of where the defense bar can do a better job. I think on the front end, there's a bit of a gap between when we're told about bond conditions, and they can be in place for weeks or months before a lawyer is appointed. For things like emergency protective orders, magistrates give very clear warnings with the consequences of a violation. And I'm not convinced that a lot of the bonds that we see with conditions, there's a warning that comes into effect. And I think members of my profession often prioritize things like EPOs and EMs and IIDs more than maybe a class or other conditions. And by treating them all equally, it may be a situation of what we should prioritize. On the second part, kind of on the back end, if there's a violation, we know that some judges have lots of communications in misdemeanor cases with defendants about how they're doing and how they're complying. On a bond forfeiture, I think those prosecutions are probably pretty easy in calling the bailiff to say the person was called their name 3 times and didn't appear. I don't think we want trial judges as witnesses, but a lot of those conversations, either the trial court's going to have to admonish them of their right to remain silent and their Fifth Amendment privileges with pretrial, with all the kind of things that I think happen naturally. And how are you doing? Are you complying? And someone says something, well, I'm having trouble. I would think in working with your office to clean up some of those provisions, a lot of just the logistics of what we do right now in bond conditions are all with the court's inherent power as compared to outsourcing it to the prosecutor's office. And the only other comments we have, we do appreciate a lot of the clarifying language of SB 6 because there's been a lot of issues on people out of custody getting the public safety reporting system done. To echo some similar concerns just related to a notice of appeal allowing someone who was granted a bond, who posted that bond, but then to be detained until the appellate courts have a decision. If we could make sure those are on an expedited briefing schedule or something else, we would hate for someone that was eligible for a bond and posted bond to then sit a year or two waiting for an appellate court to make a decision, given the backlogs post-COVID in all of our appellate courts.
Okay, thank you for being here. Jeffrey, Ms. Stein, Jeffrey Stein.
Good afternoon, Senators. I'm Jeffrey Stein on behalf of Civil Rights Corps. I'm a Texas resident, and I'm testifying in opposition to the bill. I want to focus just on 2 sections, starting with Section 11, which is the appellate procedure that's been discussed a little bit. We strenuously object to that provision. It effectively gives the prosecutor a de facto veto over any bail decision made by a judge. I've been practicing in criminal courtrooms across the country for over a decade, and I can probably count on one hand the number of times that a prosecutor has consented to the bail request by the defense attorney. And what this provision does is gives that prosecutor a vehicle to essentially override the judge's decision while that appeal is pending. And I can tell you from experience what happens then is as a case languishes in the appellate courts, the pressure on a person, whether they're innocent or not, is going to increase to plea. That's what we saw in a study that was done in Harris County prior to the enactment of the O'Donnell consent decree. There was a number of people charged with drug possession offenses who pled guilty just to get out of jail because they didn't have any other way to do that. And then when the drug testing came back, it showed that what they had possessed was actually not a prohibited substance at all. So you had proof that there were people who were factually innocent pleading guilty. And what you'll have here is if an innocent, someone who maybe the evidence is weak against, so a trial judge says, I'm going to release you on a personal bond or a low bond, and the prosecutor objects and files an appeal, that person is just going to be stuck. And that's not just, it's also going to clog the courts because what we'll have is a slew of appeals pending in the appellate courts that are going to need to be heard and ruled on. Whether there's an expedited procedure or not, they're going to clog the courts and consume resources and further contribute to the backlogs that delay people getting justice on either side of the V in those cases.
Let me ask a question. What would be the status of the defendant or the person charged while you appeal?
Well, the way the bill is written, that they would be held in custody, but remember, these are only state would only have the right to appeal when there's the commission of a new felony while they're out on a felony bond. So it's not all bonds
Yeah.
at all. It's
That's
a
the reason I asked the question.
It's a very specific subset, which
Who are out on bond, and then they commit another crime, or charged with another
it's a
crime.
new felony.
Yeah.
It's a new felony.
New felony.
You know,
So
on
it's
bond.
not nearly as broad as, the reason I asked my question. You
it's-
make it sound like people are gonna be stuck there in large numbers while the DA gets a veto, as you call it. But it's really someone that's already out on bond.
And historically, many times, they would be held at no bond when they committed a new felony and they were on bond. I mean, they would revoke the bond and then they would pend a hearing or, or something. That would take time in itself. I see the DAs in the audience shaking my head. So all this does, and, we could
It's
make
another
it an
safeguard.
expedited appeal, so it's
It
just
doesn't
kind of
bother you
creepy.
if someone's out on bond and they charge another crime and
I think that's a
they get
decision
another
that,
low bond, and at what point do you get concerned?
so I think that's a decision for the judge to make who hears the new evidence, whether it's actually a basis to believe that there's reasonable evidence against the person. They can consider other factors. They're the fact finder who is closest to the case. This isn't a situation where it's giving the judge authority to detain someone. They have that authority. It's giving the prosecutor a trump card
But
for
see,
all.
in Harris County, you keep saying the judge, and if it's the Waller JP that has to stand for election, and he's held accountable, but in Harris County, our magistrates are appointed, and we really don't know much about them when they're appointed. Can you see where that's a broken system in that we're just trying to do the right thing? We're being asked by our constituents to do the right thing. So I'm just trying to get your input on what would be a solution.
Sure. I think transparency in the system, I'm all for transparency. I don't think the solution to having concerns about transparency is creating an automatic detention order and giving the DA the ability to essentially just have a blanket override with no review until an appellate court has the
So
opportunity.
if we don't do that, as Senator Huffman's proposing, we'd have a magistrate giving someone another perhaps low bond, and then they'd be returned to the streets.
If a magistrate gives a low bond, and as I think one of the DAs testified earlier, and they object, they can file, and they have a number of avenues available to them, ranging from filing a motion with the trial court to pursue. And if this bill contains an appellate procedure, that is an option, but including the de facto automatic detention, I think that's more reminiscent of something frankly out of Guantanamo Bay than out of the system of laws and rule of law that we have here.
You just lost me.
Then I'll back up. And the only other, I don't, if there's the
I was trying to get there with you, man, but see, that's
allowing, giving.
No, we're having a dialogue, but I'm asking you for a suggestion. Of course, you just blew it comparing what we're doing with Guantanamo Bay. But we've got a serious problem in Harris County. And so if you're going to criticize the proposal, you need to have a more reasonable proposal, solution.
I think including an appellate provision is one option, but having an automatic detention order that overrides any judge's decision, just because the DA in whatever case files a notice, I think that's too blunt.
I appreciate your concern.
And if I could just very briefly raise just one more point with regard to Section 7, I would just note earlier today we heard a lot of testimony about how SJR 44 just increases judges' discretion. What Section 7 does here in removing judges' ability to grant personal bonds is just reducing discretion for judges.
Okay, thank you.
Consider what I might add, because a couple people have said this, there may be a way, and I'm very open to adding an expedited appeal to the process. So that may be a good compromise that sort of addresses different folks' issues. And, I don't know how many of these there are going to be, but I don't think there's going to be that many, because I think when the judges know that they're going to get appealed, they're more likely to set something reasonable. So we'll see.
I don't
how it
think the
works.
person's going to be languishing in jail. We'll put our heads together and see how we can get it resolved sooner than later.
And I'll just, on that particular note, there are already legal mechanisms where a court or an advocate can request that an appellate court issue a stay of an order. So issue a stay of a bond order or something like that, rather than having an automatic, without a judge weighing in as to whether the prosecutor is likely to prevail or something like that.
Yeah. Well, if we can do it quickly appealed, you won't have the pressure for someone to plead, go ahead and plead when they would rather not. And I, as a young lawyer, have seen defendants in the holdover cell be told how long they're going to be there till next month when they need to get back to jail. So that was a serious problem because they'd go ahead and plead for something they didn't think they should because they didn't have the $1,000 traditional bond in Harris County. So I'm hearing what you're saying on the pressure on someone to plead when they wouldn't ordinarily. But we'll deal with that they don't sit in jail any longer than the pressure on them to make that decision. Thank you.
Thank you.
Nathan Fennell. Oh, Nathan, are you unfortunate that you got to testify against this too?
Yes, Chairman. Nathan Fennell, Texas Fair Defense Project. We're opposed to this bill. I think it's possible this bill was amended since I printed it out, but the way that it reads right now is that Section 11 for the district attorney's right to appeal would apply to anyone who had previously been granted bail for an offense punishable as a felony. The language grants bail means bail has been set for someone, and the Constitution provides for a right to bail for all felony cases, with a few exceptions right currently. So the way the bill is currently written, the right for a prosecutor to appeal a bail set because any prosecutor felt like the bail wasn't high enough and then hold the person preventively detained until it was resolved would apply to anyone who had ever been arrested for a felony in Texas and had a bail set, even if they were acquitted, even if it was 30 years ago, anything like that. So the current language here, we would ask Senator Huffman and the committee to consider if the intent was that only be for people who are presently out on bail and accused of another felony on bail, that be clarified in the language, because right now it reads differently. And I do think that the delay in the appellate courts is a significant consideration, and I think the more in my appellate practice, things take 5-6 months to get the first hearing. The OCA says it takes 11 months on average for resolution. So adding anything to that is going to slow things down, and I think if there's going to be an appeal here, having an expedited process would be helpful. It would still slow down all the other appeals, and so we would still have that negative impact, but we would ask at minimum that so that folks aren't being, ideally not being preventively detained at all at the request of a prosecutor, especially not a line prosecutor who's not the elected prosecutor in an area, for that. Thank you.
Good points. Thank you. Lauren Rosales. The Bell Project. Who's here representing the Bell Project? And I can't read their handwriting. Lauren. Saba Blanding.
Good afternoon. Thank you so much for the opportunity to testify. My name is Saba Blanding. I'm from Houston and Harris County. I'm covering both. And I'm speaking for myself in opposition to SB 1318, especially Section 7, which is categorically is a categorical bar on personal bonds. And I just want to go back to the previous testimony. 80% of those in Harris County Jail have a mental illness. 5% report is unhoused. If we want to fix this, we need to go to the root of housing and mental illness and providing resources to our communities. I also really want to bring up the fact that in the past year, 161 people died in county jails. That's a huge amount of people. These weren't people who went and got a public execution. They died under the state's watch, under the county's watch. That includes, in Houston, it was 32 people. It included 4 suicides, 3 homicides, and several due to medical neglect. And I just want to highlight a couple stories. Specifically, I'm a mom, I have 2 kids. I think we all want safe communities. I think we all want everyone in Texas to have the same rights, and this bill does not do that. Kristen Smith died in jail last year, leaving behind 4 kids, all because she couldn't afford $40,000. Her bond was lowered to $5,000 after she died. One woman was pregnant with twins when she was arrested. She couldn't afford the $80,000 bond required for her release, so she was stuck in jail. She faced extreme abuse, also in a miscarriage. Oh yeah, sorry. It's just hard to read this as another mom. She miscarried in jail, one of her twins. She was taken back to the jail where she was assaulted by multiple women in her cell. She was then taken to the hospital again and sedated. When she woke up, she learned that doctors terminated the second fetus without her knowledge or consent. A few weeks later, she attempted suicide. After enduring all of this, the DA dismissed the charges on which she had been jailed. Like, every Texan matters, and we need to consider these terrible conditions. I understand you're trying to do right and keep us safe, but we need to put the resources and the housing and the mental illness, because they are going to come back. When you ask, was he arrested before? That's what happens when we criminalize mental illness. And so I trust we can do better, and that you can do good for Texans. So thank you so much for your time.
Thank you, ma'am. Thanks for being here.
Good job.
I'm sorry, do you have a question?
No, I just wanted.
A sister, yes. Melissa Martinez.
Oh, good afternoon.
Good afternoon. Ms. Martinez.
Yeah, my name is Melissa. I was born and raised here in Texas, in Houston, and also a resident of Harris County. I'm here showing up for Texans in front of this committee to vote no on this extreme bill. When I say that I show up for Texans, I mean that I don't think of a single community group that I exclude. I think of those in the front line of injustices that are in need of safety, from the youth that are in juvenile detentions and from all across the age spectrum, survivors that are from economic disparities, sexual, physical, and psychological violence, from being failed by our systems that lack necessary investment and not being cared for, such as the 85% of the 100,000 that are in pretrial defense, such as the 32 deaths within the 14 months, and from just there's a lot of neglect here, and I just want to emphasize on how there's this legacy of neglect and dismissal towards these incarcerated residents, as it reveals a legacy towards exploiting these vulnerabilities of mental health and so forth. Just as mental health was also discussed previously that I spoke on, and also just in this body right now, again, like 95% are of homelessness. 80% are from people that experience mental health crises that are being incarcerated. And that's just to show again where we're putting these investments. These are predisposed beliefs that we are cycling through and recycling of these harmful beliefs of our, of how we criminalize. How can we criminalize, for example, recently of humanitarians wanting to feed the hungry, and to criminalize houseless folks when we can invest towards housing, or how we don't have adequate care in our mental health towards those that have crises. And I'm also an educator, so I'm always around my own peers, my younger siblings, family members, students, and I've always seen the change of just how we believe and take care of one another based on how we're invested in each other one-to-one, and seeing how we change into betterment for having a safe place to be in. And I emphasize that because these are loved ones, these are family members, and Section 7, I want to bring that up as I believe that it should be striked from these personal bonds for additional offenses. And again, these are criminalization of poverty. What are we trying to criminalize for than just investing towards the issue? And
very good.
That's all I wanted to emphasize, and just to reimagine than just what we have existently have, as for the many decades that this state has been perpetuating and investing towards, more jails, more fines, profiting off of these vulnerable people. And I really want to emphasize that it is possible. It is possible if we were to have these resources and
Very
take
good.
into consideration and to vote no. And thank you.
Thank you for being here.
Thank you.
Anyone else present like to testify for or against Senate Bill? Nikki Presley? Well, whoever you are, come down. State your name and who you represent.
My name is Nikki Presley. I represent the Texas Public Policy Foundation, and we're testifying on the bill. I first wanted to thank you, Senator Huffman, and also the Lieutenant Governor for continuing to work on this issue and being such a champion. This is a public safety issue and a justice issue. Our goal at Right on Crime and TPPF has always been to base bail on someone's risk and not their ability to pay. With that being said, there are some sections of SB 1318 that we think could be worked on. Section 27, which is creating that new offense for violating bail, is a little broad, and I think that people would be getting new offenses for technical violations and those types of things rather than continued criminal activity. And I think that there might be some alternatives to creating this new criminal offense that would provide accountability to those who are actually reoffending while on bond. And then sections 9 and 11 both seem to be in conflict with the Texas Constitution and someone's right to bail, as it is written now. And then I did want to point out, I really like the integration aspect and the transparency on hiring magistrates and that process. And I'm happy to meet with y'all's offices, and I look forward to working with all of you.
Thank you, Ms. Presley. David Johnson. State your name and who you represent, please.
Absolutely, Chair. Thank you. My name is David Johnson, and I represent Grassroots Leadership. I am here to testify in opposition of 1318. Simply put, the entire criminal justice system that I believe everyone present today believes in so strongly is centered around innocent until proven guilty. And as much as we may want to believe that it is fair to judge the vast majority of human beings in Texas according to a very small percentage in order to violate that fundamental right on which all prosecution and criminal justice operates, is a violation of not only our constitutional stance, but it's also a violation of our humanity as a community. As we've expanded electronic incarceration, ankle monitors, and house arrest, as we have expanded things like bail revocation so that this becomes something that actually funds the criminal justice system and disproportionately harms, I will surprise you, Black, brown, and poor communities. We are leaning in a direction of fear based solely on our apprehension that there might be something horrible that happens. As someone who has been pistol whipped and robbed in a hotel room, as someone who has children who are the result of fentanyl toxicity because of tainted substances reaching the street, I can speak from the position of someone who is directly impacted by what we talk about in crime. And I still believe that the day that we are unable to protect the presumption of innocence for anyone, because as the National Institute of Medicine has proven in 2012, 1% of people convicted actually responsible for 63% of what we call violent crimes. What you were talking about today is eradicating a person's ability to participate effectively in their own defense based on their presumption of innocence, because we're afraid that they might be acquitted. If we're afraid of people's acquittals, then we're really afraid of something far greater that's plaguing our justice system, and I think that probably should be addressed first. Thank you.
Thank you for being here.
Thanks, David.
Do you want to read these in or not?
Anyone else?
Do you want to read these in or have them?
No, I'm going to let, there's a number of witnesses, go ahead, have a seat, that have signed in that do not wish to testify, and I'm going to let the clerk read that into the record when we finish public testimony. Go ahead, sir. State your name and who you represent.
My name is Ken Good. I'm an attorney. I'm a board member of the Professional Bondsmen of Texas. I'm here
You
to...
fill out a card?
Say it
You
again?
filled out a card?
I did. I filled out a card.
Okay, it's probably in the stack. Go ahead.
We're here to testify in favor of Senate Bill 1318. I just want to address one very small issue dealing
Go
with
ahead.
Section 4. Section 4 deals with a magistrate or a judge can review a public safety report when he's issuing a warrant. I just question whether it addresses the issue that was raised. SB 6 really doesn't address the issue of warrants, but it requires the review of criminal histories. And so the issue that's come up since SB 6 is a bond amount tied to a warrant a recommended amount? When is it required? OCA testified at a hearing last summer about there are times when the database doesn't show whether it's mandatory or not, because we know a warrant issued by a grand jury is mandatory, it can't be changed. What the bill says is you can review a public safety report in issuing a warrant. I think if we made it, we have different warrants. They don't recommend a bond amount, or they say defer to the magistrate, or they set an amount. If we just changed it to say if the warrant has a bond amount, they're required to review the criminal safety report, I think that fixes that issue and resolves OCA's issue. That's my only comment, but we're in favor of the bill. Thank you.
Thank you. Okay, one more time. Anybody here for or against 1318? If not, public testimony is closed. We'll leave it pending at the request of the author. And now we'll move on to, you ready for 645, Joan?
Yes.
Chair recognizes Senator Huffman on Senate Bill 645.
Thank you, Mr. Chairman and members. In recent years, overdoses in the United States have skyrocketed due to the increased production and smuggling of fentanyl, an incredibly potent synthetic opioid. According to the CDC, in the 12-month period ending in February 2022, more than 75,000 Americans died from overdose of synthetic opioids, mainly from fentanyl. In fact, this has made fentanyl the #1 killer of adults aged 18 to 45. Since the beginning of Operation Lone Star and Texas efforts to secure the border, the Texas Department of Public Safety has seized over 353 million lethal doses of fentanyl, which is enough to kill nearly every person in the United States. In 2021, the 87th legislature passed Senate Bill 768, which increased the criminal penalties for manufacturing and delivering over 1 gram of fentanyl, creating its own group that appropriately reflects the lethality of fentanyl compared to other drugs. Following the passage of SB 768, we have tragically learned the extent of the lethality of fentanyl and how even under 1 gram is just as dangerous. So at the time, getting that passed last session, it felt like it was going to be an improvement. It was actually, believe it or not, a little bit of a lift to get that out of there, because I was raising punishment for a small amount of drugs, but we've learned a lot in those 2 years. So to continue our efforts to keep this drug from hitting our communities in the way that it is, Senate Bill 645 increases the penalty for manufacturing or delivery of less than 1 gram of fentanyl from a state jail felony to a third-degree felony. Furthermore, when an individual dies from a fentanyl overdose, the penalty would be enhanced to a second-degree felony. This is designed to address the one-pill scenario where, due to the lethality of fentanyl compared to other illicit drugs, it only takes 1 pill to kill. The bill also includes possession of fentanyl with intent to deliver in the organized crime activities statute, which gives prosecutors more tools in the prosecution of this offense. And lastly, upon recommendations from prosecutors, the bill clarifies penalty levels for drug offenses to ensure more efficient prosecution of these crimes. Members, I do have a committee substitute. If I could send that up, Mr. Chairman. Okay, send it up. Oh, well, just send it up. He's not paying attention.
Chair recognizes Senator Huffman for introduction of committee substitute.
All right, well, the committee substitute adds that if a toxicology examination reveals a detectable amount of fentanyl, the death certificate shall include in the cause of death the presence of such substance as fentanyl poisoning. Members, we have reached the critical point in the fentanyl crisis here in Texas. We have no choice but to take a comprehensive approach to this complex issue. Along with Senate Bill 645, I also have Senate Bill 1319, which will be heard today. Furthermore, in Senate Bill 1, I have allocated over $18 million to support overdose prevention, education, and overdose reversal medication. This record amount of funding will provide overdose reversal medication access for law enforcement, first responders and healthcare providers, schools, and community organizations. Additionally, Senate Bill 1, which will be the budget, includes a record $4.6 billion for Operation Lone Star, help secure our southern border with Mexico. It also appropriates $147 million for DPS Crime Lab services to assist in the prosecution of fentanyl-related crimes throughout the state. It is flooding our border. It's killing our citizens at a horrifying rate. We must act. And I will have another bill. It just wasn't ready today, and the language that's being worked on, and which I have to get done by Friday, which will actually make knowingly delivering fentanyl and it resulting the death to actually be a murder. So you'll have the tools within this bill if the other one passes, which will be a standalone bill. It will create a murder statute. And
Very good.
that's what I have.
Thank you. Elise Lindberg. State your name, please, Ms. Lindberg, and who you represent.
Good afternoon. My name is Elise Lindberg, and I represent Dallas County Criminal District Attorney John Crusoe. Thank you, Chair Whitman and committee members, and thank you, Chair Huffman, for filing this bill. SB 645 is a bill that clarifies the appropriate level and degree of drug offenses with enhanced punishment ranges whose penalties are found in the Texas Health and Safety Code. Currently, if the level and degree of a felony offense is not specifically designated in the code, it defaults as a third-degree felony offense under Texas Penal Code 1241. Currently, that's the designation it would be for a third-degree felony offense. In the 87th legislative session, this body placed fentanyl and its derivatives in its own category of offense in penalty group 1-B, and also increased the criminal penalties for a person who knowingly manufactures, delivers, or possesses with the intent to deliver fentanyl. This body took great steps in the fight against fentanyl last session, and we appreciate Senator Huffman's efforts to do more this session. By strengthening punishments for fentanyl to curb the destruction it causes our communities, enhanced penalties were previously established. This bill now makes the offense level comport with the punishment consequences that this body already saw fit to implement. By clearly defining that a person who violates these laws will face first-degree penalties, enhanced with minimum years of prison time, as well as increased fine amounts, these offenses can be prosecuted with the severity they deserve, and thus will no longer be categorized as third-degree felony offenses pursuant to Texas Penal Code 1241. This bill enumerates that if the maximum punishment is life in prison or up to 99 years in prison, then the level and degree of the offense is specifically categorized a first-degree felony offense, like other first-degree felony offenses which carry a penalty of life or up to 99 years in prison. Additionally, this bill also increases the penalty for manufacture or delivery of a substance, like Senator Huffman mentioned, that if someone possesses less than 1 gram in penalty group 1B fentanyl, it now is going to be a third-degree felony offense, not merely a state jail felony offense. Finally, this bill adds the first-degree felony penalty designation to other current drug offenses in the Health and Safety Code, which do not have the level and degree designated in the code, but they have a maximum punishment up to life or less than 99 years in the Texas Department of Corrections. These changes are important for all parties involved in the charging and sentencing to have clear specificity for record-keeping purposes, for efficient prosecution, especially with regard to the judgment and the sentence. For these reasons, I encourage you to approve Senate Bill 645. And if you have any questions, I'm happy to answer them.
Thank you. Thank you for being here.
Thank you
Thank you.
for having me.
We're in good shape. Thank you.
I think you're good.
Okay, thank you.
Yeah, we're good. Mr. Burback? Caven, Burback? I may be, yes, ma'am. Yes, sure. Says you signed in neutral?
Sir?
Are you for or against the bill, or neutral?
Oh, we're for or against the bill. We're for the bill. I just had two critical issues I wanted to speak
Sure, go right ahead.
to. However, with
State your
Senator.
name, please.
My name is Karen Burbach. I'm formerly Governor Perry's general counsel. I apologize for the sunglasses, but I had eye surgery yesterday.
No problem.
So I'm here with that, and everything's kind of blurry, so I'll do my best. And Senator Huffman, the amendments you just mentioned, I believe, cover what my issues are, but I'll go over it anyway, just in case, since I want to make sure we got there. I applaud 645, Senate Bill 645. I think it does great things. My two issues are two issues just to expand, and as I said, it is much in line with what Senator Huffman just amended. First of all, we would like to increase the penalties for a death from a counterfeit pill, a single counterfeit pill. And those are most of the deaths that occur today. Someone takes a single counterfeit pill that looks like a prescription pill, and it can have as little as 2 milligrams of fentanyl in it, according to the DEA, and that is a lethal dose. So the larger amounts really don't address this very big issue that is the one that is mostly happening in our state and country today. So we would like to increase the penalties for the criminal penalties for the death from a single dose counterfeit pill and prosecute it as murder. The second issue is a practical one that most people, I think, aren't aware of unless you've actually been through this nightmare. And I am here because close family friends of ours has actually occurred, and I will go through his story to explain to you the practical disconnect of what impedes prosecutions for these single-dose deaths. Jake Ellinger grew up here in Austin, Texas. He was a very gifted athlete and as well very gifted academically. He made a 35 out of 36 on his ACT. He was recruited by top-tier schools such as Stanford, Brown, Penn, Dartmouth. He chose to play at the University of Texas because his brother Sam was the quarterback at the time, and he wanted to play with his brother. So Jake began at Macomb School of Business as a finance major. He became a member of the Silver Spurs, and he was on the UT football team as a linebacker. As a sophomore in 2021, Jake was looking forward to his internship at Dell. On May 6th of 2021, Jake's mother received the unbelievable call that her 20-year-old son had died from fentanyl poisoning. Jake's murder from fentanyl poisoning will never be prosecuted. And the reason it will never be prosecuted is because the DEA and the Austin Police closed the investigations once the medical examiner's report came out that it was an accidental death. Most of the medical examiner's reports today say that. They call them accidental overdose, accidental is that there are two things. It's a cause of death and a manner of death. And in the manner of death, they can say accidental or it can say homicide. There are categories for that. And then the cause of death will say fentanyl or whatever the cause of death was. By not using the words fentanyl poisoning and categorizing it as an accidental overdose, the law enforcement has to close their books because it's really hard to prosecute an accident. So it's really a disconnect that I think unless you've been through it, you don't understand that there's this disconnect between the ME's office and law enforcement that's causing these investigations to be closed once that report comes out.
Do they
It's
know
over.
where he received the substance?
I'm sorry?
I'm listening to the facts, and I
Yes, sir.
generally remember reading about it. But you're saying someone should be prosecuted, so I'm wondering, in that specific case, did you have a suspect? Do you know how he came about the drugs?
They didn't, they closed the investigation before they completed it because of the medical examiner's report of accident.
The
We were
medical
told that
report
directly.
happened. They received a medical report that quick? I mean, surely they looked on his phone.
They
And
had
had-
the phone, the DEA said they couldn't get into the phone. Well, I don't know why, but anyway, the Austin Police and the DEA
Yeah.
both had the investigations open until the medical examiner's report came out.
Yeah.
And they told us
Anyway,
directly.
I just think there's probably the rest of the story in terms of who the suspect was and not, go ahead. I understand your concern that it did not list, it was declared an accident instead of an active investigation.
Right, it was declared an accidental death.
Yeah.
Therefore, the law enforcement,
Did not
DEA
pursue it.
and Austin Police closed their investigations because it's difficult to prosecute an accident.
Sure.
Okay.
And that's why we're doing the bill.
Yeah.
Yes, ma'am. So what you said today, I think your
Yes.
two amendments
Very
really
good.
are addressing those issues.
Right. See, as it is, yeah, if this bill passed, then it would be fentanyl poisoning on his death certificate. And if, the DA knew who had delivered the pill,
Sure.
if they knowingly delivered the pill, then they would be responsible for his murder, yes.
Perfect.
They
Yes,
could be
that's-
prosecuted under this bill for an enhanced penalty of a second degree, but I will have another bill that would also make it a murder, and we'll see, how the members feel about this. This one,
Okay,
is- is
yes,
enhanced
exactly.
penalty.
That,
We can get
those
up
are
to-
our two issues.
Right.
Exactly.
yes.
And just to close, I'm going to close with, and I'm going to try to read this because it's a quote, so I want it to be exact. As Governor Abbott stated in his recent State of the State speech, to end cartel killings of Texans, we must do two things: call fentanyl deaths what they are, poisonings, and prosecute them as murders.
Right.
So I have a draft of some language, if that's helpful, that I can leave with you.
I have it, thank you.
Oh, you do? Okay,
Yes.
thank you so much. Thank you all.
No, thanks for being here. Aaron Johnson?
Thank you.
Aaron, he's been with us all day and he's not here now. Peter? You come forward. Stout. State your name and who you represent.
Good afternoon, y'all. I'm Dr. Peter Stout. I am president of the Houston Forensic Science Center, which is the crime laboratory that serves the city of Houston, and I'm also president of the Texas Association of Crime Lab Directors. So thank you for the chance to comment here. I'm testifying on the bill as a resource. And really, it is outside the purview of the forensic laboratories about what the charging is. Our job is to produce the result to let others do that. The committee sub that you put in, I guess what I would ask is we probably need to talk some about the language in that. So I'm a toxicologist, I'm a board certified toxicologist, and how that gets characterized from the scientific standpoint of a toxicologist. Am I trying to say that concentration in the blood means this? Alcohol's the only drug that really behaves nicely. All the rest of them are complicated. And the difficulty is I see regularly in DUIs, people that are out there driving around in the community with concentrations that I would have classically viewed as beyond lethal for them and about 12 of their best friends.
Right. And they're not dead.
Yeah, and they're not dead.
Yeah, right.
Not only are they not dead, they're out there driving.
Right.
Not
Not well. but
No,
they're-
no,
yeah.
yeah, not ideal behavior.
Yeah.
So I guess if we could talk some about the any detected amount, because the other challenge we have for medical examiners and the toxicologists associated with medical examiners, there is a wide variety of how that gets reported, what's detected, indicated, all these kinds of things. And if we don't approach it carefully, we could end up with probably some unanticipated consequences of how things get reported and the impacts to laboratories.
Right. And we're happy to work with
Yeah.
you. I think you understand the objective.
Oh.
It's a situation like the Ellinger young man,
Yeah.
Ellinger young man, where, you know, he's a very healthy, athletic young man. Clearly he was killed by fentanyl,
Yeah.
an overdose of,
Yeah.
you know, but it was poisoning. But the word accidental, of course, and we're,
Yeah.
as legislators, what we're trying to do is to say, yeah, you may have delivered the pill and you may not have known there was fentanyl in it, but that's going to be the cost of doing business. If you deliver a pill and someone dies from it, then guess what? You're going to be responsible for that. So it's a knowing act, not necessarily an intentional act. So we need to appropriately reflect that. Now, if in fact they didn't die of fentanyl poisoning, then I'm assuming that would be something you would find through your examination whether it was a.
And even in that can be complicated as well.
And
'cause
that
we
may
see
be a fact issue for a jury
yeah.
to have to,
Yeah, and
or judge
how
to work
we,
out, or prosecutors to
yeah,
work out.
and I think there is a lot of nuance in the language of reporting, and we see so many cases where it's not just one drug, it's 12 drugs on board, and then trying to parse out what actually was contributing to the cause of death can be really complicated. So I think, you know, best I can say is please reach out, let's talk about the language on that and see if we can help find something
can.
that accomplishes what you need.
Yeah, all right, thank you.
Any other questions I can answer while I'm sitting here on this one?
How much fentanyl did you tell me you're waiting to test the other day?
We have mountains of pills. We have detected it. The first fentanyl that we detected in Houston was in 2015. That was the first case. Last year, we identified it 145 times. So you're looking at 145-fold increase in the space of, 7 years. And keep in mind, what we see in the laboratory sits behind what law enforcement interdicts and seizes and what's going to actually have charges filed on it. So there is more out there that we haven't detected. We detect fentanyl regularly in combination with things like xylazine and nitazines. The combinations that we see this stuff in is just gigantic, hugely dangerous. I can't overstate it enough. I've talked with student groups and citizen groups all over the state about you just have no earthly way of knowing which is just stuck in your mouth. And yeah, this is a challenge for all of the laboratories. We are all struggling to keep up with the increasing complexity of the testing because these pills often have many multiple compounds in them. Basically, the materials that we get to test, I joke, we test goo in socks, but it's everything imaginable, and we have to figure out how to test that stuff. So, y'all have heard me many times before. Resources for labs are absolutely essential. That is DPS, but it's also all the other laboratories, because DPS really only handles about half of the drugs that are tested through the state. Otherwise, it's municipal and county laboratories that do that other half.
Thanks for being here.
Certainly.
Anyone else from Senate Bill 645? If not, public testimony is closed. Senator Huffman, you going to move this bill, or are you going to make it?
What?
You want to move this bill?
Yeah, I want to move it, and if I need to clean it up, I'll do it on the floor, if that's okay. I'd like to move
fine.
it. And I'm going to work with the doctor, and I'll
problem.
work with the governor's
All right,
office.
Senator Huffman
We'll
moves
figure
that
it
Senate Bill 640, committee substitute, wasn't it?
Yes.
Committee substitute for Senate Bill 645 be reported back to the full Senate with a favorable recommendation. Clerk, call the roll.
Whitmer,
Yes.
Flores,
What bill we want? I'm sorry, Mr. Chairman, I was just.
No, no problem. Fentanyl enhancement, punishment, fentanyl bill.
That's 645.
We're in the process of taking a vote. Let's go.
Flores,
Aye.
Hinojosa, Huffman,
Aye.
Betancourt, Miles,
Aye.
King,
Aye.
There being 5 ayes, no nays, committee substitute for 640, Senate Bill 645 is reported back to the full Senate with a favorable recommendation. Moving right along. What else you got? 1319? This must be the Huffman day in here.
Yeah, you just that on my bills
Senate
today.
Bill.
Thank you, Mr. Chairman.
I know. Senate Bill 1319 recognizes its sponsor.
All right, thank you. Mr. Chairman and members, since we're talking about fentanyl, overdose cases in Texas have been on the rise because of fentanyl, and currently the way the Texas Medical Information Act fits into the Health Insurance Portability and Accountability Act, or certain state entities do not have liability coverage under HIPAA, which enables them to share overdose information. So this information can help identify overdose spike areas, deploy overdose responses, and target and secure community resources. Under HIPAA, the public safety umbrella, which covers law enforcement, fire, and emergency medical technicians, are not covered from liability. The public safety umbrella has the pertinent information needed to do overdose mapping, but the only way for a public safety entity to be immune from liability under HIPAA is to have a mandatory state law. So the Department of Justice funds an overdose mapping system through the Bureau of Justice Assistant Governmental Program called ODMAP that is free for law enforcement use across the country. Regardless of the legal uncertainties that currently exist, over 75 Texas public safety entities actually utilize the ODMAP system. So Senate Bill 1319 allows a public health authority, local health authority, or law enforcement agency to provide overdose information to a governmental entity that maintains a computerized system through a participation agreement. So the kind of information that'll be eligible, it does not include personal information of the victim at all. It's the date and time of the overdose, the approximate location, the sex and approximate age of the person treated, the extent of treatment, the type of substance expected to have been used, and whether an opioid antagonist was administered, and the outcome of the patient. And I do have a committee substitute, if I could send it out.
Okay, Chair lays out committee substitute for Senate Bill 1319. Is there objection to adoption? Chair is none. It's before us.
The committee substitute simply moves the requirement to provide information from physicians to the public safety umbrella, who will have access to this information. Doctors want to be kept out of it. As we know, the epidemic is a complex issue. This is another way to kind of look to see where the problems are occurring and where we need to address our resources. And by addressing liability concerns, counties will operate through this free federal system without worry of liability.
Okay, very good. We have Don Knight with City of Dallas who signed up in support. No, in support. Okay. Appreciate, I don't think we had any questions. You had resource and support. Scott Klumpner, resource witness.
Resource witness, Senator.
Okay, thanks for being here. Thanks for being here. Now we have some Adam Balsawin, City of Dallas. Wants to testify. State your name, who you represent.
Thank you, Senator, Mr. Chairman. Adam Bazaldua, City of Dallas, council member for District 7. Thank you, Chairman and Senator Huffman. Thank you to the committee members. Good afternoon, and thank you for this opportunity to speak. I'm here representing District 7 and testifying in support of SB 1319. I want to thank Senator Huffman as a city leader for your leadership on this issue. This is not an anomaly to our city. It's definitely a statewide issue. It's a nationwide issue, and it's one that we need to take serious. SB 1319 would require physicians and healthcare institutions treating substance overdose to share overdose data with law enforcement agencies of the municipality or county in which the physicians practice. By making the disclosure required by law, SB 1319 allows providers to make a limited disclosure of the overdose information and remain in compliance with privacy laws. It also provides a level of consistency with that mandate that wouldn't exist if it was on a voluntary basis. SB 1319 strikes a careful and necessary balance between privacy and public health and safety needs of reporting overdose information. It also allows for law enforcement agencies to map these overdoses for public safety purposes and allows municipalities to work with a private overdose mapping entity. I have seen firsthand in my council district the devastation caused by drug addiction. I've also seen firsthand in my own personal life and experience. My first recollection of death outside of natural causes was my sister's boyfriend who died of an opioid overdose. That was when I was 10 years old, and I fast forward to now having a 10-year-old daughter who doesn't know that sister of mine because she is also addicted. She struggles and goes back and forth from the street and transitional housing, and I often just hope to get a text message to know that she's alive. Resources like this is going to help so that we can provide the right resources to those who need them most. SB 1319 will be a huge step in getting the data into the right hands so that we can direct those resources where they are needed the most. Again, I want to thank you all for your time today and allowing me to testify. I'm pleased to answer any questions that the committee may have.
I think we're all right. Thank you, sir, for being here.
Thank you.
Mr. Blackman, Paula Blackman. Oh, council member. State your name and who you represent.
Good afternoon, Chairman Whitmire and members of the committee. My name is Paula Blackman, and I serve in District 9 for Dallas City Council, which is East Dallas. On behalf of the City of Dallas, I'm here testifying in full support of SB 1319. And I want to thank you, Senator Huffman, as an elected official and as a mother, for taking this on, and to all of your elected leadership, because this is so important to our communities. As you heard, SB 1319 required physicians and healthcare institutions treating substance overdose to share overdose data with law enforcement agencies of the municipality or county in which the physician practices. By making this disclosure required by law, SB 1319 allows providers to make a limited disclosure of the overdose information and remain in compliance with privacy laws. This bill strikes a careful and necessary balance between privacy and the public health and safety needs of reporting overdose information. It also allows law enforcement agencies to map these overdoses for public safety purposes and allows municipalities, such as the City of Dallas, to work with private overdose mapping entity. It will then allow us to make better decisions and planning. Like the rest of the nation, as you know, opioid crisis is in Dallas. Serving in District 9, we are in the top 10 zip codes in our city for Narcan administration, and we're probably one of the most affluent. In 22, one zip code alone in 1728, Narcan was administered 163 times. We have been working with our first responders and health authority, as well as school districts and nonprofit organizations, to bring together every resource we can to support our community, our medics, and our parents. Next week, or actually today, because this was done last week, we are launching an aggressive education and outreach campaign across Dallas. Allowing opioid data sharing between law enforcement, fire, and EMS departments within the same city makes sense, and it's urgently needed. Senators, we recognize how privileged we are to appear before you today on behalf of families in Dallas who are grieving the loss of their children and loved ones. And this has affected me personally as well, including my friends, the Heitzmans, who live in Lakewood. I know many of you have served in public office and here and locally for a long time. And occasionally you receive alerts of items that have happened in your district. Well, one day at a council meeting, an alert showed up, and it was the address of the Heitzmans. And their son was poisoned. And he was a longtime friend of my son. They were schoolmates, and they went to St. Thomas. It took one pill, suffering from an anxiety attack. Found it on Snapchat, and he's not with us today. So we urge you to support this legislation. I can't say that this would have saved his life, but it's going to save some, and it's going to save most, and it's going to hopefully save all. So this is so important for us that you pass this in order for us to help the families that are in Dallas. This is a huge step forward in getting data into the right hands so that we can direct resources where they are needed most. Again, thank you for your time and your leadership on this. It's not an easy subject, but it's one that we need to talk about and be honest about. I have any questions if you have any. Or if you have any questions, I'll be happy to accept them.
I think we're fine, Ms. Blackman.
Thank you, sir.
Thank you.
Thank you.
Peter, do you want to testify again?
Good afternoon again. Dr. Peter Stout, President of Houston Forensic Science Center, and also President of Texas Association of Crime Lab Directors, and testifying for this bill, which is not something I do often on bills. But that point out, I hope, the importance of data collection stuff. So thank you for doing this. I would also encourage out of this, and in the written testimony I've detailed some of it there, there are multiple holes in our data collection around opioid and other drug overdoses. I have multiple circumstances where, because I talk with health officials all over the state, law enforcement agencies all over the state. Back about a year ago, there were a series of xylazine overdoses here in Austin with pills that we knew probably were showing up in Houston. The route by which Houston was starting to become aware of xylazine was people calling me from Austin and then me calling other people. That ain't how this is supposed to work. There are some serious holes between the data that we collect in crime laboratories about what we detect in drugs, what is detected in overdoses in the morgues, and also what is detected in driving under the influence cases. So what we're seeing kind of nationally is there's a significant trend towards the younger the driver is, the less likely they are to be drunk, and the more likely they are to have multiple drugs on board. Now, the trick of this is DUIs give us a window into the ambulatory community. These aren't the people who are in the morgues or in the ERs. They're out still driving around, and you see drug trends among them that you don't necessarily see elsewhere. But if I've got a case that comes in that's got a 0.1 alcohol or above, I don't test for any of the drugs. None of us have the capacity to be able to do that. So we lose that information. We don't also have any way of linking these together. The state of Texas is, shall we say, hesitant in participating in some of these programs. One of them that the CDC has is called the Overdose to Action Grant, OD2A. That one actually has federal money that both health department laboratories and crime laboratories could qualify for if the state participated in it. Harris County participates in it, but the state itself doesn't. So if there are any places that we can encourage the state to participate in things like this, would also be welcome. But this is a marvelous step forward, so anything I can do to help with it, please let me know. Any questions I could answer?
I think we're fine. Thank you, Peter.
Thanks, Doc.
John, you ready to testify?
Yes, sir.
State your name.
Thank you. Good afternoon. My name is John Corzo. I'm the Dallas County District Attorney, and I'm here in reference to SB 1319. First of all, thank you, Chair Whitmire and the committee. Overdose mapping is an invaluable tool which helps law enforcement identify the sources of the most dangerous drugs in our community. As we all know, fentanyl has become a scourge in our communities, and it is beyond time we give our public policy, safety, and public health entities what they need. As we started the process to participate in the overdose mapping program, which is a free program offered by the Department of Justice Bureau of Justice Assistance through our HIDTA entity, High Intensity Drug Trafficking, in Texas and Oklahoma, we quickly realized that we needed legislative assistance to protect our public safety and public health agencies from federal liability. And I appreciate Chair Huffman. Thank you very much for working with us to develop this bill that addresses our needs and moves us forward in this fight against fentanyl. I also appreciate her continued effort to refine the bill language, clarify definitions, and add additional liability protections to our law enforcement agencies throughout this process. As more and more illicit fentanyl crosses our border, I believe SB 1319 will help all our communities to provide data-driven responses such as identify spikes in overdoses, rapidly respond with outreach programs in the community, and most importantly, providing needed information to law enforcement to apprehend illicit drug dealers. So I appreciate your support. Just as a way of explanation, overdose mapping is a project across the United States. We happen to have a dearth of it right around the Dallas County area. The city of Dallas raised these objections. Half of my cases come from the city of Dallas. And so it's necessary for the entire state to be on board so we don't run into this snag in other communities. We are working through HIDA, myself and the HIDA director, who covers all of Texas and Oklahoma. We are working to get this overdose mapping in place so that we can be on top of it. So we really appreciate all of you. Thank you.
Thanks for being here. On another matter,
Yes,
do your magistrates give bond to capital murders?
they do. They might.
Really?
Do they set? Well, so to go back from your earlier discussion, we too have magistrates. You may call them a little differently, but they're magistrates. They're appointed by our judges.
Yeah.
We also have municipal magistrates that you may not have in Harris County, and those are hired by the cities. In no event is the state or the defense present when these magistration hearings occur.
Sure.
And obviously, that's a problem. It's not constitutionally required. It's my opinion, my personal opinion, that we should be there, present, both sides.
But you said they might, but we have hundreds of, you heard the numbers this morning. We have hundreds of people charged with murder or capital murder out on bond.
We do not have.
Y'all have those kind of volumes because we're larger.
We do not have hundreds of people in Dallas County out on bonds on capital murder. I'm sorry, but I was listening to all of this, and it sounds like a foreign land to me.
Mr. Chairman.
In fact,
kinda is.
And
as
the
you
reason
know,
you're important,
my family's in Harris County. You got me kind of scared to go home now.
well, it's legitimate, and you and I have worked together for a long time on
Yes.
criminal justice reforms. John, I've never seen anything like it. I mean, it is totally broken. And what is shocking is the appearance or the apparent lack of concern by some stakeholders. I mean, whether it's resource allocation or speaking out, there's just a missing link there back home.
Well,
And so I was just asking you the question because you're of comparable size in complex criminal justice issues in Dallas. I do read about your backlog and your jail overcrowding, but I don't see the violence, repeat offenders in Dallas that I'm experiencing in
Well,
Houston.
let me say this. I do believe that our judges in Dallas had to make an adjustment at the beginning of the lawsuit and the responses to it. I think at the beginning, there were probably some very low bonds and appropriately set, at least in my opinion. I was a judge for 22 years. I wouldn't have set the bonds, okay? So, in my opinion, people got out. I think that our judges have adjusted to that. And I think that our magistrates, they are hired by the judges, so they're responsible to the judges, though they act independently.
Sure.
And I think there's a certain amount of concern about keeping their jobs, I would imagine, normal.
A good point.
I cannot remember what the criteria are for hiring a magistrate, but obviously live in the county, be licensed for so many
And
years.
know
or whatever.
somebody.
It's not, the judges do it kind of behind closed doors, but it's not a secret as to who the magistrates are because they get a public check. So we know who the budget department is sending the checks to. Sometimes these, unfortunately, magistration occurs in the bottom of the jail and there's nobody down there. So it's not a public hearing in that respect. So making findings of fact and conclusions of law is a really good idea. When you don't have a public courtroom, at least you have something in writing. I'm with you. Got it. But no, we do not have the magnitude of that problem. Thank God.
Okay. Well, thank you.
Mr. Chairman, one question.
Sir Miles.
You've been gone for a long time, John, but we can always welcome you back home when we miss you back home. But, and City District 13 particularly. Point of clarification, you said the state is not involved and that's clarify clarify that statement.
I'm sorry,
State
about what?
is not around or not involved, and that's a
Yes,
good thing.
so I get arrested, I'm taken to jail. Let's say I'm taken to a municipal jail or to the county jail, either one, it doesn't matter. At some point, my paperwork is going to get ready, my probable cause affidavit, I will go in front of the judge, and there will be no defense attorney for me, nor will there be a prosecutor there at that proceeding. And the judge will use whatever information he or she has to make the decision on the bond.
Okay, but I think our issue was the state being involved in the selection of
I don't think that's what he's
The
talking
choice.
right, the
Who
choice.
determines
That's
who
what
the
that's what
magistrates
my hot button.
The judge, well, and the municipalities, the city council or some committee, I know for the city of Dallas, for example, there's a judicial nominating commission.
Yeah.
Each one of these city council members will, have a person on that.
But it's not the state of Texas making those decisions.
We have a panel.
No.
Okay, thank you.
No, we are not, nor will my office ever be involved in the selection of a magistrate. We're not going to do that. In Dallas County, the judges do it.
Thank you for that.
Yeah.
Okay, thanks for being here.
Okay, thank you. Good to see you all.
You bet. Abigail Moore.
I didn't think this bill would stir up as much. Pretty simple.
State your name, please. Who you represent.
Good afternoon. My name's Abigail Moore, and I am the current president for the Association of Addiction Programs for the state of Texas. And I'm here for representing our organization in support of Senate Bill 1319. As we know, it's a free website, mobile-friendly, near real-time system that allows to track those overdose incidents in our state. And we believe that the benefits of it is, again, to identify and track those spikes that happen in communities, to deploy response teams. We are a nonprofit that provides services there in Bexar County, and we currently do ride-alongs with first responders, EMS, and when they are answering to overdose incidents, our recovery coaches ride along, and when a overdose is reversed, we're able to provide resources for the person that had an overdose. So in Bexar County, in 2019, there were 1,800 overdose reversals by EMS responders. We had to put a stop to the work we were doing because of the pandemic. So the priorities changed, and EMS was responding to the crisis of COVID and other things. In 2021, EMS reported to us 3,700 overdose incidents called to EMS. So it went from 1,800 in 2019 to 3,700 in 2021. Those are huge numbers. Now, a lot of those received Narcan and they were reversed, but there were a lot of fatalities also in Bexar County. We also track data in rural counties like Kerr County and Kendall County. Kerr County has the highest per capita prescriptions of opioids in the state of Texas. So looking at all of these things and the data that can be gathered by OD mapping, we want to show our support, and we believe that it'll help organizations like ours that do community work out in the communities be able to target and secure community resources for our communities, be able to respond with Narcan, education campaigns, being able to talk to schools and universities and talk to them about what's going on, especially if there are spikes identified. So we just want to, again, reiterate, we are supportive. Thank you, Senator Huffman, for doing this work and being one of our champions.
Very good. Thank you, ma'am. Robert Abbott.
Hi, Robert Abbott, Fire Chief with Lake Travis Fire Rescue, Travis County ESD 6. I want to thank the Chair, Vice Chair, and Senator Huffman for bringing this forward. I'm actually a user of ODMAP. I've been using this program for going on about 7 months in our organization. And I can tell you that as simple as these things are, and this is about to go dead, but I could bring up this kind of information in real time via this device or any tablet, including a lot of the work that our firefighters and paramedics and law enforcement officers are doing in the community. I know some of you have a great law enforcement background, and you can imagine the days when this kind of fusion point of information would have been very helpful to your line of work. When I was in the field as a paramedic, there were a lot of times that things were developing in very fast pace in the area that we just didn't know because of information data sharing just was not there for a number of reasons, whether technology wasn't there, whether it just was a cost issue, or whether it was a HIPAA issue. This program is HIPAA protected. I use it daily. Our organization uses it daily. We share this information with the City of Austin, Travis County EMS system. And I can tell you just in the last 24 hours, now as I've been waiting to testify, 48 hours, we'll kind of exaggerate that. But Lake Travis community, just west of here, is a very beautiful community. I know you all recreate there at times. But we've had 4 ODs in the last 24 hours in that community. And that's not a community that you would maybe think of having an issue. And I would tell you that this crisis has no boundaries. It's in the cities, it's in the suburbs, and it's definitely in the rural situations. A lot of times it's in the suburbs and the rural areas where data information and data flow is not what it may be in a metropolitan area. So this platform is vital. The fact that we can share this information in real time is very important. We use it. And I encourage a lot of other public safety organizations in Texas to start looking at it. As it was mentioned earlier by some of the other folks, it's a free system. It is a free system. And as we all know in today's complex government, public safety world, free is very hard to come by. But here is a system that is up and running, ready to serve the citizens of the state. It would take somebody about a couple hours to sign up, somebody from a public safety agency, and then within a couple hours of being approved to use the system, they can start reporting their OD cases in real time. That could be manually from the field, or it can be an automated upload from the record management system, one way or the other. But it's a very useful tool. I'm disappointed that I didn't start using the system earlier than I did. Other states have had these kind of laws on the books that protect the public safety and encourage public safety and require each and the reporting of OD mapping. And I'm glad to say now that I'm on the system and it's working quite well. So I'm also a resource if you ever need me in the future for this bill and things like it. Thank you very much.
Thank you. Thank you for being here. Kathy Mitchell. Kathy Mitchell signed up in opposition. Kate Gazani signed up in opposition. Anyone else present would like to testify for or against Senate Committee Substitute for Senate Bill 1319? If not, public testimony is closed. Senator Huffman moves that Committee Substitute for Senate Bill 1319 be reported back to full Senate with a favorable recommendation. Clerk, call the roll.
Whitmer,
Yes.
Flores,
Aye.
Hinojosa,
Aye.
Huffman,
Aye.
Betancourt, Miles,
Aye.
King.
Aye.
6.
6 ayes, no nays. Committee Substitute for Senate Bill 1319 is reported back to full Senate with a favorable recommendation. I assume you want to take that to the floor too, yeah.
Yes,
Yeah.
I'll take it with the other
Yeah,
one.
let's rock and roll. What number?
Last one,
Which one?
287.
Okey doke. Chair lays out Senate Bill 287, recognizes its author, Senator Huffman.
All right, members, unfortunately, we have seen an uptick in threats to schools and daycares across the state. Law enforcement takes these threats very seriously, of course, but they need additional tools to ensure that those who make legitimate threats of violence against our children and educators are held accountable. For example, just last September, an adult male called a school in Austin numerous times. He left threatening voice messages which resulted in the school closing for 2 days while law enforcement investigated. Luckily, the suspect was later arrested. However, he was only charged with a Class B misdemeanor. Although his actions terrified the school community and other indicators suggested that this individual had the intent to follow through on his threats, his actions did not qualify as a felony under the existing terroristic threat statute. Current language of the terroristic threat statute classifies a threat of violence as a misdemeanor unless the threat poses a substantial portion of the broader public in fear or the suspect specifically threatens to use a weapon or brings a weapon to school grounds. The gap in this statute poses a public safety risk to every community. So this bill alters the terroristic threat statute so that legitimate threats of violence that place a person in fear of serious bodily injury who are present at a child care facility, a school, or institute of higher education can be charged as a third-degree felony. Members, we've heard some concern from a few parents that shared concern that certain school districts may attempt to abuse this provision. However, I want to remind everyone that the terroristic threat statute is only triggered if a person threatens to commit violence. That's what triggers it. Then the person who's at the facility has to be in fear of serious bodily injury. To further narrow the provision and make it a little clearer, I did take a different approach in the committee substitute that specifically addresses offense involving violence with the intent to place any person in fear of serious bodily injury. Therefore, and this is, I need to send up the committee sub. I'm sorry, Mr. Chairman. Can I send up the committee sub?
Yeah, is there an objection to adoption? Committee substitute chair is none, so good.
Yeah, so we just narrowed it and did a little different approach, so it's very clear that it's only for threats involving violence with the intent to place a person in fear of serious bodily injury. I don't believe there's any way that school district officials or local law enforcement will be able to utilize this provision in a manner that it is not intended, which would be to somehow punish parents for going to a school board to complain. That's not my intent. This is to stop direct threats by individuals who threaten violence, violence being, I'm going to come shoot up the school, I'm going to come burn down the school, I'm going to come kill everyone in the school. I think we know what threats of violence are, and it places those who are actually at the school in fear of serious bodily injury. We have to stop these threats of violence. They're kind of terrorizing our communities. They're taking over schools. This school was paralyzed, basically, and there was not really very much that law enforcement could meaningfully do about it. So that's what the bill does, and that's the intent.
Very good. Any
Thank you.
questions?
Thank you.
Not Lynn Garcia? Oh, my God.
Good afternoon, Chairman Whitmire, Vice Chair Flores, and members of the committee. My name is Lynn Garcia, and I'm here to speak in favor of this bill. I'd like to share my experience as the mother of 2 children who attend the Austin Waldorf School. On Monday, September 19th, I was in a staff meeting of the Texas Forensic Science Commission, where I've served as general counsel since December of 2010. When I checked my phone after the meeting, I noticed a flood of missed texts and calls. A 37-year-old former student had sent 5 threatening voicemails to the school over the weekend. The messages included things like, "I'm coming for you. I'm coming for you all, and there's not a goddamn thing you can do about it." He also said he was watching the school. The school reported the threats to the Travis County Sheriff's Office. They also sent a mass message asking parents to pick up their children as soon as possible. By the time I realized what was happening, the fear among the parents in my son's 3rd grade class was overwhelming. Parents raced to the campus to pick up as many children as they could. The texts were frantic. "Can someone grab Charlie, please?" asked one mom. "I have Monica's 2 girls," said another. The school shut down for 2 days while the sheriff investigated the threats. As parents, we did our best to explain to the children what was happening without scaring them. Faculty and staff were understandably shaken and unsure about returning to campus. Mercifully, the threats did not materialize that day, and we pray they never will. On September 22nd, the sheriff's office arrested the individual who left the messages. The county attorney charged him with terroristic threat, a Class B misdemeanor. His bond was set at $3,000. I was surprised by this, considering that other Class B misdemeanors include theft of property valued between $100 and $750 and lying about your age to get a body piercing. Eventually, I learned that one reason the threats weren't prosecuted as a felony is because the defendant did not specifically threaten to come to the school with a gun. He told investigators he was drunk when he left the voicemails. For many of us, that raised more questions than it answered. If he's charged with a misdemeanor, how restrictive will the bond conditions be? Do we know if he has access to firearms? Is he capable of something more serious? How will law enforcement know if he's near the school or if he poses a threat in the future? As I sit here today, we do not know the answers to these questions. The school spends over $30,000 each month to have armed guards on campus just in case. SB 287 changes the terroristic threat statute so that legitimate threats that disrupt the activities of a daycare, a school, or institution of higher education can be charged as a third-degree felony. I'm grateful to Senator Huffman and the bill's co-sponsors here for working to ensure that threats of violence made against our children and educators are taken seriously, and that law enforcement has the tools they need to prevent future harm when the threats are identified. Thank you for the opportunity to testify.
Thank you, ma'am. Alex Stringer?
Good afternoon, Senators. My name is Alex Stranger. I'm speaking in support of Senate Bill 287 because, listen, we got to protect our safety and we need to protect our kids. And, we got to be honest here, okay? In order to do that, we got to realize that the greatest threat to our safety is our fellow Americans. And this is especially true about these MAGA hat-wearing terrorists who infest our state with their hateful rhetoric, all right? Listen, I'm triple vaccinated and boosted, and I've gotten COVID 4 times, okay? You want to know why? Because these people, they refuse to wear a mask and they refuse to get vaccinated. And you have to understand, these people, they could have killed me, and they wouldn't even care. You want to know why? Because they are murderers and they are terrorists, all right? And then let's talk about my wife. She's immunocompromised with stage 5 testicular cancer. She hasn't left the house in 3 years because of these MAGA QAnons, all right? And these people, they're murderers. They deserve to spend the rest of their lives in prison, and this is how we need to treat these people. And I understand that, I'm really glad that we have good Republicans, like Senator Huffman and Dade Phelan, and you guys fully agree with me on this. Look, I took my 5-year-old son, Carla, to a drag show last weekend in Dallas, and we are regulars at our school's Drag Queen Story Hour. And the drag queens and minor attracted persons performing for our kids, they are amazing people and they are role models. My son, Carl, even started transitioning when Sprinkles, the drag queen, sat on his lap and gave him her thong after the performance, stains and all. And when these Republicans want to take the joy away from my 5-year-old, it's only because they want to exterminate the LGBTQ community because their hearts are filled with hatred. I'm going to close with this, okay? I'm your banker, I'm your college professor, I'm your city council member, I'm your kids' elementary school teacher, and I moderate your content on Facebook. And I'm doing this to protect you from the MAGA terrorists who invaded the state just like they invaded the Capitol on January 6th. All of the 81 million people that voted for Joe Biden, they fully agree with me on this. And, when you speak at a school board meeting and you say, hey, I don't want my kid to wear a mask. I don't want my kid to get vaccinated. Why is there a urinal in the girls' room? Why is my 5-year-old taking puberty blockers without my permission? Well, your rhetoric is contributing to a culture of violence, and you are murdering people, okay? And this is why we need to classify these people as the terrorists that they are and throw them in Guantanamo Bay where they belong. So please pass Senate Bill 287. Thank you.
Thank you for being here. Anyone else would like to testify for or against committee substitute? Why don't you come down front? Okay. State your name and who you represent.
Thank you, Mr. Chairman. My name is Kyle Sims. I represent myself and thousands of parents that speak at school board meetings. I live in McKinney, Texas. My wife and I have 6 grandbabies. I speak at meetings all over North Texas. This last speaker is the reason I'm here. 25 copies of this book is in McKinney ISD. It's called Sold. This is about child trafficking. Very graphic wording in this book. A child cannot consent when they are 6, 7, 8, 9 years old. So why do we have these books in schools? This is why we speak at board meetings. I'm not here to condemn anybody. I think that bill is a good bill with some changes in the language. I'm the one that called Representative Frederick Frazier, that called your office. And the reason I reached out to him is because when I read this book in a meeting last week at a board meeting, I was called a terrorist. I was called a bigot. I was called a white nationalist. I'm not any of those things. I want to protect children from innocence. Sex trafficking in this country is out of control. We have to think about the children and quit thinking about hurting somebody's feelings. I don't get my feelings hurt when somebody calls me a terrorist because I know in God's eyes what I'm doing is what the children need. We don't need this stuff in our schools. This is what's causing all the harm. So I would ask you to be very cautious with the wording in that bill because some people are going to feel threatened by that language in that bill. Who says, I don't know if y'all know about what we're dealing with in North Texas, but you take McKinney, Texas, Prosper, Texas, Salina, Texas, Plano, Texas, Allen, Texas, Salina, Texas. In North Texas, we are dealing with school boards that are so tyrannical to where they have 18 to 25 policemen show up at every board meeting for less than 50 people. It's an overpowerment that these people are terrified to even speak up for their children. That's why we're here. And I hope that you all will consider, when you finish this bill, to consider the language in it that this is for all parents and all children, not just for one group. Thank you.
If I could,
Yes, ma'am.
and I don't know how to state this broadly enough and emphatically enough. This has nothing to do with parents being able to talk to school boards and expressing your discontent. And I don't know about the book you're holding up, but not liking the book or not liking drag shows. You have an absolute right to speak up and do that. This bill only would addresses where there is violence threatened, all right? Violence threatened, and then there's with the fear of serious bodily injury, protesting against a book or the content of curriculum or messages that teachers are giving students or equity issues. None of that has anything to do with this bill. I'm happy when I'm on the floor to stress that through my legislative intent. What school board members may, want to do or not do, that's just not what the law says they can do. So I've tried to address the issues by making it very clear that it's a threat of violence, that it's, that it's made directly, that the person is placed in fear of serious bodily injury.
Well, just so this committee is aware, there have been people removed from meetings for simply reading a passage in a book.
Well, that shouldn't happen, but this bill
It shouldn't happen, but we have no legal standpoint to fight back.
But this
That's
bill
the
doesn't
problem.
have anything to do with that occurrence. It
Okay.
really doesn't.
Okay,
If
thank
I
you.
thought for a second it did, I wouldn't do the bill. I'm very supportive of parents and their rights to protest to schools about what's going on in schools. I mean, it's your kids, it's your school. You have a right to protest. I get it. I mean, I'm in support of that.
Thank
I don't
you.
like what the schools do a lot, don't do, or do sometimes as well.
Yes, ma'am.
Okay.
Thank you so much.
Cecilia Wood is in opposition. Jennifer Fleck. Spicewood, where is Spicewood?
I think that's near Dallas, I think.
Thank you.
Where's-
I'm outside Austin, 40 minutes southwest, toward Marble Falls.
Southwest? I thought Marble Falls is like north.
in my district.
Yes, help him.
It's in Texas.
I thought Southwest would be Dripping Springs, wouldn't it?
Well, it's a little more west, but still south.
Okay, go ahead.
It's
State-
nearby, Senator Wood.
It's close enough to get
Somebody
here.
said Dallas, so that threw
I
me
was
off.
wrong. I
Yeah,
was wrong.
yeah.
I don't know what.
Okay,
State your name and who you represent.
Jennifer Fleck, I represent myself. This bill expands the immense powers the school district uses against parents already. The bill might not be so offensive or vulnerable for abuse and unintended consequences if, 1, the school districts didn't already have their own police departments answerable only to themselves. 2, if we had education code with enforcement provisions that allowed parents to seek redress of wrongs. 3, if the TEA administrative law judges had broader jurisdiction and everything didn't get dismissed for lack of jurisdiction. And 4, if the school districts didn't enjoy sovereign immunity. There are stories coming out almost daily of parents across the country being ignored and discriminated against for, as the law says, trying to influence the conduct or activities of public schools. Public education continues to indoctrinate our children with sexually explicit materials, promoting the false narrative that boys can be girls and girls can be boys, anti-American sentiment, and racism. Parents are mad, and we want it to stop, and yet school boards want us to be silent because they know best. I understand that the law also requires an element of violence, but who defines violence? I have been accused of violence in a public building for tapping on glass. That led to a criminal trespass charge and my confinement in jail. I personally know of 2 parents in Round Rock ISD, one of which was here earlier, who were arrested at a board meeting under this law, and 2 parents in Eanes ISD. One was arrested for holding a sign, and one was charged with violence and criminal trespass.
Wait, you said we're arrested under this law. This law hadn't passed yet. So.
Under this current law, there is a provision that allows them, I can't remember what line item it is, but it applies to an agency or political subdivision of the state. So technically, this law already applies to K through 12 public education. But to specifically line item it now, in my opinion, emboldens the school districts to even more forcefully apply it to parents. And I know that's not the intended consequence, but let me finish because then I don't want to mess up my... In summary, the language of the bill would embolden public schools to further exercise their power over parents. The public schools have proven themselves untrustworthy, and that's why I'm opposed to the bill. I understand, Senator Huffman. I know what you're trying to do. What I'm telling you is the school districts have proven themselves untrustworthy. They use every gap, every loophole, and there's no proper oversight of how they treat parents.
And I shouldn't even engage the subject because I think we're getting off of the purpose of this bill. But when you sit here and say public school districts, that's pretty broad.
Yes.
You think like all of them?
Yes. Yes.
All
Every single
1,050 of them?
Every single school district is exposing our children to sexually explicit pornographic books.
All of them?
All. And we can prove it, all. Okay. And gender affirming ideology. I hate to call it that. Basically, they're trying to convince our boys that they're girls and girls that they're boys. It's in every single library in this district, in the state. Every.
Okay.
And there's nothing that parents can do about it. And my point on this bill is it's like you're giving them something else. You're giving them another tool that they can use against us. And we should be spending time on bills that are strengthening parents and families and protecting children.
Okie dokie. Thank you, ma'am.
Thank you.
Appreciate you being here. Now I know where Spicewood is. City Castillo signed up, but not here. Natalie eBay. I got it. I know. It's too interesting. State your name and who
My
you
name is
represent.
Natalie eBay. I'm a registered nurse, a career nurse. I live in Leander, Texas. And I want to thank you for allowing me to express my concerns regarding Senate Bill 287. If I may use the term plugging in, these institutions, these universities and private and public schools have been added in, plugged into the current law.
What are you saying? Plug
They've
it.
been added in. There's a law and they've been added in.
Oh, okay, adding in. Okay.
Yeah.
I thought it was a word I had never heard of before.
Yeah.
You're just talking about adding in.
And the rhetoric in the law is subjective.
Yeah.
Such as cause a reaction of any type, that's pretty subjective. intent to, that's pretty subjective. Fear is totally subjective. And I don't believe with that subjectivity that it's going to be used appropriately. The subjectivity clearly opens the doors for parents to be wrongly convicted. And haven't we already heard how our courts are backed up with obvious and deadly criminals on our streets? The verbal assault is a crime in Texas. According to Texas Penal Code, Title V, Section 2201. This rhetoric for the penal code related to verbal assaults is specific. It is directed. It is not subjective. It is objective. So if you have a verbal assault law on the books, why do you need one for a school board meeting? Isn't verbal assault the same at a school board meeting as it is in a movie theater? If the school board members are that concerned, they can file a verbal assault charge. The law is there. We don't need another law to address this. Why aren't the school board members doing that? Maybe because it's not really verbal assault. Maybe because they're not really threatened. They have the means. Why is this law necessary? I'd like to finish.
Well, I want to ask you a question. You can still finish. I just want to ask you, am I ask a question?
Sure.
Where are your school board meetings held?
I don't have children.
Well, okay, well, the ones you're worried
I
about.
was present at the Texas Education 911, and I've heard the horror stories.
Okay.
And I am concerned as a citizen, as a person who's had stepchildren. And then the other thing about this bill, it makes this a third-degree felony. This threatens the parents' livelihoods for the rest of their life. You make somebody a felon, you have made it impossible for them to get jobs. This is such a serious offense. Verbal assaults are, depending on the severity of the assault, are Class C misdemeanors, Class B misdemeanors. That's a fine, that's a probation. But making a parent a felon is serious threat to them. Of course they would be concerned about talking up at school board meetings. And I don't see any examples of a parent standing in a school board meeting with a knife or a gun. I haven't seen that newspaper article. I don't know where that's happened in Texas or the United States. Where's the examples of that? In France, there was a teacher that chased a man, a parent, an angry parent. He chased a father down the street, decapitated him in the street. That happened in France.
Oh, my goodness.
Yeah.
I want to go there.
We had a school board meeting where a man was upset that his daughter had been raped, and he was arrested, and he's going to be filed with a third-degree felony? Again, there haven't been parents threatening to shoot or stab school board members. And if the school board members felt like they were being threatened with stabbing or shooting, why aren't they filing verbal assaults? In fact, there were 12 people on the terrorist watch list that crossed our border in 1 month, in the month of November. 12 on the terrorist watch list. So, in my opinion, if you're so concerned as the Senate about terrorists, then please file a legislation to declare an emergency on our southern border, because there's at least 144 on the terrorist watch list coming across our border every year. That's probably a very conservative estimate. In my view, this bill is all smoke and mirrors until the real terrorist threat on our border has been addressed by the Senate.
Okay.
Thank you.
Mr. Chairman, I don't know if there's I have a resource here, Shannon Edmonds. I'm not sure you can answer this question, or maybe, has anyone in here been on a school board? Bill, have you?
No.
Where do school board meetings usually happen? Isn't it at the ISD buildings?
Yes.
They usually have a room like this.
Yeah, but not at the school, right?
Sometimes they have them in auditoriums or.
Yeah, they're
It
usually,
varies from time to, okay.
All stadiums.
yeah, they're on the campus.
Yeah, they're on school
Well,
property.
HISD doesn't. I know they have them at the.
Administration
At the
building.
admin building, but I didn't know if all cities. Anyway, because this would not apply unless it was on the premises of a public school. So the intent is not,
It's on public property, it's on school property.
I'm not, I'm just making a point. I said to the, that's why I asked the questions, okay? But the purpose, the whole point is, the intent is not anything to do with school school board
Board
meetings.
meetings.
It's about people who are at a school, a daycare, really goes to daycare, or college campuses, or elementary school, and the people at the school, working at the school, are threatened by someone, threatened violence. But anyway.
Okay, very good. Thank you, Ms. Ebake.
Do you have a question? Can he ask?
Yeah, sure, Senator
Just
King.
maybe a clarification, because I've had people reach out too that were concerned that this might be misapplied in a school
Sure,
setting.
we're trying to avoid that.
Yeah, I just wanted to read through a couple sentences just to ask you if I understand it right. So,
And you're looking at the committee sub, right? Because
yes.
Yes, okay.
Well, actually, I'm not. I don't think.
Okay.
Is this right?
Okay,
Yeah, it is.
because we did
Okay.
change it once to
Right.
try to address the
So
issue.
line
Yeah.
6 says a person commits an offense if the person threatens to commit an offense involving violence to any person or property with intent, so there's got to be that mens rea there, right?
Right.
The intent to, and then flip over to page 2, line 1, place in fear of serious bodily injury any person who is present at a child care facility, public school, or institution of higher education. So, with tremendous sensitivity to what the earlier testimony was, particularly of the lady who was arrested, I'm not sure how this would apply to the kind of situation. I think what they're concerned about, legitimately, is that they would come in and speak at a school board meeting and in opposition to something that is occurring in the school,
Yes.
and that they would be arrested for that testimony. But for them to commit an offense under this, they would have to have the intent. They would have to, their purpose for being there would not be to testify that you've got these books in the library or you're taking positions on gender and things
True.
like that.
Yes.
Their purpose for being there would specifically have to be to place the school board members or staff in fear of serious bodily injury.
By threatening violence.
By
'cause then there's a
threatening violence.
You'd have to
And-
have the violent
And so I
aspect.
think there may just be some confusion.
Right, I'm
that
trying
for
to
them-
clarify.
For them to be convicted under this or arrested for this, and you can be illegitimately arrested. Somebody could arrest me for drunken driving when I don't drink.
Of course, yes.
But for someone to commit this crime, they would have to go to that school board meeting, and they would have to go there for the purpose of threatening the school board members and placing them under, with the intent and purpose of placing them in fear of imminent bodily injury. Is that correct?
Yes.
And what,
If the school board meeting was even on school premises.
and
because
what the gentleman testified to, which I'm very sensitive to, and the earlier witness, they did not go there with that intent to do that, and she did not go there with
Right.
the intent to do
Right.
that.
Yeah.
Whether she was arrested for some offense that was inappropriate, I don't know. But as I'm reading this doesn't affect at all what they're
Right.
worried about.
I think the concern is
If
unintended
it did, I'd be opposed to the bill.
consequences, right? It's not, I don't think anyone here is questioning that I'm really trying to protect kids, but y'all are worried about unintended consequences. I hate to take over your meeting here. This is an important bill. I want to fix it, okay? Because I think this is an important piece of legislation to the mother who came to testify. This is a real problem. It's a real issue. So,
Let's go on to the rest of the witnesses.
yes, thank you, Senator.
Charlene Reagan is in opposition. Beth Abel. Jeremy Story. State your name and who you represent.
Sure, I was just waiting for Senator Betancourt.
You may be waiting.
Senator
a long
Huffman,
time.
rather, sorry.
Yeah.
My name is Jeremy Story, and I'm against the bill. And I'm also the chaplain of the Republican Party of Texas as well. So
You're the chaplain of the
Yes, sir.
Republican Party.
That's correct, yeah. Although I believe this is a bipartisan concern what I'm speaking about today, and I'll demonstrate that in my talk today. I'm also a subject matter sort of expert and probably the leading legal case on this in the state, which I'll discuss in just a minute. So just so you know, I was born in inner city Houston. So Senator Miles moved to the suburbs. So Senator Huffman and Senator Whitmire And my wife her family owns a big business in Corpus with Senator Hinojosa, and I presently live in Round Rock near Senator Flores. So I'm very familiar with all of your districts and have a lot of connections there. And I want to say that this is a bipartisan concern across the state, what people are expressing. I want to explain a little bit further why it will be abused. It's a bipartisan concern because, number one, on the Democrat side, I think many of you understand that you don't want to see government power for criminal activities expanded because oftentimes it's abused, and then people are abused through the criminal system. On the Republican side, I believe people understand sometimes that some of the school boards have gotten astray. So I think hopefully in between that this would be a bill that could not just be amended but removed. The intent is extremely good, Senator Huffman. It's extremely good. I know your intent is good, but it will be abused. And I want to explain after I tell you my story. They will twist the definition of violence. They will twist the definition of threat, and it will be abused. And what will happen oftentimes is these people will be arrested, and I'll tell you why I know that. They will be arrested under false pretenses, often false affidavits, parents and others, not just at schools, but city council meetings and other things, by people who, when they're speaking against something that an official doesn't want them to speak against, they can be arrested. And yes, it will be worked out in the courts, but meanwhile, that person sits in jail. How do I know that, Senator Huffman? Because I was that person. I'm a pastor. I've been a pastor for 30 years. I worked across the country with college campuses, have never had any run-ins with the police, to my knowledge. I can remember beyond like a speeding ticket. I united together people across race and denomination across this country. I served on the National Day of Prayer board. I serve on the board of King's College. I serve on boards, the Parents Board of King's College, serve on a lot of different boards across our country, and really have no malintent towards anyone per se in that regard. I showed up at a school board in Round Rock ISD because a principal had told me that and I'd seen evidence from her text messages and other things that we had verified, that the superintendent of Round Rock ISD had an affair with her and got her pregnant and then threatened her when she wouldn't have an abortion. And so I showed up at the school because first I tried to contact privately, calmly, without any threat, to the school board members via email. They basically 86'd all those emails and said they weren't going to do anything about it. When I showed up at the school board meeting to speak about it, they actually literally pulled me off the public speaking stand backwards using the police, telling me that I was speaking about something that wasn't, quote, on subject, even though the subject was security that night. Yeah. And the superintendent had had a protective order filed against him secretly, or actually publicly, at the school district headquarters. My point in saying this is that 5 of the school board members out of the 7, yes, was this appropriate? No. But they used a law that they twisted to say that I was disrupting the meeting somehow, right? Now, then, after they pulled me out of the room, I peacefully left. 30 days later, when I would not be quiet about their malfeasance, they leveraged our local sheriff to show up at my house and in front of my 7 children, arrested me in my front yard, claiming that I had disrupted a public meeting and that I had done these things, and took me to jail at 5 o'clock on a Friday. Y'all know what happens when you get taken to jail at 5 o'clock on a Friday. I didn't know that. Now I do. They hold you overnight. They claim that they can't find a judge for you, and they penalize you to keep you quiet, which is exactly what they were doing. They were using the criminal justice system to keep me quiet from exposing what was their malfeasance, because this woman had gone to them and asked them for help. And instead of helping her, they actually told the superintendent, and then he showed up at her house and aggressed against her. So they were complicit, and rather than them going to jail, they tried to put me in jail. So here's the point. Does the current law allow them to do what happened to me? No, technically not. That's what I'm saying. I know your intent is very good. But did they twist it because it was close enough for them to do it? Absolutely. And as a result, I spent the night in jail, and the next day, and our community had to have a prayer rally around the jail around the clock until they finally released me, because it was their intent to hold me there all weekend to keep me quiet. And I think they were using words like that I disrupted when I hadn't. So in your bill, you have words like violence and threat. And the problem is that the definition of violence and threat is in the eye of the beholder. And in my case, or in other cases, local officials who are malfeasant, we're not talking about people who aren't, will use these types of words. In our district, for example, after this happened to me, they began to implement a clear bag policy where they told everyone, well, we've been threatened. And so therefore, we're going to make everybody have clear bags. Well, they had never been threatened, but they were creating an atmosphere that made people think that they were so that they could do whatever they wanted, including put citizens in jail who had no history of being having any problems whatsoever. Later on, in the middle of all this, they literally blocked the doors with school district police officers. So you couldn't get in the school board room, and they took out all of about 200 chairs and left 18 chairs in the room and said, if you didn't play the musical chairs game, to sit in one of those 18 in a huge room like this one, which is actually bigger than this one, that you could not be in the room.
Yeah.
And so they used police in that way.
Let's get back to the bill.
So my point is that this is a perfect example of what can happen to parents. I have a federal suit in progress right now on this. The letter, for example, that was sent to our federal government by the National Association of School Board, if you look at it, the cases that were reported of violence or all that, the 15 cases that they cite, not one of them were this kind of violence that's supposedly out there. So I think sometimes what this bill is intended, I know, to prevent horrible things like Uvalde from happening, right? That's what it's for.
Or to prevent disruption of schools and the terror that's inflicted upon children when they're.
But what it will be used most of the time for, Senator Huffman, is
I'm not going to argue about
silence people.
I want to fix it because I want to address this mother's problem. Okay, I'm going to address this mother's problem.
How about my problem of being put in jail?
Well, I'm worried about your problem too, but
or other parents, Travis County,
I can't
Dallas.
Fix your problem.
It's not me. It's parents across our state.
I'm not going to argue with you. Okay.
You are, so I'm arguing back.
Well,
No. Let's slow down. First of all, you've made your point.
Yeah.
And you have had adequate time. Sorry about what happened to you at Round Rock. Sound like maybe they were out of control, but that's not what this.
But this is happening to parents across the state.
And I'm sorry
And this bill
about
will
that.
only make it worse.
Well, you need to talk to your representative or senator. Senator.
You mean like Senator Flores?
And that's great. He's a great one. So we've
This
had
bill will only make this story worse. You're going to hear more of these.
You've made your point. Thank you. On a more interesting point to me is, how do you become a chaplain for the Republican Party of Texas?
Sure, I think both parties, have a position for chaplain. It's not just the Republican Party.
You're appointed
And it
by
just
the-
means because everyone, whether we're Democrat or Republican or
appointed by the
independent,
chair?
we all have spiritual needs. And so our goal is to meet the spiritual
Not
needs.
your job description. How are you made the chaplain?
I don't know how it works in the Democrat Party and the Republican Party. Our state chair appoints officers. I assume it works the same in the Democrat Party. And so
I'm
I
not
was
sure we
appointed.
have one. We're so diverse that, we'd have to have about 6 or 8. So anyway.
Yeah.
Thank you for being here.
No problem. Yeah.
if I could just clarify, Senator Whitmire, so I think understanding what the group is saying is they don't object to the intent of the bill. What they object to is if it applies to school board meetings.
Not just school board meetings, but also it can be city councils or other things. I believe that
I'm
malfeasant
not-
officials will use this to basically threaten people that disagree with them.
I haven't changed any of the law relating to since city council meetings. This bill, what I'm doing, does nothing to that, okay?
Okay.
Just addresses daycare facilities, middle schools, elementary schools, and higher ed, okay?
I think schools then would be people's primary concern.
So would it be, I'm trying to figure out what your group is complaining about. I think it's
First off, it's not my group. These are people that represent
Okay,
the whole state
well-
of Texas.
the group that is opposing it, okay? And it is school board meetings.
Yes, ma'am, and I appreciate your question because you were asking, are most of these people, are these meetings held in public schools or not? And the honest to goodness truth is most of them are held on
Yeah,
public school
that's why I asked the
facilities.
question, yeah.
Yeah, it's not like HISD where they may have a separate building for it.
Maybe there's a way to do the enhancement of this, and that was the whole point of this, to make it a felony so that when they were threatening school, a direct threat and so forth, that there's something that law enforcement could do about it. So there may be a way to word this to exclude those type, school board meetings, because there's already laws that have nothing to do with this law that are in existence now. They could be, if you threaten, they can charge you now for something.
Yes.
That has nothing to do with this law. So let those stand where they may and just have this effect.
I just worry about expanding their ability to do that.
This would not expand their ability if I took out, I think,
Public schools.
well, I'm not going to take out public schools,
Okay.
but I will take out school board meetings. If that gives your group, or not your group, but
The group would be parents across the state of Texas who have kids in
Exactly, who
education,
have-
which is about
who have
80% of our public,
concern.
or our kids.
I mean, I don't see it, but I'm trying to respect the wishes, and this is important legislation that needs to be
Yes,
passed.
ma'am.
So maybe there's a way to-
Thank you.
And Senator Whitmire, to address your issue with the Democratic Party, I'd be glad to serve the Democratic Party and their spiritual needs if you'd like me to. So just let me know.
Okay, thank you.
Chairman,
Party.
can I just ask him one quick question before he goes? I'm
Sure,
sorry.
sure, Senator King.
So, what were you charged with?
I was served, it's something like, it's a Class A misdemeanor, I found out. And it's something like disruption of a public meeting, something along those lines. And it's very much similar wording to what's in this terrorist section currently. And so I understand the bill, that it will already exist, but
We're
this
trying
expands
to
it.
get discussion, just question your charge.
Yes, sir.
Disruption.
Mhm.
Were the charges ultimately dropped, or are you still under charges, waiting for go to trial? Or?
Yes, sir. Because my case has been so unique, every single one of our local authorities.
I'm just sorry.
It's hard to answer your question. I'll just really fast. The
I'm not trying to
FBI,
press you.
the county attorney, all these local authorities abdicated investigating. So the AG is now investigating the school district. Because the AG can step in when all local authorities step out.
I'm just trying to make sure I understand what happened to you.
Yes, sir.
So you were charged with disruption of a public meeting.
Yes, sir.
And are you still under prosecution? Are you waiting to go to trial, or have the charges been dismissed?
They are not dismissing the charges, I think, because they're afraid I'm going to sue them too. And so what they're doing is, I think, just waiting them out.
Okay, thank you. Thank you,
You're
Mr. Chairman.
Thank you. Fran Rhodes? Thank you, Senator Huffman. Thank you. I'm glad I didn't schedule it first.
Yeah, my name is Fran Rhodes, and I'm representing myself. I am president of True Texas Project, but I'm here mostly on my own. And I don't have much to add that hasn't already been said. I certainly understand the intent of the bill, and my heart goes out to this young woman over here who had that horrible experience. And it just astonishes me that that was originally a Class B misdemeanor to make that kind of threat. So I very much support real threats like that being, elevated to a higher level. But I think all of you underestimate the tyranny that is infecting school board meetings that we have all witnessed, and many of us, like Mr. Story, has experienced personally. So I think what we're looking for here is, and maybe it's a different bill altogether or a different law, but some sort of protection for citizens who speak out and not have the elected officials use language that's in this bill or some other bill to use it against us. I'm sorry, my words are not coming.
The key to it is you said elected officials. So we're sitting here concerned about folks that have to get elected. So somebody's placed them in those positions of
Yes.
responsibility. Isn't that the accountability we're looking for their actions?
Not necessarily, because once someone's elected, it's at least 2 years or more, depending on the office, before you can unelect them again. And
Okay, well, good job for being here.
thank you.
Appreciate you. I'm sure Senator Huffman's going to continue to review it. Let's see, Melissa Beckett? Okay. Sounds good. Thank you for being here. Anyone else? Come on down. I started to ask you to stand in for Miss Beckett, but,
I was going to offer, but shut.
well, first of all, state your name, who you represent.
My name is Paula Hilliard. I represent myself.
What is 9/11 organization?
Oh, this is Texas Education 911. It's just alerting the legislators to the reality that we have issues at our public schools that we want to bring solutions to. We don't want to come with
So the
complaints.
911 is symbolic. Do you want
It's emergency.
to, okay.
But anyway, but I'm speaking on my behalf. I just didn't take off my little pen.
No, that's okay.
But I want to say again, we do see the intent being good, and thank you for trying to solve a problem that someone brought to your attention. But the reality is, and please don't. This is maybe. I just have a sense of humor. This may be out of line, but you used a word during the introduction that a school board would throw us out for. You said the word trigger. And you can't say, we were emailing and I said, I can't say the word attack. I can't use this common colloquialism we all use. We were like, be kind when you're writing your legislator, don't attack them. Oh, I can't say the word attack because we're so scared of our school boards. We're used to, anytime we talk to these elected officials that are the closest to our homes, we have to guard every word we say because
Yeah.
I haven't seen the substitution, but the original said that any one person takes offense to and thinks is a threat. And so I don't know what their bar is. People are very sensitive in different ways, and if they're mad at you, they're going to act like they're sensitive when they're not, and they're going to act like they're scared and threatened in order to manipulate and control the situation. And so there's just a real fear. I did want to share with you that some school districts in Texas are just one school or one, so they might only, they're going to have just at campus is where their meetings are going to be. And a lot of them are so big, they have to have them in a gym or, stadium type place, whatever that's called, auditorium. And anyway, so, it's kind of hard because there are so many school districts and there is not a one size fits all. I do get what you're saying. But at the same time, the police are on our campuses as well. So if we say something to the administrator who can, direct the policeman or woman to arrest us, they now are supposed to give us a warning. But districts, you know what they're doing? They're going into the education code and saying, well, we don't want to follow this, where we don't even have to give parents a warning anymore. You're just kicked off of campus for 2 years. So they're allowed to do this under the law. And the problem that we're having is not that the law itself is bad, it's just that they will interpret it bad. And there's nothing in place for us. And so I almost feel like if we fixed the enforcement thing first, so we had an inspector general, we had an ombudsman, we had some sort of enforcement, maybe one of these people who spoke said something about expanding the ability for the TEA or the administrative judges to actually do something, because they all say, we can't do anything, we can't do anything. The board gets to be its own judge, jury, and exonerator. They just say, we didn't do anything wrong. Well, that's how we interpret it. It sounded violent to us. And then the parent who's just trying to love and advocate for the school and to be better is paying how many, I don't know, legal bills out the wazoo. And if that's not a bad word, I'm sorry if it is. Out the ear.
Did you come from Longview for this bill?
I did not. No, but Ms. Beckett is from Longview.
Oh, okay. Where are you from?
I'm from San Antonio.
You have kids in public school?
I sure do.
And you've been going to school board meetings?
My husband's on the school board. And yes, I do. I go to meetings until...
Your husband's on the school board?
Yes, except for...
Talk to him about behaving?
He's a good boy, but one of his colleagues told me to stop coming because you have your own board member and you're married to him. You don't need to come and talk to us. So that is what's happening. If they'll do that to you wouldn't do that to each other's spouses. You wouldn't speak to them that way. But if they'll do that, they'll do that to anybody. So it's a real concern. It's just those little words, hey, you're the bomb. I can't say that, and it's just going to happen. And I don't know the solution. I've been racking my brain because I'm like, I know we can do this and to get you what you need, but to protect us. And I'm almost thinking we fix the education system first and then slip this in.
You're in the wrong committee for that. So.
I know. Y'all have friends. Y'all have friends all over this place. No,
okay.
But so.
Thank you.
Thank you.
It's been a long day. Thank you for being here.
Oh, yes.
Anybody else? Man, I hate for this to come to an end. Public testimony is closed on this committee substitute for Senate Bill 287.
I just want to leave it pending. We've had a good discussion. I think I've shown what my intent is. I've got a commitment to work with everyone here. I think we can reach a solution, and let's pledge to do that. I do appreciate y'all being here. We don't always understand what we're thinking, but that's what the process is about. So thank you for being patient, and other members, thank you for being patient.
Let me clarify the record that we adopted the committee substitute for 6:45.
Yes.
And that all the witnesses who signed but did not testify will be entered into the record. So just making certain everybody knows their position is well documented. With that, members, thank you for a good, hard day, and we stand in recess.